spirito, ma non posso celare la mia sincera preoccupazione, se non angoscia, davanti all'evoluzione dello scenario internazionale, alla ripresa della corsa agli armamenti e ai drammatici rischi di questa escalation, quando non solo in Italia, gran parte della popolazione mondiale vive in difficili situazioni economiche che imporrebbero investimenti nella sanità, nella scuola e in generale nel welfare. Il divario tra miliardi di poveri e qualche migliaio di ricchi non è sostenibile. Non guardiamo solo all'Ucraina, allo Yemen, come alla strizia di Gaza. Il nostro è un mondo senza pace, un mondo che ha bisogno di pace, cioè di quella ordinata concordia di cui parlava Agostino. Ma l'ordine concordia non si raggiunge con le armi, né perpetuando ingiustizie e soprusi. Non una pace qualunque, dunque, né correre il rischio di quello scenario evocato già da Tacito, dove fanno il deserto lo chiamano pace. Ubi solitudine faciunt, pacem appellant. Non è di questo che abbiamo bisogno, ma di un ordine basato sul diritto e la giustizia. La Commissione di Venezia del Consiglio d'Europa ha tutte le carte in regola per giocare un ruolo straordinario nel costruire un cammino di pace. Con la guerra tutto è perduto. Dal 90 a oggi la vostra Commissione ha svolto un ruolo straordinario in virtù della vostra autorevolezza che vi ha portato ad essere punto di riferimento dei paesi del Mediterraneo, dell'America Latina e dell'Asia centrale, dopo aver svolto una funzione straordinaria nella stesura ed elaborazione delle costituzioni di molti paesi europei, ad iniziare da quelli dell'Europa dell'Est. Oggi la Commissione conta 61 Stati membri, i 46 Stati membri del Consiglio d'Europa e altri 15 membri non europei, mentre Argentina, Giappone e Santasegue sono osservatori. È attiva la cooperazione col Sudafrica, la Palestina, le istituzioni sovranazionali, l'OCSE e l'Organizzazione degli Stati Americani. Potete parlare con autorevolezza della vostra storia, con la voce del diritto e della cultura, esprimendo il sentimento più profondo della maggioranza delle nazioni del mondo, che non chiedono una pace qualunque, ma giustizia ed equità. La vostra voce, la voce della diplomazia e del dialogo, non può essere sopraffatta dal pandemonio fragroso delle armi. Quos Deus avertat. Io saluto con speranza i vostri 35 anni di vita, dalla giovinezza state entrando nella maturità, con la forza di chi in gioventù ha dato prove eccezionali di credibilità, concretezza, cultura, intelligenza, messa al servizio di nazioni che affacciano fiduciose la democrazia e la libertà. Buon compleanno allora e lunga e proficua vita. Questo era lo speech del Presidente del Consiglio regionale del Veneto e vi ringrazio. Passo la parola alla dottoressa.
Good morning, President and members of the Venice Commission, members of the International Association of Constitutional Law, professors, dear colleagues. It is a great pleasure to open this conference organized by the Venice Commission and the International Association of Constitutional Law jointly. I would like to thank the Venice Commission deeply for its engagement in the co-organization of this conference. Furthermore, I would like to congratulate the Venice Commission on its 31st anniversary. 35th anniversary. Oh, sorry, I cheated you there 4 years. Sorry about that. Of course, your 35th anniversary. The Venice Commission is one of Europe's most important institutions in setting standards for democracy, rule of law, and fundamental rights. Importantly, the Venice Commission also makes a global contribution to setting standards within the mentioned fields. It is precisely the experience and contribution of the Venice Commission as regards the transnational constitutional standards, which is the topic of today's conference, where we together celebrate the Venice Commission's anniversary. There is a significant overlap between the work of the Venice Commission and the objectives of the IACL, and even an overlap in members. In all regions of the world, proper constitutional standards regarding democracy, rule of law, and fundamental rights are challenged. So is peace. We are at what seems like an important time in history. Upholding proper standards of democracy, rule of law, and fundamental rights is more important than ever, and may guide us through the many crises all over the world. On behalf of the International Association of Constitutional Law, I would like to express how much we treasure the long-standing cooperation with the Venice Commission. this is not the first joint conference, and hopefully not the last, between the Venice Commission and the IACL. In the IACL, we now have a commission on the cooperation with the Venice Commission, which devotes its entire focus and work to this purpose. This joint conference with the Venice Commission and the new IACL blocks on important opinions of the Venice Commission are among the results of its work. It has taken much hard work to organize this conference, and in that regard, I would like to extend my gratitude to the Venice Commission and the IACL Commission and everyone involved in the organization of this conference, including from the Venice Commission, of course, the President of the Venice Commission, Claire Bassi-Mallory, member of the Venice Commission, Angelica Notzberger, Director, Secretary of the Venice Commission, Simona Granata Mangini, and of course also Sergei Kuznetsov and Iona Pastinaru from the Secretary of the Venice Commission. And from the IACL, our first Vice President, Celine Esen, and Deputy Secretary General, Francesco Biaggi. And last, but certainly not least, of course, the region of Veneto. We all feel very blessed and inspired by these magnificent surroundings. Looking ahead, I hope the Venice Commission and the IACL may continue its fruitful cooperation. I wish you all an excellent conference today. I certainly look very much forward to it. Thank you very much.
Oui. Bonjour à tous. Je vais parler en français, mais j'ai tout à fait une tellement grande confiance pour nos interprètes qui nous accompagnent toujours. Je pense que je vais effectivement parler français aujourd'hui. Mesdames et messieurs, chers collègues, c'est un vrai plaisir pour moi de vous saluer à l'occasion de cette conférence qui porte sur l'expérience de la Commission de Venise dans l'élaboration de normes constitutionnelles transnationales, qui est donc co-organisée par la Commission et l'Association internationale de droit constitutionnel. Je remercie surtout tous les nombreux participants, qu'ils soient à Venise ou en ligne. Je les remercie de l'intérêt qui est porté aux travaux de la Commission et je suis surtout persuadée que les discussions lors de cette conférence, qui est organisée dans le cadre des célébrations du 35e anniversaire de la Commission, vont apporter des idées pour les travaux futurs de la Commission. Je voudrais aussi, bien sûr, remercier le bureau du Conseil de l'Europe à Venise pour son soutien dans l'organisation de cet événement et en premier lieu le Conseil régional de la Vénétie qui a mis à notre disposition la salle aujourd'hui. Alors je regrette de ne pas être avec vous en personne à Venise, mais je dois participer en tant que présidente de la Commission à une réunion à Strasbourg. Mesdames et messieurs, au cours de ces 35 ans d'existence, la Commission est devenue, je crois possible de l'affirmer, un partenaire fiable de nombreux pays en Europe et ailleurs, avec une mission bien précise, soutenir les réformes des systèmes constitutionnels et juridiques et contribuer au développement d'un ordre démocratique stable. Au début de ces travaux, la Commission était principalement appelée à aider les pays de l'Europe centrale et orientale dans leur transition démocratique. En peu de temps, toutefois, la qualité et l'importance des travaux de la Commission ont fait que le reste des pays membres du Conseil de l'Europe et un nombre croissant d'États non européens ont voulu profiter de l'assistance qu'elle pouvait apporter au développement des institutions démocratiques. Chaque État a sa propre manière d'organiser ses institutions et son système juridique en application des principes démocratiques auxquels il a adhéré. La diversité des modèles constitue la richesse du patrimoine constitutionnel, de ce patrimoine constitutionnel européen qui nous appartient à tous et qui réunit les pays membres de la Commission autour de valeurs communes telles que la protection des droits humains, l'état de droit et la démocratie. Mais la mise en œuvre de ces principes est en constante évolution. les États changent leur constitution, leurs institutions, leur législation, dans le but de suivre le développement de la société et de faire face à de nouveaux défis. Les choix faits par les pays ont évidemment été contraints par le cadre institutionnel international dans lequel ils se sont inscrits, Conseil de l'Europe, autres organisations internationales et plus encore l'Union européenne, qui ont toutes mis en place leurs propres instruments pour assurer le respect des traités et conventions qui les ont créés. Mais en termes de principes et valeurs, ce qui unit ces institutions est plus fort que ce qui les distingue. Et la Commission de Venise a vu tout au long de cette période des évolutions remarquables vers plus de démocratie, plus de respect des droits de l'homme, plus de séparation des pouvoirs. Malheureusement, elle a aussi assisté à des dérives parfois graves qui ont compromis le présent et surtout le futur démocratique. Mesdames et messieurs, le sujet de notre discussion aujourd'hui porte sur le rôle de la Commission de Venise dans l'élaboration de normes constitutionnelles transnationales correspondant à la mise en œuvre du principe de l'état de droit. Inutile de rappeler d'ailleurs dans cette enceinte qu'état de droit, droits de l'homme et démocratie sont intimement liés. Lorsqu'elle traite de l'état de droit, la Commission n'opère pas de distinction entre ses pays membres. Nous partons du principe que l'état de droit est avant tout un état d'esprit, une forma mentis, comme disent les juristes. Il est aussi une responsabilité partagée, la responsabilité de tous. Depuis 35 ans, notre objectif consiste en un développement d'une culture de l'état de droit et d'une aspiration générale à sa réalisation. Et cet objectif doit être partagé par les institutions, toutes les institutions, au niveau national comme au niveau international. Nous devons constater avec regret que cet objectif est loin d'être atteint. Certes, il n'est pas étonnant que l'évolution des systèmes et des règles dans les pays qui ont connu une rupture fondamentale avec un régime non démocratique n'ait pas été linéaire. Mais au-delà des inévitables stop and go, accompagnant de tels bouleversements sur une période aussi courte, nous parlons ici de 30 ans, c'est-à-dire 2 générations, des tendances très lourdes de résistance à la mise en œuvre concrète des principes et valeurs démocratiques, notamment de l'état de droit, voire leur remise en cause effective, sont apparues ici ou là. Et c'est à de tels phénomènes qui, à des degrés divers, n'épargnent aucune de nos démocraties, que se rapporte le Conseil de l'Europe lorsqu'il constate la régression démocratique. Nous ne pouvons pas, bien sûr, ici, aujourd'hui, laisser de côté le cas des lois liberticides, telles celles qui empêchent la liberté d'expression sans laquelle la démocratie ne peut vivre, parce qu'elle seule permet le débat, fondamental pour la vie démocratique. Liberté d'opinion, liberté de conscience, liberté de communication, liberté de manifestation, elles sont toutes des formes de la liberté d'expression. Et si la liberté d'expression est une des garanties du respect des autres droits et libertés, elle doit être particulièrement protégée. Toutes les libertés qu'elle inclut appellent toutes aussi des protections particulières qui font partie de l'état de droit. Liberté et garantie de la liberté vont de pair. Aujourd'hui, la puissance des médias augmentée de la puissance des techniques numériques donne une nouvelle dimension au combat nécessaire pour la protection de la liberté d'expression et ses nécessaires limitations. Nos avis couvrent tous ces domaines et de plus en plus, tant le pouvoir en place, quant à lui, cherche trop souvent à protéger son pouvoir en amenuisant les garanties, sous prétexte bien souvent de protection. C'est évidemment la justice qui est le pilier de la protection des droits. Alors pourquoi cette importance donnée à la justice? Parce que c'est l'expression la plus connue et la plus emblématique de la séparation des pouvoirs. Parce que c'est elle, la justice, qui assure in fine la promesse de l'exercice effectif des droits des individus vivant sur un territoire. L'indépendance et l'impartialité du pouvoir judiciaire sont cruciales et souvent aussi mises en cause, non seulement en pratique, mais aussi dans la législation soumise à l'expertise de la Commission. Et en fait, ces dernières années, il est remarquable que les avis de la Commission soient toujours autant consacrés au système judiciaire. Si nous parlons des leçons apprises et des leçons à tirer en relation au pouvoir judiciaire, je vais souligner 2 éléments qui m'apparaissent comme très significatifs de la dérive ou du succès dans ce domaine et qui doivent être l'objet de préoccupations pour tous les États démocratiques. La première est, vous le savez, le risque de capture des institutions judiciaires. L'indépendance de la justice, principe cardinal, signifie que le pouvoir judiciaire doit être mis à l'abri de toute pression extérieure. Or, il y a encore beaucoup à dire sur les systèmes de nomination, sur les questions relatives à la discipline des juges et aux procédures disciplinaires. Il faut ajouter sur les pouvoirs accordés à certains juges eux-mêmes, sur l'organisation du système, et tout ceci en évitant le corporatisme qui est un autre danger pour l'indépendance et l'impartialité requises. La Commission de Venise, vous le savez, accorde dans ses travaux une importance particulière aux conseils judiciaires sous leurs dénominations diverses, car ce sont des organes essentiels, censés être les gardiens de l'effectivité, de l'indépendance et de l'impartialité des juges, et il en va de même, toutes choses égales par ailleurs, pour les procureurs. Dans beaucoup de nos États membres, les réformes se succèdent encore aujourd'hui, et elles sont souvent le signal d'un danger pour le fonctionnement de la justice. Le second sujet de préoccupation qui appelle une attention particulière est la justice constitutionnelle, essentielle pour la sauvegarde de l'état de droit et pour la prévention et éventuellement la correction des abus de pouvoir. Pour exercer sa mission, la justice constitutionnelle peut, elle doit, s'opposer aux législateurs, auteurs de la loi, lorsqu'ils ne respectent pas les principes constitutionnels. Et ce faisant, le juge constitutionnel peut générer de l'incompréhension, malheureusement aussi du rejet. La critique frappe les esprits parce qu'elle peut s'exprimer en termes simples et pourtant parfois combien trop simples au regard de sa signification. Et la tentation est grande pour le pouvoir en place de ne pas respecter une ou des décisions du juge constitutionnel. Nous avons vu trop souvent cette tentation devenir réalité. L'autre tentation est d'utiliser les procédures de nomination dans l'espoir de soumettre le juge constitutionnel à des objectifs politiques et d'obtenir des décisions indulgentes ou déférentes. S'il appartient d'abord aux États d'identifier les problèmes pour pouvoir les résoudre, l'auto-évaluation ne suffit pas toujours. Faire revenir en conformité avec les principes de l'état de droit les systèmes qui s'en sont éloignés ou risquent de suivre cette voie est une tâche aujourd'hui d'autant plus difficile que cela suppose bien souvent la remise en cause d'institutions, de procédures, voire de situations individuelles qui sont nées dans des cadres officiellement démocratiques. La Commission de Venise restera à la disposition de ses États membres pour les conseiller dans leurs efforts de mener les réformes en conformité avec les principes de l'état de droit. Vous savez que nous avons entrepris une mise à jour de la liste des critères qui est devenue l'outil de base de bien des travaux d'analyse de la situation de l'état de droit dans un pays. Et vos discussions aujourd'hui seront une contribution importante à ces travaux et je vous en remercie d'avance. Merci pour votre attention et je vous souhaite beaucoup de succès dans vos travaux d'aujourd'hui. Merci.
Good morning. Hello to everyone. So we're starting the first session of today. And, you know, I'm really happy and grateful to be here and to celebrate the 35th anniversary of the Venice Commission. It started to aid to settle the core principles of the democratic or liberal democracy when this commission was founded in 1990, but now it was expanded, and it's expanded its influence to out of Europe. So commission plays a really significant and important part for not only for Europe to set the minimum standards and principles for liberal democracy, but also out of the Europe. So today's first panel is regarding the negative and positive roles of the constitutional courts. And we have three distinguished speakers today. The original panel consisted of 4 people, but one of our speakers unfortunately can't make it today during listing, and she sends apologies, but she says that she's sick, ill, so she can't travel here. So I would like to, I'm not going to speak any further. I would like to give the floor to our distinguished speakers. So I would like to start with Professor Kate O'Regan. Please, Kate, the floor is yours. She has PowerPoint, so I hope you can reflect her PowerPoint here.
Thanks, Ellen. Thank you very much, Selen. And first, I'd like to start by just saying how grateful I am to the Venice Commission and to the International Association of Constitutional Law for the opportunity to speak here today. I'm going to start because it's just over 30 years since the South African Constitutional Court was established. It heard its first case in February 1995. So this year we are celebrating 30 years of the Constitutional Court, and of course, for reasons that remain somewhat surprising to me, even 30 years later, I was one of the first members of that court. What I really wanted to say is what a terrific role the Venice Commission played. At the time, the Venice Commission itself was relatively newly established. But there we were at the southern tip of Africa, and a country which had received the attention during the apartheid years of many supporters across the world, attempting this transition in many ways difficult circumstances. And the Venice Commission, despite the fact that we are so far away, showed a terrific interest in that transition, and was one of the many organizations and one of the many friends of South Africa during that period. When I was appointed to the court, one of my roles was actually to liaise with the Venice Commission. So I worked closely with your former president, Giovanni Boccicchio, and Mr. La Pergola, and a range of other distinguished members of the Venice Commission. They spent, in the first 5 years, quite a lot of programming in South Africa, all of it which was really helpful. So I feel it's an opportunity to say thank you. It's really been a terrific journey that we've been on, and we're very grateful to the Venice Commission. So turning then to the topic of today's remarks, it's really to talk about the ways in which courts function or contribute to the system of checks and balances. And the title of my talk is, I'm going to talk about South African Constitutional Court's rather surprising jurisprudence on judicial review of legislative procedures. And I'm not going to presume that there's a simple answer to whether this is positive or negative. Time will probably tell, and I'm going to illustrate why I think that. I think, and certainly on one level, it's been very positive. On another, we still have work to do. So I'm going to talk through a series of cases, and I'm sorry, I will try and explain them to you because they, I think, are all rather surprising cases. The first case in this field arrived quite soon after the Constitution was established, and it related to an opposition member of Parliament. And one needs to remember, when you're thinking about South Africa, that until the last election last year, for the first 29 years of its democracy, the African National Congress, the liberation movement, which was led by Nelson Mandela, and which had fought so bitterly against apartheid for 30 years, or perhaps 40 years prior to 1994, and was banned in South Africa and exiled from the country and its leaders imprisoned or in exile, it enjoyed a significant proportion of support. We have, like many European countries, a very strong proportional representation system, a pure list system. But it did not produce a proliferation of parties and coalition government until last year. And for the years up till then, the African National Congress generally enjoyed more than 60% of the vote. So when I talk about an opposition MP in Parliament, it's important to realize that this is a relatively small number of people in Parliament. And this opposition MP decided that she was going to state in Parliament, under the rules of parliamentary privilege, her freedom of speech and her right not to have consequences for that, such as defamation or libel, 10 members of the African National Congress as people who had been spies for the apartheid state. This was not a small allegation to make in Parliament, and it angered the majority party. She immediately withdrew when challenged by the Speaker, but the majority party, African National Congress, were very angry with it, and they held a meeting and they decided that she would be suspended from Parliament for what she'd said. And she then went to court and she said, well, under a provision of our Constitution, Section 58, I have a right of free speech in Parliament which may have no consequences, and certainly not the consequence of suspending me from Parliament. This, of course, is an old provision. It goes back to Article 9 of the British Bill of Rights of 1689. It's reproduced in the American Constitution. It's reproduced in our Constitution. It is very common, this idea that one of the things that our representatives can do in our democracies is speak their mind without consequence in the space of the legislature. And so she took her case to court and she said it was not constitutional for the Parliament to have suspended her, and she won. And at the time it was considered a surprising decision that the courts would uphold her right to speak in Parliament without the fear of suspension. But it was in many ways the beginning of a line of jurisprudence that has built from them, 1999, all the way through to today. The next line of cases which builds on this idea that the court will hold the legislature, will investigate the processes of the legislature and hold them to a constitutional standard, was a series of cases, and of all the ones, as full disclosure, that I'm going to tell you about, this is one I sat in, was a series of cases that came before the court where there was a provision in the Constitution which says that the National Assembly must facilitate public involvement in its legislative processes. This is an important provision to South Africans because if you look at what happened in the transition, the process of transition from the unbanning of the liberation movements in February 1990 to the adoption of the final constitution effectively in February 1997, there was a long period of consultation and discussion that went far wider than the political parties. And one of the reasons for that was that South Africa had an enormously active civil society. So this provision, which is not a common provision in modern constitutions, was put into the Constitution partly, it would seem, as a recognition of the fact that politics in South Africa goes deeper than party politics. And when the case that came before the court was a challenge to a series of pieces of legislation, some of them of great significance, including one relating to abortion, for example, in which Parliament had taken no steps to enable public participation in its processes. The technique for enabling public participation is normally one of the committees of Parliament that debates the bill before it goes to the full House, invites comment. And that comment can be in writing, but at times Parliament also holds public hearings, and those public hearings are sometimes not only held in Cape Town, which is where the seat of Parliament is, but throughout the country, particularly where a particular area of the country is affected. But they had not done any of this in that case. And a group of organizations who were offended by that came to the court and said the legislation is invalid because there was no facilitation of public process. It was quite a difficult case to decide, and the court went about it quite carefully. It said, firstly, you may not bring a challenge of this sort until the legislation has been signed into force by the President. That's the first moment when you can bring that challenge, because bringing it at other times will interfere with the processes of Parliament and prejudge what Parliament may do. Secondly, it says you can only bring this challenge if you genuinely sought to try to participate in parliamentary proceedings. And that too was a closing down of standing, something this Constitutional Court doesn't often do. But thirdly, it then said, because Parliament, in the case of 3 pieces of legislation which had been signed by the President, had not enabled any public comment on them, they said this was not a proper exercise of your power. The court will defer to you in deciding whether you think public participation is necessary, but you need to show us that you've considered the question. You can't simply say we can't be bothered. You've got to do something that looks like a reasonable attention to this provision. And so 3 pieces of legislation were struck down, and that line of authority had quite a few cases that followed, including some of great public interest, like redistricting, redrawing the boundaries of our provinces, which had terrific political implications. And again, there were questions there about whether there had been adequate public consultation. And in one of the cases, the court struck the amendment down, which was in fact a constitutional amendment. And in another case, it upheld it on the basis that there had been sufficient consultation, although the court was divided. So again, you can see this is quite an unusual power for the court. But it was one that I think was by and large accepted by Parliament, and by and large we have seen very few such cases since. It was almost a one-off series of interventions over a period of about 5 years, and now the pattern of public consultation seems well set in Parliament. The third area where the court has intervened related to the concept of private members' bills. This is the idea that a member of the legislature has the right to introduce a piece of draft legislation, even if the executive and senior members of Parliament are not supportive of it. The idea that private members can generate legislation. And this case was brought again by a member of the opposition who had wanted to introduce a piece of legislation, but effectively was refused by the Leader of Parliament, the Speaker, and the Scheduling Committee. And again, the court said, and here the constitutional text is less, in my view, clearly stated, but that it was a necessary principle of multi-party democracy that private members should be enabled to have bills tabled in the House. Doesn't mean that, of course, that they will be passed, because by definition, if you can't get a majority in the House, you're not going to be able to enact legislation. But in many ways, I think this can be seen as a powerful opposition right. If you look, for example, at the United Kingdom's record, there are almost every session of Parliament, there are private members' bills that certainly get seriously debated in the House and sometimes get passed. There has been, for example, over the last session in the United Kingdom, an important piece of legislation on the right to die, the euthanasia. and that was introduced in the House by a private member. So this is an important part of recognizing the role of the opposition in multi-party democracies. There was a similar case on motions of no confidence in the president, which again the court said, you may not defeat a motion of no confidence before it's tabled in the House. If the opposition, and this case was brought by the leader of the opposition, wants to table a motion of no confidence, it's not up to the Speaker and the leader of the majority in the House to deny the right for that motion of no confidence to be tabled. So again, you see an interference in the, or at least I suppose an interference in the way in which Parliament works. The court saying you may not ignore the opposition, and if the opposition wishes to impose a vote of no confidence, they must do so. There were then a trio of cases under the presidency of the former President Jacob Zuma, all of them arising out of a finding by our public protector, which is our ombud, that he had spent improperly on his personal home. The government's regulations entitle the public figures, including the president, to have their security at their personal home paid for by the state, but no other benefits. But it turned out that former President Zuma's home in a rural area in KwaZulu-Natal had been enhanced by a series of improvements which could not be called security: a swimming pool, a place for chickens and cows, and a range of other improvements of this sort. And the public protector said this is improper use of public funding, and under her powers to make a remedial order, she said that the president must liaise with the Department of Finance to repay an appropriate amount for the improvements that he had received. This was an enormous politically consequential moment. It happened the court's finding happened in March 2016. And after that, a series of events unfolded, which led to the court being involved once again in relation to the way in which Parliament responded both to the report and to the question of former President Zuma's fitness for public office. The first major question related to whether a vote of no confidence would be held by secret ballot, because going back to the earlier case, the political party said Parliament hasn't done enough here, the President hasn't done enough, we want a vote of no confidence. And a series of organizations came to the court to say, we would like this to be in secret, but the Speaker thinks she cannot make it a secret ballot. And the court said, look, the Speaker can make it a secret ballot. There's nothing in the Constitution which stipulates it may not be. In fact, the appointment of the President is required to be by secret ballot. So there's nothing in the Constitution which says you may not. And the Speaker then did, in fact, hold the ballot by a secret ballot, and it was narrowly defeated. But it was pretty clear that quite a large number of members of the African National Congress had voted to a vote of no confidence in President Zuma. So I could tell you more about these cases. There was another one which was of importance, but I'm conscious of time. And I really want to turn to this question of how we assess these kind of interventions in the separation of powers, in checks and balances, which is the topic of this panel. And I think the first thing to note about that is that there is no one conception of the separation of powers. For those of us who live in presidential constitutional settings, to those of us who live in semi-presidential like South Africa, or purely prime ministerial, we recognize that the relationship between the legislature and the executive varies across all of these. Similarly, the role of the courts varies across different settings. So it's not as if there is one true account of the separation of powers. And when we then turn to asking the question, well, is this rather extraordinary jurisprudence in South Africa positive or negative? It seems to me that there are two ways we can answer this question. The first is the external view, a political science view, if you want. By that I mean external to the legal doctrine. And here I'm drawing, and I've probably spent too long in Oxford, on the ideas of HLA Hart, who recognize that the way in which a legal system is constructed has an internal point of view, which is how lawyers understand the system, whether lawyers think an argument is good, whether lawyers think something is law, is a very important part of how a legal system is constructed. An external view is how politicians and political scientists and social scientists view the system, and perhaps how citizens do too. And if you look at this series of cases coming out of South Africa, there's a rich jurisprudence emerging on it. For those of you who are interested, Stephen Gardbaum, the distinguished British-American comparative constitutional lawyer, has developed a theory of comparative political process theory, drawing on John Hart Ely's founding work on the American constitutional system, recognizing that there is something about political process which may be a legitimate role for constitutional courts in modern democracies. And in South Africa, Feroz Kachalia has written a brilliant piece, I think. But to me, both of these pieces are external. They're thinking, and this is what a lot of comparative constitutional law is. It's very hard to be internal about legal systems across a whole array of them. And so I think that there's no doubt that both in South Africa and abroad, there is generally cautious support for this line of jurisprudence, recognizing, and the argument often is that at the time the African National Congress was dominant force in South African politics, political scientists labeled South Africa as a single-party dominant democracy. There hadn't been a change of political power since 1994. And in those circumstances, it was argued that is legitimate for the courts to be more engaged. And as a citizen, I welcomed nearly all of these judgments. But as a lawyer, I think the questions are different. And I think it's very important as lawyers that we remember that what the task of a constitutional jurisprudence on the separation of powers is to build a coherent account of the separation of powers, which has predictive value, which we can understand both as lawyers and legal advisors to the president and to parliament can say, the court will get involved if you do that. And my question today is whether we have yet developed in South Africa a convincing account of what the court has done over these cases. I think the early cases, they're longer ago, and I think we now have had more writing. I don't think that I think they are now fairly clear when the court would get involved in a freedom of speech case in Parliament, and similarly in relation to the role of the public in legislation. But I think the later cases still require more work. And I suppose my plea is that we can't fully say this series of cases was positive until we can be sure we can answer that question, both from an external perspective and an internal perspective. Thank you.
So good morning, everyone. I'm going to talk about constitutional courts as guarantors of the separation of powers. And if I take up the main message by Kate, I could say we agree that constitutional justice is about protection of minority, of the opposition in parliament. That is one issue I'm also going to address. So since the beginning of the 1990s, the promotion of constitutional justice has been one of the core missions of the Venice Commission, and it has remained a core issue. It has continuously been a crucial element in the wider goal to advance constitutionalism in its member states and beyond. Notably, the Venice Commission has repeatedly emphasized that constitutional justice plays a vital role in ensuring checks and balances within a constitutional democracy. Constitutional courts are an instrument to protect the normativity of the Constitution and hence serve as the primary constraint on state power. In my presentation, I will discuss some aspects concerning the role of constitutional courts within a system of checks and balances from a national as well as from a European perspective. In particular, I'm going to highlight the position of constitutional courts in relation to the legislative and the executive branch. Following that, I will examine two ways in which constitutional courts contribute to checks and balances in democratic systems. Finally, I will discuss how constitutional courts maintain checks and balances in transitional systems and in situations where democracy is in a crisis, and how they themselves can be subject to oversight. So what is the position of constitutional courts in relation to the legislative and the executive? In most European jurisdictions, legal checks and state power play a crucial role in the functioning of the political system. Nevertheless, the rise of modern constitutional courts in a large number of states is a relatively recent development. Constitutional courts in Europe were typically established in the course of transformation of democracy, and the primary purpose of these courts was to overcome the anti-democratic burden of the previous regimes and to protect, above all, human rights, which were to a large extent violated by former dictatorial or autocratic regimes. Instead of the principle of the unity of power, which excluded any control over parliament, separation of power was breaking ground, and so from a European perspective, constitutional justice and separation of power are historically closely linked to each other. The prevailing constitutional review, or the prevailing approach to constitutional review in legal theory, goes back to the ideas of Hans Kelsen. So I may say I have lived too long in Vienna not to quote Hans Kelsen. Kelsen, who has been a justice at the Austrian Constitutional Court himself in the 1920s, conceived the legal system as being constructed upon hierarchical structure, with each rule deriving its validity from a superior role. At the top of this hierarchy is the Constitution, which serves as the ultimate source of validity for other rules and the legal systems as a whole. Kelsen's main concern was the supremacy of the Constitution and the uniformity of constitutional interpretation. In his opinion, the democratic process must not be reduced to the majority principle. An understanding of democracy based on the freedom of the individual necessarily includes the protection of minorities in opposition and their rights. And the idea of constitutional justice is that this protection of the minority in the sense of effective control of power can best be guaranteed by a body that is independent of any other state authority. It is remarkable that discussions on constitutional justice as counter-majoritarian difficulty have hardly emerged in Kelsenian systems. And there's a reason for that. In the least dangerous branch, American Alexander Bickley argues that constitutional review is illegitimate because it allows unelected judges to overrule the lawmaking of elected representatives, thereby undermining the will of the majority. With the exception of comparative analysis, this approach is not shared among European scholars on the continent. While constitutional courts have been perceived as democratically problematic institutions in countries with long democratic transitions, most notably in the United States, Great Britain, or Scandinavian states, there's historically no comparable criticism of constitutional courts in post-totalitarian or post-authoritarian political systems like Spain, Italy, Hungary, Austria, or Germany. As constitutional courts there, on the contrary, have shown to be strong enforcers of democratic structures there. Those countries have deliberately chosen to establish powerful constitutional courts because of the former threat to democracy and fundamental rights. The Constitutional Court's competences are understood to positively serve the purposes of a constitutionally limited government, and their powers are conceived as a juridical category that relates to the variety of functions developed by constitutional courts. Now, based on this theoretical background, how do constitutional courts contribute to democracy and the checks and balances? Especially in the light of the challenges and the loss of trust constitutional courts face across Europe and the world, it is essential to maintain a careful balance between constitutional courts and other branches of government. The concern about constitutional courts potentially becoming a threat to democracy could arise when these courts overstep their mandate. Not all constitutional courts have the same competences. I would like to highlight two key areas of competences where constitutional courts uphold the principle of separation of powers and positively contribute to the system of checks and balances. The two examples are proceedings between state organs, in the German language Organstreitverfahren, and norm control proceeding as the second category. Now to the first two proceedings between state organs. This has impact on the separation of powers, and many constitutional courts have to decide over conflict between such organs in the exercise of their competences. In this kind of disputes, the constitutional courts assumes the role of a kind of arbitrator between other constitutional bodies, for instance, the President of the Republic and Parliament, or between two chambers of Parliament, or in federally organized states, constitutional courts are responsible for legal disputes between individual constituent states or between a constituent state and a federation. The constitutional jurisdiction ensures compliance with the system of competences and it is thus a procedural vehicle for the protection of the system of checks and balances. The Venice Commission has repeatedly addressed the importance of the role of constitutional courts in preventing conflicts among state institutions, thus ensuring their smooth functioning. According to several opinions of the Venice Commission, one of the essential roles of constitutional courts is to maintain equal distance from all branches of power and to act as an impartial arbiter in cases of collision between them. I would here like to emphasize briefly two aspects of those proceedings. One is the protection of minority in Parliament. In line with the general aim of constitutional justice, it is one goal to protect the democratic minority from the reign of the majority. Or in the words of the German Federal Constitutional Court in its 2014 decision on statements of the federal president regarding political parties, I quote, "The minority shall always have the possibility to become majority." The second aspect is, as I would like to call it, strengthening the self-healing power of democratic institutions. In their case law, the German Federal Constitutional Court and the Austrian Constitutional Court have developed duties of parties in a conflict, a so-called obligation to confront. The complicated German word is Konfrontationsobliegenheit, and it means that before addressing the Constitutional Court, the parties must demonstrate that they are not replacing political action with constitutional steps without good reason. This means that applicants are required first to attempt to resolve the conflict through political discourse if possible. The Constitutional Court's role in resolving the conflict is considered subsidiary and ultima ratio and should not be seen as an option to avoid pursuing a political solution. Through this principle, the Constitutional Court encourages political parties to address the conflict themselves, thereby strengthening the self-healing capacity of democratic institutions. Now let me turn to norm control proceedings, which is at the heart of the Kelsenian model of constitutional justice. As constitutional courts are empowered to set aside laws and statutes, they are often described as negative legislators. The Constitutional Court is inevitably and on a permanent basis close to the powers of the legislature, also in a positive sense. And let me enumerate 3 features of possible positive or active interventions of constitutional courts with the legislative power. First, the so-called interpretation in conformity with the Constitution. In many systems, constitutional courts have a degree of discretion in deciding whether to strike down a law or interpret it in such a way as to bring it into conformity with the Constitution in context of normative review proceedings concerning the constitutionality of a legal provision. While at first sight they preserve the integrity of the law, this is not always an act of judicial self-restraint. In particular, in cases where the legislature clearly intended a solution that the Constitutional Court has found to be unconstitutional, the court replaces the original meaning with a new one, in effect amending the law. In cases where the legislature could have chosen another solution that would also have been constitutional, and taking into account the fact that the majority in Parliament would have opted for a different solution, this approach may de facto limit the legislature's room for maneuver. Secondly, constitutional courts may give guidelines for new legislation and be quite active in doing so. Sometimes, the courts do not confine themselves to saying what is absolutely necessary to justify or found the annulment of a law. In fact, they go further in their reasoning and provide guidelines for future legislations to the parties in the case and above all to the legislature. In systems where the Constitutional Code is accepted by all political parties and has acquired a high degree of authority, such guidelines can have a considerable impact on the legislative process following the annulment of a law. Thirdly and finally, constitutional courts are sometimes even supplementing Parliament. There may be situations where legislation was required by the Constitution or simply by practical reasons, but there is no consensus in Parliament on a solution. In such circumstances, it is possible for one of the conflicting parties to refer a more or less political question to the Constitutional Court, which is often prepared to decide the question by means of constitutional law. In this context, and in a certain contrast to what is suggested in articles referring to the need for constitutionalism, I call for awareness that constitutional courts regularly come close to the boundary between judicial power and legislative power, which is neither a straight nor a clear one. And there may be situations in a constitutional system where the Constitutional Court steps over this line without being accused of abusing this power. The legislature's political discretion also includes a margin of appreciation, to take a famous notion of the Strasbourg Court, especially in complex situations involving technical questions of any kind where the ex-ante view of the legislature is necessarily different from the ex-post view of the constitutional judge. Issues of climate change, for instance, are definitely a field where judicial activism is currently under heavy discussion. In well-functioning democracies, constitutional courts will also take into account the strong material democratic legitimacy of a decision of Parliament, which the court will not replace with its own assessment in situations of political discretion. The extent of the judicial self-restraint will vary from country to country and from one field of legislation to another. We have just seen the example of South Africa, and I think we could add, with our experience here in this room, many other examples. Nevertheless, there are common lines in a comparative perspective, and here I'm very much in line with what Kate has said. Common lines that are drawn by international courts, especially regional courts, such as the European Court of Human Rights or the Inter-American Court of Human Rights. These courts have set standards in the past with respect to many human rights guarantees, and they have defined areas where the member states enjoy a larger margin of appreciation and situations where there must be a stricter control by the international judge. Before I end my presentation, I would like to add a more fundamental observation on constitutional courts in transitional systems and in situations of crisis. On the one hand, constitutional courts are typically set up to provide a strong enforcement for constitutions and democracy. On the other hand, they are, as we have seen worldwide, endangered. Limiting judicial review is a significant step in weakening the systems of balancing, controlling and checking governmental power. When constitutional courts are undermined or manipulated, they can no longer fulfill this balancing function effectively. In a negative sense, and we have seen these examples recently, in systems in crisis, courts can obtain pro-regime roles as bolstering of administrative discipline or the cohesion of the ruling elite. However, if the courts remain independent, they can play a key role in giving the opposition opportunities to contest government policies, in particular when democracy is in danger or under open attack. Today, constitutional courts are powerful entities in their own right in many countries. They not only oversee checks and balances, but also play a significant role within the political power structure. At least in Europe, they are generally regarded as a strong asset to the system of checks and balances rather than a threat. However, as we have seen over the last years, constitutional courts possess unique powers that, if misused, could also pose a risk to the separation of powers and democracy. In a constitutional system of checks and balances, what safeguards do exist to prevent justices from gradually rewriting the constitution to accord to their preferences? Are constitutional courts a check that remains unchecked? The answer is as simple as short: no, they are not. They must not remain unchecked. The practice of constitutional courts is open to correction by politics. However, as the eminent former German judge Dieter Grimm puts it, a correction by politics does not mean to ignore judgments or to set them aside. In a state governed by the rule of law, there's no retroactive but only a prospective correction of the case law of constitutional court. And the means for this is the change of the constitution in the procedure laid down there. My personal approach, based on the practice of almost 20 years in the Venice Commission, as well as in a constitutional court with some experience, may be summarized as follows. At least for member states of the European Union, the judicial triangle of national constitutional courts, European Court of Human Rights and the European Court of Justice has by now reached a quality and a level of integration that there is a separation of power also transnationally and within the judicial power in a wider sense. In this way, the influence of constitutional courts on the political process, including the power to amend majority decisions in Parliament, seems adequate, as those courts do not decide simply based on a competence of the last word, but as a result of a sometimes complicated process of judicial dialogue which takes account of the case law of the other courts, transforms it, and by doing this gives innovative input also to the international case law. In other words, the power of judges is distributed in a well-balanced way, as it is the result of a case law of shared burden. It has gone through a process of an intrajudicial process and of checks and balances. Future discussions among scholars as well as among judges will have to take into account this particular European aspect of separation of powers. They should not limit themselves to clauses of competences, ultra-virus discussion, but keep the broader goal of harmonizing the protection of fundamental rights in Europe in mind. The broader goal remains to protect the democratic process by preserving open space for public debate and fair elections. In fulfilling these tasks, constitutional courts are, as the former German constitutional judge Susanne Baer puts it in her speech at the 2023 Strasbourg Judicial Seminar, I quote, "the institutional device to make sure that democracy works," end of quote. In conclusion, while constitutional courts are seen as crucial to upholding democratic values and maintaining checks and balances within European political systems, they also carry the risk of overreaching and undermining democratic processes if their powers are not carefully calibrated. The evolving role of these courts in European democracies highlights the need for ongoing debates about their role in the political systems, the limits of judicial power, and the balance between different branches of government. The Venice Commission's call for strengthening constitutional justice continues to resonate, emphasizing that while constitutional courts are essential for safeguarding constitutional norms, they must also respect the principle of separation of powers and remain accountable within the broader political systems. Thank you very much for your attention.
Oh, thank you. Okay, good morning. The polite way of starting a presentation is to thank the organizers for the invitation to make this presentation, but I'm afraid I will not be polite. And I'm not going to thank the organizers for the invitation, because after my two colleagues' presentations and looking at the audience, I don't have anything to thank at all. Because in some sense, I feel more an impostor than a speaker. Because I was asked to present the way the Venice Commission has deal with the constitutional justice issue in these last 15 years. And I'm not really a true expert in constitutional justice, and I've been only 3 years at the Venice Commission, so I'm not an insider, I'm not an expert, so who am I? Well, I am, I would say, an outsider. I have the eyes of an outsider that knows how the Venice Commission works. Okay, so I have prepared a presentation. Yes, that doesn't work. Okay, it's all right. Oh, yes. So here we are. I'm an impostor. And then what I want to present here is a presentation not about the content of what the Venice Commission has said about the constitutional justice, but mostly about the context in which the Venice Commission has been asked for to give an opinion over constitutional justice. That means reviewing, looking at 15 years of work of the Venice Commission, which includes 81 opinions, not reports, not studies, but concrete opinions. And what do we find? Well, these are the numbers. This is 81 opinions, which 15 are amicus curiae opinions. And here are the numbers. At first glance, we may raise some conclusions. First, there are very few opinions on democracies whose constitution was passed before the 90s. Most of the opinions are for countries with younger constitutions. Second, and here from this number I think we can have a first conclusion and a proposal. There are sagas. There are countries where there is a repetition of opinions on the same topic. These sagas, hey, I love this thing. It doesn't work? Okay. Okay, here. I'm sure you are helping me. Thank you. Okay, the first conclusion is this sagas, a comprehensive assessment of the question is a kind of a multi-level approach. The Commission first works from the point of view of the general standards settled down in constitutional justice, but then, step by step, it makes a tailored approach to the concrete problems and the factual situation in those countries. So to adapt this general approach to the concrete situations in those countries, learning from the previous opinion. In this way, the Commission may develop a kind of a dialogue. But in fact, we have to be conscious that sometimes it's a dialogue of the deaf. I mean, there's no one listening at the other side. That's something sometimes happens. And to the proposal, which is the basic structure of my presentation, I think from this reading of these opinions in the last 15 years, I think that the Venice Commission has played three different roles. First, it has played a purely technical role in advising national institutions when facing issues related to constitutional justice. But the Venice Commission never losing sight of this technical approach, because it's a technical body. It has acted as an arbiter in some situations, and it has acted as a red flagger in other situations. Let's see these three different contests. Okay, here we start with the jokes. I love Calvin. Calvin loves it. First, the Venice Commission has been a highly specialized advisor. I mean, the Venice Commission has been requested to ask or to evaluate, to assess national reforms that can be global from a constitutional point of view, from a legal point of view, constitutional legal acts for constitutional courts, rules of procedure, or sometimes concrete aspects on constitutional justice related to any other reforms, or even judiciary reforms where constitutional courts may play a role. Who asked? National authorities. Why? Because they need this technical assessment. And sometimes, and this shouldn't be forgotten, because there is some kind of international external pressure, especially when we talk about countries who want to become candidates to the EU accession. I mean, on the pressure of the European Commission to reform the legal orders, they will ask the Venice Commission just to get, the quality stamp of rule of law, good candidate. Which are the issues? Well, it depends on the country. I mean, every kind of issue about constitutional justice might be the object of the request. Global restoration of a constitutional court or specific reforms. What is the role of the Venice Commission? It's a technical advisor. I mean, and this is, the classical role, I would say, of the Venice Commission, the idea that gave birth to this specialized body to help the transition in countries to rule of law standards. So this is a very classical approach, in which, it was stated by the academic literature, and in this role, the interconnection between access to the EU and the ability of the Venice Commission to get its recommendation followed is quite, it's quite interesting. States who are candidates to EU accession will comply with the recommendation, and then they become members after some negotiations, some years. They become members of the European Union European Union, thanks to the respect of the so-called Copenhagen criteria that was settled down in the last 80s. Now we go to the second role. Here, this is not Calvin and Hobbes. I mean, I'm sure that the Spaniards, the Latin Americans will know this joke, which is Mafalda. It's well known in Latin America. Well, this second context is when the Venice Commission is requested to intervene because there is some kind of constitutional problem at national level, or some kind of constitutional crisis, nor basic constitutional crisis in rule of law issues. This is a very deep constitutional crisis. When there's a kind of clash, it can be a checks and balances crisis or a socio-political crisis. It can be clashes with parliaments, and we have quite examples. Can be clashes with the executive, specifically in the scope of opinions I have revised with presidents. It can be a crisis with constitutional reform power. From a counter-majority, from the perspective of the separation of power, we could imagine that there will be clashes between the Constitutional Court and the judiciary. We can think of, the Italian Guerra delle Corti, war among courts, Supreme Court and Constitutional Courts, but there is none. There is no case in these 15 years of a conflict between the Supreme Court and the Constitutional Court. And there are also classes because of what I may call Constitutional Court bad decisions, those that Christoph talked about, overstepping their role. And then we have those political crises. I mean, a strong clash between a majority and opposition, or even cases in which there is an absence of a public confidence on the Constitutional Court for different reasons. Who ask for? Mostly national authorities. But sometimes, when the crisis is important, also international authorities, and in particular any organ of the Council of Europe. Can be the Secretary General, can be the President of the Parliamentary Assembly, can be the President of the Monitoring Committee, whatever. Why? Well, there are two different situations. Sometimes it is the Constitutional Court who uses the request to the Venice Commission to defend the scope of their competences. And it's very interesting that sometimes it makes it through an amicus curiae, not through requesting a report, but through an amicus curiae, and sometimes it makes it even in advance. Yes, taking into account that any concrete decision is going to raise a strong opposition. Then the Constitutional Court may ask the Venice Commission. The other situation is a national authority asking the Venice Commission its opinion about its own solution of the constitutional crisis they are trying to solve. Which are the issues? Well, it may vary, but most of them are appointment, questions of vacancies and delays in appointments, removal of members of the Constitutional Court or presidents, disciplinary proceedings, and sometimes competencies. In particular, again, Christophe's two perspectives of the same ideas. I think we are just absolutely in line. Enforcement of judgments. And which is very interesting is the fast-track procedures in cases of parliamentary reapproval of law previously declared constitutional. It is quite interesting that in some countries there are a problem of declaring the unconstitutionality of a given law, and then the parliament will approve again the same law. So this kind of situation. Here, my first option was to understand, to see the Venice Commission as an arbiter, but after going a bit in depth in the issues, I think it's more a facilitator than an arbiter. I mean, what the Venice Commission usually does, in my view, outsider's view, I wasn't part of the discussion, is to give the national continents the rules of the game, but not the solutions. It's for the national authorities or for the national powers to find the solutions in this context. We have 14 minutes, so I have only 4 minutes to go to the most important part, so I will go fast on it. Rule of law crisis. A global questioning of the fundamentals of the rule of law. Here we must distinguish, or at least I propose you to distinguish, three different situations: before rule of law backslidings, after rule of law backsliding, and restoration of rule of law backslidings. Before, okay. The joke is wonderful. Responsible for Albert Walker. When after an electoral victory, a moment that questions the foundations of rule of law, will try to implement its program. By whom? This is interesting. In the first years, by national authorities who wanted to change the system. They did it once or twice, they never repeat. In the other cases, it was basically the Council of Europe. Why? When the national authorities make their request, they were looking for justification of the changing of the basis. When the request is made by international institution, the idea is to protect rule of law principles. Which issues? Okay. Appointments, of course. The change of the way to appoint members of the Constitutional Court. Terms of office, disciplinary regime, execution of judgments, and what the Venice Commission has named crippling the effectiveness of constitutional justice. I mean, basically two ways. Limitation of the power of constitutional courts to review constitutional amendments, first. And second, the introduction of procedural reforms. Higher quorums, low time limits, pre-established sequence of deciding the questions, just to weaken the way Constitutional Court may confront a rule of law backslide. After a rule of law backslide, this is a second context. Okay, this is last work before I push, so thank you. Here the situation has changed dramatically. Now the Constitutional Court is captured. It's in line with the government. Who asked? Obviously, the Council of Europe. And what are the issues? Again, habitual suspects, appointment, tenure. But in competences, there is a shift. Christoph has pointed that absolutely correctly. I was very happy when I was listening to you. To be, I was not so wrong. Because here, there is a strengthening of the new Constitutional Court. We want it even stronger, just to protect the effect of rule of law backsliding. So, particularly clearly in some countries, the control over international court judgments to avoid any international court. But also, and I think it's very interesting, is a generalization of the ex-ante control of constitutionality. So just to avoid any possibility of a law to enter in force before the new capture Constitutional Court may have said its word. So, third context, and I'm reaching the restoration. Okay. Again, as in these two contexts, the Venice Commission is a red flag. Say, no, you can't do this. This is not in line with rule of law basics, rule of law foundations. In restoration of rule of law, things change. Because here, when it's after a restoration party has won elections, who? The new government is the one who asks. Why? To support the reforms, to gain the authorities of the Venice Commission in this restoration, and to find, if any, rule of law limits to this process of restoration. And what are the issues? I mean, it can be a global restoration, a refoundation of the whole system, or a concrete reforms to change the situation. And what are the topics here? Appointments, tenure, but tenure of former judges, I mean judges of the previous Constitutional Court who was captured, a review of judgments made by this Constitutional Court's capture, in some cases, when they have been declared not to be courts established by law. And additional safeguards for the future, in particular procedures to appoint new judges. Here, the Venetian Commission is not only a red flag. It's not only the body that may say, for the restoration of rule of law, you can't do this, this, and this, but also it's a facilitator. If you want to do this, you should do this that way, or that other. So, conclusion. I love this joke, the place where you go when you are tired of thinking. 3 different roles for the Venice Commission: technical advisor, facilitator, not arbiter, and red flagger. What are the issues? Appointment, tenure, competences, especially in competences, ex-ante constitutional supervision of draft laws or of constitutional amendments, and parliamentary privileges, which are, for me, the 2 most important issues in terms of competences, and execution of judgments. And one final conclusion in this global approach. Constitutional, and it's the same conclusion as Christoph, so thank you, Christoph. I blame you because you have said the conclusions 20 minutes in advance to me. Constitutional Court is a seal of the Constitution and rule of law principles. It's based on strong safeguards, designed on a technical basis, able to face constitutional rule of law crisis. But this seal can be also a lock when the crisis implies a true rule of law backsliding. And here the Constitutional Court can become a sword, or even more, a battering ram to destroy not only any trace of rule of law, but also any intention to restore rule of law. And the Venice Commission, only in very, very exceptional circumstances, have assessed the conformity with rule of law standards of a constitutional court decision. I mean, there is a kind of a presumption of conformity in place that any decision of a constitutional court is right and has to be complied with. Probably with these kind of situations, we should lower the standard of control. And as in one of the Ukrainian opinions, the Commission said, these constitutional court bar decisions are probably a signal that a reform is needed and the starting point of a reform. Thank you for your kind attention to this impostor.
Well, thank you very much to all 3 speakers. We listened really 3 interesting presentations, actually complementing each other. According to the program, we hit the deadline for the first panel, but I would like to give the floor at least, for a couple of questions, because these 3 speeches are really interesting, and at least I have questions for you guys, but before I do, please go ahead if you have any questions to the speakers or any comments regarding the subject matter of this panel.
Perhaps, thank you very much for your interesting lectures. Just perhaps to start, a question for Christoph. You mentioned this Bickel paper and the counter-majority and difficulty, and then you said, well, it was not really accepted or taken over by, and then you named Hungary, Germany, Austria, Spain, and all those were we had an experience of dictatorship, and we understood that something like constitutional courts are a necessary institution. That means for me that you sort of distinguished between the countries. You said it depends on experience. If you have such an experience, you need it, the institution. If you do not have, and there you mentioned the US and Scandinavia, you said, well, you may be more skeptical. And for me, the interesting point is now, after 35 years of Venice Commission standards or trying to set some European standards, how do we take in this experience? We have now all those, and Rafa mentioned, we have these models, especially in Eastern Europe, where we had huge difficulties with constitutional justice, and it had been instrumentalized to bring about authoritarian rule. I mean, we all know what we are talking about. So it had the opposite effect. And my question is, can we aspire to have some general standards, or do we have to qualify the standards with a view to experience and to say, you have to have something, we always want to have something universal, but experience matters, and you can sort of change it according to your experience. Thank you.
Thank you very much, Angelica. Let's collect the questions, actually, before give the floor to the speakers for the last time.
Yes, I would also like to thank all the speakers for their presentation. I shall continue from where Angelica stopped, to the possibility of general standards. I think the last 15 years of rule of law regression have learned a lesson also in the respect that what is crucial to be able to block this regression is an independent constitutional court or independent constitutional review, and it was no coincidence that the regression started from the attack on the constitutional court in Hungary, in Poland. But can we produce general standards which would protect the independence? The nomination of the judges, it is crucial, as both Christoph and Rafa said. But, for example, if we look at the opinions of the Venice Commission and our reports, we haven't come up with very precise recommendations as to the proper process of nominating and appointing the Constitutional Court justice. We have emphasized that when Parliament elects at least part of the judges, a qualified majority should be needed, and we have also recommended some kind of dispersal of the appointment power. But that's about all we have said. But can we be more precise? This is a very sensitive issue because there's also the requirement of a certain democratic legitimacy, different from what ordinary judiciary needs. So there's also, as regards the nomination process, appointment process, there's this delicate balance of law and politics, so to say. Yeah, maybe I stop here.
Well, thank you very much. Point taken, I think. Yes, please, from the second row.
Thank you, all speakers. I would add an obvious point that is the experience, especially from Hungary and Poland, shows how the Constitutional Court can be turned, shall we say, and become an instrument for authoritarianism rather than the other way around. So I think it's important to note that. Plus the fact that we saw also the resilience of the ordinary Polish courts with the assistance of the European Court of Human Rights and the European Court of Justice, were able to fight back in a way that the Constitutional Court was not, because it's quite simply much more difficult to take over the entire judicial system. If there are brave judges, which fortunately there were in Poland, we saw much more effective resistance there.
Okay, thank you very much. So I would like to give the floor to the speakers again in order to respond the comments and the questions, or in order to complement your presentations if you deem necessary. Kate, would you like to? Okay, so let's start from the...
All right. Well, a lot of these questions are reflecting on the ability to set general standards, and my own view is that they are very difficult. I think South Africa, obviously, like every other country, has its own very particular history, which means that that history is enormously influential. Law is path-dependent. We build on what has gone before, and it's very difficult to eradicate that sense of history. So I think it is challenging. On the other hand, the idea of recognizing that there are a kind of minimum core of principles does seem to me to be possible. I just wanted to comment on the appointment process, because again, I think that, you know, here at play, there is the need for democratic legitimacy, but there's also the need for expertise and competence. And I think there is a possibility of setting some standards of criteria more candidly, more openly, more publicly, which I think would be useful. And I've just been involved in that for a international organization that engaged with transitions, looking at what are the criteria for judicial appointment. So I think that is, in fact, an area where we could set some relatively general standards, but which would be valuable. And I think that, you know, just lastly, I think what we have learned over the last 20 years is that constitutionalism can be turned against itself. And so really we can't ever leave politics behind. Politics remains enormously crucial here. And sometimes I think as lawyers we forget that, and that our role as citizens is almost as important as our role as lawyers.
Yes, thank you. Brief comments on all three questions. Angelika, yes, I agree. Experience matters, definitely. And coming back to my point, I would just rephrase it, what I have said in 2 sentences. In countries where we had dictatorships and we have the positive experience of a successful constitutional justice, we have no difficulty with the counter-majority difficulty, so to say. So we are not as critical on the fact that judges are not elected, but we see a value that they are appointed for a longer term than one legislative term of 4 or 5 years, and they remain there and are independent of the governing party and live that also. And that leads me to the Carlos question, should we look more on the standards for nomination of judges? I think partly yes, partly no. I think to start with, the question of nomination of judges, the importance of this must not be underestimated. It is very crucial, and why I say partly no is that the experience of looking from a comparative perspective on nomination processes, it's not only about rules, but it's about constitutional culture. We can see this in countries where the political system changes. Look at Germany. There you have a very positive culture of agreeing on constitutional judges between the 2 former big parties in parliament. And now that a right-wing party comes up, the rules are questioned, constitution is changed, and there is, besides that, there is one nomination waiting in parliament from the Conservative Party, which is not moving forward, and may the consensus is not so strong, although the rule in this point has not been changed. Thirdly, Ian, I fully agree, and I think it's very important that you mentioned the ordinary judiciary. I think we cannot look at constitutional justice or just on an isolated basis. I would say constitutional courts are in situations of a crisis, they are in a way the Achilles heel, because if you have an arrow, if you target this Achilles heel, you can hit the whole system. But the judiciary, you cannot have so many arrows to hit every judge, and it's a sound basis for the rule of law. And I would add, from a European perspective, also the European courts in Luxembourg and Strasbourg are strengthening the systems. So thank you. I should have added in my presentation also the ordinary judge, civil and criminal administrative judges. Thank you.
Thank you. It's great to talk the last because you don't have anything to say. I absolutely agree with my colleagues. I just would like to point out that obviously I agree, experience matters. There is a connection between experience and culture. Depending on the experience, you may build.
Changes as well.
Yeah, but
the
the question is, you can't take it for granted.
Yeah.
I mean, you have used Spain as example. I don't like to talk about my own country, but that's the view some years ago. We must take into account that the most important constitutional crisis in the last years in Spain is in part due to a constitutional court decision. And this constitutional court decision has raised, at least in a part of the country, a very strong counter-majoritarian objection. And then something we took for granted, and now it's not granted anymore. And the question was, if the Constitutional Court decides regional constitution is again the Constitutional Court is no longer democratic. So we have that problem. And very important also with Ian and Carlo. And I think it's very important to find a way to make a tailor-made approach to these standards, general standards and then tailor-made approach. And there is, some kind of an elephant in the room, which is which model of constitutional justice. Probably it's not the same question in concentrated model with the constitutional court that can be quite easily captured by parliaments and by politics. And American type constitutional system, maybe the standards are not the same. Just a very general reflection. Thank you.
Okay, thank you very much to all three speakers. The topic is very hot, so we cannot finish it or come to an end. So I encourage you to continue this discussion while you're having coffee. Thank you very much.
Dear participants, we kindly ask you to return at 20 past, if possible. Well, a little bit late.
Yes, I emailed. Where did you print this? Oh, I see. Because it was only last night that I somehow I must have to wait to print it out here.
Dear participants, I think since we're running a little bit behind the schedule, probably we will start the next session. And I have the pleasure to announce the second session of this conference, Fighting Against Corruption and Upholding Rule of Law Standards. This session will be moderated by Tuomas Ojanen, member of the Venice Commission in respect of Finland, and our panelists will be Mr. Kerim Kerimi, member of the Venice Commission in respect of Kosovo, Renata Deskoska from North Macedonia, and Veronika Bilkova from Czechia. So since we are behind the schedule, I really ask you well, we will try to respect the schedule, but also for the questions at the end of the session, be aware that we will try to finish as announced in the program. Thank you. So, Mr. Ojanen, please.
So warmly welcome to this second session or panel of this high-profile conference, Fighting Against Corruption and Upholding Rule of Law Standards. So this panel is set to focus on corruption, which is a particular challenge to the rule of law, since corruption leads to arbitrariness and abuse of powers. Corruption also promotes human rights violations and increases the influence of elites and organized crime on policymaking. Moreover, corruption undermines global climate action and efforts, as well as maintain authoritarian government constellations. In short, therefore, corruption undermines the very foundations of the rule of law. So welcome to this very timely and important panel, and we have today three distinguished speakers who will be sharing their insights on this topic of fighting against corruption and upholding rule of law standards. I must inform you that we have changed a bit the order of presentation that is displayed by the program, namely Veronika Pilkova will start, and after her presentation we will hear presentations by Mrs. Renata Deskoska and Mr. Kerimi. I will introduce them in more detail before they start presenting. So now it's my pleasure to introduce our first speaker, Veronika Pilkova, who is Vice President of the Venice Commission and lecturer of the Law Faculty, Charles University of Prague. She is also a member of the Management Board of the Fundamental Rights Agency of the European Union. Please, Veronika.
Good morning, ladies and gentlemen, dear colleagues. Many thanks for the kind invitation and for the kind introduction. Just if you wonder why we've changed the order of the presentations, it is simply because my presentation seems to be the most general, So it will set the general scene for more concrete contributions by my two colleagues who have kindly agreed to this change. And I'm really very honored to be on this panel together with them and with Thomas. The rule of law checklist, which was adopted by the Venice Commission in 2016, refers to corruption in 57 different places. Corruption, together with conflict of interest, is singled out in this rule of law checklist as one of the particular challenges to the rule of law, which, and here I quote, undermines the very foundations of the rule of law, unquote. I fully share this assessment, and in my presentation, I would like to argue that indeed corruption is even the very antithesis of the rule of law, but that at the same time, ensuring and promoting the rule of law is one of the best guarantees against corruption. These arguments are not new, they are not original, but I think sometimes it's good to go back to some of the basic truth and to recall them. In my presentation, I will proceed in 3 steps. In the first one, I will briefly introduce the concept of corruption as well as the legal framework applicable to it under international law. I'm an international lawyer by education and by profession. Also an imposter syndrome here a bit. In my second step, I will then show how corruption has a detrimental effect on the state of the rule of law in specific countries, but also more globally. And then finally, in the third step, I will recall some measures that should be put in place by states to counter corruptions, and I will also argue that ensuring the rule of law is one of the best measures to counter corruption. So let's start with the first part. Let's move to the concept of corruption and to the international legal framework. By now, as I think you all know, several binding international legal instruments have been adopted to counter corruption. They include especially the 1996 Inter-American Convention Against Corruption. Here, the American continent was the very first one to set the example. Then the 2 1999 conventions adopted within the Council of Europe, the Civil Law Convention on Corruption and the Criminal Law Convention on Corruption. And finally, the 2003 United Nations Convention Against Corruption. These instruments, even if adopted in different frameworks, are actually very similar in the obligations they impose on states. They are the typical criminal law cooperation agreements, so they oblige states to adopt measures to prevent corruption. They also oblige them to make corruption into a criminal offense under domestic law, to prosecute those engaged in corruption, and to compensate victims. They also, to a large extent, agree on what corruption is, on the definition of corruption. So I'll quote here Article 2 of the Council of Europe Civil Law Convention, but the definition is similar under the other instruments as well. So Article 2 indicates that corruption is, and here I quote again, requesting, offering, giving, or accepting a bribe or any other undue advantage or prospect thereof, which distorts the proper performance of any duty or behavior required of the recipient of the bribe, the undue advantage, or of the prospect thereof. The World Bank suggests a much more concise definition of corruption, suggesting that corruption stands for, I think one of the last quotes, the abuse of public office for a private gain. And indeed, even if corruption may also hit private sector, the typical scheme of corruption is a public official departing from the established rules and making a special favor to some person or persons in exchange for a bribe or another advantage provided by that person to the public official. So we have the two persons both engaged in corruption. We have on the one hand some benefit, some material or other gain, and on the other hand some distortion of rules in exchange for this benefit. Finally, all the international law instruments agree that corruption represents a major threat to the rule of law, democracy, and human rights, and this is explicitly indicated in all the 4 instruments. And that brings me to the second part of my presentation, where I want to demonstrate that corruption goes against the rule of law, in fact, against all the 6 elements of the rule of law. As the distinguished audience will certainly remember, There are the 6 elements identified in the 2016 checklist on the rule of law adopted by the Venice Commission. That means the legality, legal certainty, prevention of misuse, then equality or prohibition of non-discrimination, 2 sides of the same coin, access to justice, and fair trial. Now, in a model rule of law country, in a country where corruption is not a serious problem, public officials act on the basis of legal rules and within limits set by these rules. They apply these rules in a non-arbitrary manner and without discrimination. Individuals who have some ideas or believe that public officials did not treat them necessarily in a fair and lawful way may then turn to impartial and independent courts, which then decide based again on legal rules and within the limits set by these rules. This is the ideal situation. This is a situation of a country where you have the rule of law guarantees put in place and when corruption is not a serious problem. If, however, the public officials taking the original decision or the judges considering the case later on are corrupted, the scheme looks very differently. So the public officials do not decide then on the basis of legal rules. They depart from these rules, they bend these rules to grant the request, whatever this request is, of the person offering a bribe or another advantage, just departing from the principle of legality, because they don't decide any longer on the basis of rules, but on the basis of personal preferences, of the needs of special persons. That also brings in uncertainty and unpredictability into the decision-making, because the main factor, as I've just mentioned, is no longer the rules, but the needs, the wishes, the preferences of specific persons. That goes against the principle of legal certainty. Moreover, the rules are applied differently depending on these rules and preferences of certain people, which means that there will be arbitrariness, misuse of the position, and unequal treatment, not in compliance with the principle of equality. If, moreover, courts are also corrupted, then there is no chance that legality would be restored through judicial means. We would encounter the same arbitrariness here as well at the judicial level, with judges deciding in light of narrow personal interests rather than in light of general legal rules. There will be also no fair trial, and the very access to courts will be merely formal and fictional rather than real and effective. So you have the distortion of all the 6 elements of the rule of law as identified by the Venice Commission. There is probably no country without some level of corruption. That would be a utopia. But the level is quite different. And in some countries, we might have a minor level of corruption, isolated incidents. But in some countries of the world, corruption is even a systemic and endemic problem. According to the estimates, corruption costs in the whole world more than $2.6 trillion a year, which amounts to more than 5% of the global GDP. This sum would be sufficient to lift more than 1 billion of people living on less than $1.25 a day above the poverty threshold and keep them above this threshold for at least 6 years. Corruption, and that was already mentioned by Thomas, increases the gap between the poor and the middle class on the one hand and the wealthy groups in the society, granting the latter, the rich ones, disproportionate access to goods and services that should be available to everyone. There is also, as a minimum, a correlation, if not a causation, between corruption and a low standard of the protection of human rights and democracy. Furthermore, and these are just examples, I mean, we could go on and on. So furthermore, research has established that the presence of a high level of corruption significantly hinders the inflow of foreign direct investment to countries. Corruption, and that's one of the most important elements, also very seriously undermines public trust in the institutions and the readiness of people living in the country to support the system, and even, and we see it in some war-torn countries, even in my part of Europe, Central and Eastern Europe, the readiness to defend the country, because if you think you don't own the country, you are not very willing to die for it. So corruption is a serious problem. It has detrimental effects at the national level, but also more globally. The diagnosis is clear, and as I said, we could go on and on. So what to do about it? And that brings me to the very last part of my presentation. The international instruments that I quoted at the beginning, the UN American, the European ones, have some recommendations in this respect, which are obviously obligations for the state parties, and which encompass, and I already mentioned some of them, for instance, the obligations for states to criminalize bribery, to prosecute those engaged in it, to compensate victims, or, for instance, to introduce a code of conduct for public officials. These are very specific obligations. At the same time, we find there certain obligations, certain measures to be suggested, which are not specific or specified in the instruments. For instance, the famous prevention of corruption. This is always indicated as one of the most important issues, but it's rarely defined what it exactly means preventing, or how should it be done. And here I think the Venice Commission and its outputs, both in individual opinions, for instance, those issued with respect to Albania, Georgia, North Macedonia, or Ukraine, but also more general studies, especially the rule of law report and the rule of law checklist, can be of great use because they help specify some of the measures that could fall under the prevention of corruption. So for instance, just to give you some ideas, in the rule of law checklist, we find these specific measures to be declared. For instance, the obligation for public officials, including judges and prosecutors, to submit declarations of assets, or the need to ensure that people in certain positions have sufficient remuneration, though obviously the question is whether this really helps or whether the bribes just become higher. There are always double sides of many issues. Then, for instance, introducing restrictions on gifts and other benefits, having transparent rules on public procurement, establishing special anti-corruption bodies, and we've seen those appear, for instance, in Moldova or in Ukraine, and I'm sure my colleagues will go in more details on that. So this is one element that I think where the rule of law really closely meets the concept of corruption. So far, I've mainly spoken about legal obligations, institutional issues, but as in other areas, it's clear that legal and institutional measures in themselves are not enough. First of all, they need to be put in place. Obviously, it's not enough to have good laws. It's also important to have these laws put in practice. But it's important to keep in mind that corruption is also a cultural phenomenon and a social phenomenon. The extent to which corruption is tolerated and what is in fact considered as corruption in different societies is quite different. It differs in times and in space. And research has established that corruption can actually become socially acceptable and accepted, especially in context where this is the only way, going through corruption is the only way to get around the shortcomings of the system and to secure access to important goods and services. In other words, corruption is the most likely to flourish in countries where resources are scarce on the one hand, so it's one element, and on the other hand, where you do not have very clear, equal and fair rules on the distributions of these different resources. That means where the rule of law is actually not sufficiently ensured. That also suggests that the most important factors to eradicate or minimize corruption in the long run are, on the one hand, some economic or some decent level of economic prosperity, on the one hand, making it possible for as many members of the society to have access to important goods and services, and on the other hand, clear, fair, well-known, and equal rules on the distribution of such goods and services. That means to have the rule of law in place also in this domain. To conclude, while the rule of law becomes very often one of the very first victims of corruption, it's also one of the most important tools to counter corruption. Thank you very much for your attention, and I'm looking forward to the discussion.
Thank you very much, Veronica, also for keeping us in the timetable. Now, please join me in welcoming the next speaker. This is Renata Deskoska, who is member of the Venice Commission in respect of North Macedonia. She is also professor of constitutional law at the University of Skopje. And she was also, among others, Minister of Justice in the Republic of North Macedonia, as well as Vice Chair of the Parliament of that same country. Please, Renata.
Ladies and gentlemen, esteemed colleagues, it's an honor to address you today on the topic that remains at the heart of governance, democracy, and justice, the interplay between corruption and the rule of law, and the fight against corruption. North Macedonia provides a particularly compelling case illustrating how reforms that were evaluated positively as in line with international standards failed after a certain period of time. Corruption is not merely an issue of individual misconduct, but a systematic problem in North Macedonia. It is manifestation of a broader bad governance in public institutions because it undermines accountability, impartiality, and integrity of public institutions. Anti-corruption efforts as part of reinforcing the rule of law do not rest on a single definitive solution. Instead of that, they require structural reforms that strengthen democratic institutions, safeguard judicial independence, and promote transparency in decision-making. The fight against corruption is not just about punishing wrongdoers, it's about reinforcing the foundations of democracy, restoring trust in governance, and ensuring that the rule of law prevails over the rule of self-interest. Robert Hislop in 2002 wrote, "Every country has a mafia, but only in Macedonia does the mafia have a country." In part, I agree with his statement, but in other part, I do not. I agree that in Macedonia, the mafia has a country. But I do not agree that only in Macedonia mafia has a country, because I know that there are some other examples in other countries. Unfortunately, not much has changed since 2002 when he wrote this sentence. Macedonia was the only country to peacefully break away from socialist Yugoslavia, and our president at that time called us oasis of peace. And how from oasis of peace we turned into oasis of corruption and crime, it's a sad story. In 2015, the opposition started a series of press conferences called Truth for Macedonia, on which audio recordings from illegal interception of communications were released. The content of many recordings provided indication of unlawful activities and abuse of power by senior government officials. As a part of political agreement for overcoming political crisis, the Special Prosecutor Office was established. I'll call it SPO to be shorter. The SPO had competencies to investigate high-level corruption cases revealed through illegally wiretaped conversation. The creation of this institution was initially seen as a major step forward, providing financial autonomy, broad competencies, and strong mandate. The SPO was established as temporary institution with 5-year mandate, extendable annually by 2/3 majority in the parliament. The special public prosecutor was nominated by the parliament with 2/3 qualified majority and required the prior consent of the 4 major political parties before she was appointed by the Council of Public Prosecutor. So it functioned independently and as autonomous prosecution office with the judicial system, separate from the public prosecutor office. She had full autonomy in investigating and prosecuting crimes with her jurisdiction. She didn't receive any directives from other prosecution office. No prosecutor had authority to influence the work of SPO related with the case. And also the special public prosecutor was not even required to attend staff meetings with the chief public prosecutor in order not to be influenced. And there was also no possibility for external review. So it functioned completely outside of the established structure. When it was established, it became the country's leading anti-corruption institution, and its work was considered as important contribution to the fight against high-level corruption. The law guaranteed financial autonomy and stability of the SPO. SPO was submitting financial plan to the Ministry of Finance, and the Ministry of Finance was obliged to accept that, so it was no problem with providing money. So I can give you just one figure that their budget was increasing each year. In 2019, it has 3.7 million euros. And if you compare it with the 13 million euros for all other prosecutorial system, that was substantial part. So SPO became a symbol of resistance and hope for justice in North Macedonia. The street in front of the buildings of the SPO were a gathering place for the people who were protesting as members of colorful revolution. Many of the protesters were wearing T-shirts with the faces of the prosecutor and her assistants, and they are protesting under the parole, no justice, no peace. BBC even called the prosecutor and her two assistants Charlie's Angels, and there was a story on BBC, and we were all proud about that. So SPO's strong autonomy, well-researched budget, and dedicated team of investigators, which was also novelty in our system, allowed it to operate efficiently, bypassing traditional institutional obstacles. However, this very institution, SPO, tasked with rooting our corruption, became engaged in a scandal when the head of this office, the special public prosecutor, was caught in corruption. Connected with the case that she was leading, one of the oligarchs in our country. After that case, she was dismissed by the parliament and also by the prosecutorial council, and was convicted to 7-year imprisonment in so-called rocket case. So despite the promising start, the bribery case and misuse of office by a special public prosecutor, along with the political resistance, actually leaded that this institution will not exist anymore in our country. So we now do not have special public prosecutor, because the legacy that remains from this institution was a testament to both the possibility and the challenge to establish efficient institution of independent prosecution in Macedonia. We tried, but we have not succeeded. This case illustrates that strong institutions alone are insufficient without integrity and effective oversight. While legal framework and enforcement agencies are essential, they must be accompanied by genuine political will and mechanisms to prevent abuse. The second example of our fight against corruption is the establishment of the State Commission for Prevention of Corruption. The law for anti-corruption was adopted in 2018, while I was the Minister of Justice, and the new commission was appointed in February 2019. We provided in the law the process of selection of the members of the Anti-Corruption Commission that involved members of the political parties, ruling political parties, and members of the opposition, a specialized NGO to participate in the process of selection, representatives from the Ombudsman Office, Journalists Association, and from the Academy of Science in Macedonia. Interviews with the candidate who applied for members and president for Anti-Corruption Commission were broadcasted on the parliamentary channel, and there was really transparent procedure. After that, when the Commission for Anti-Discrimination was supposed to be drafted in the law, many of the ministers said, no, we are not accepting Deskoskas proposal because it is difficult to manipulate with this procedure. But after 5 years, they learned how to do that. So Anti-Corruption Commission, in his first mandate, we introduced also the prohibition that the persons who were active members of the parliament, former government official, or individuals who were donors of political parties within the last 10 years could not apply for members or president of the Anti-Corruption Commission. Also, we increased the time of experience needed in order to apply for a membership. Anti-Corruption Commission had serious competencies. They had access to the databases of many institutions. All people who were under competence of Anti-Corruption Commission signed the statement that they allow Anti-Corruption Commission to enter in their bank accounts, so they had really strong competencies to make the oversight. And first commission was really positively evaluated in the progress reports of European Commission in Macedonia because they had resolved over 2,040 cases. They also submitted initiatives for criminal proceedings, 59 initiatives for determining the responsibility of high official, so it really had effect. But at the end of 2023, the new commission was elected. However, this time, political parties has learned and manipulated the selection procedure. So they made agreement that they will give low points to those who are really good candidates, and they will give high points to those who are their favorite candidates. And as a result, there was obvious, because this scoring is public, it was very obvious when you see that those who received the highest points from the NGO sector, they had actually lowest scores from the political parties. The members of the selecting committee from NGOs criticized the selection process, that it was the scoring process, that it was manipulated, and that there was a political deal between political parties how to share the places. So after 1 year of the new Commission for Anti-Corruption, it is criticized by that it's invisible, it lacks a proactivity, and also it's not independent in several cases. That is actually another example of how political will can undermine even good, positively evaluated legal text that was evaluated as a legal text that is in line with European standards. Another field in which the efforts to strengthen the fight against corruption were made is the judiciary. Judicial institutions are essential for combating corruption, yet corruption also weakens judicial institutions. In the context of judicial reforms in North Macedonia, the Venice Commission recommendation on judicial independence and the role of judicial councils have been highly influential. The relevant Venice Commission recommendation concerning the discipline and dismissal system of judges and position of the Judicial Council were fully addressed, and it was recognized in the Venice Commission opinions from 2019 And also, I received a letter from the Secretariat at the time that each recommendation is implemented. So we didn't left any comma from the report opinions of any commission that was not implemented in the law on Judicial Council. And besides fulfillment of all recommendations for changes of the legal frame, guaranteeing independence of judiciary, a survey by the International Republican Institute conducted in May 2023 revealed that only 1% of the citizens have complete trust in the judiciary. And 18% have partial trust of the judiciary, which means that over 80% do not trust at all to our judicial justice system. This highlights the profound complexity of achieving judicial independence. Despite the implementation of numerous recommendations and reforms, the independence of the judiciary still appears to be a lost battle. The reforms need to be backed by strong commitment to genuine cultural and institutional change. Without addressing underlying political culture and entrenched practices, reforms may not be fully effective. Even if formal independence exists on paper, lack of trust and public perception of politicization, as indicated by low public confidence in the judiciary, suggests that the practical application of reforms is not effective. But it is always easier to change the law instead of changing the behavior. In an attempt to create the illusion of fight against corruption, the government asked and received through tags new opinion by peer review mission on functioning of the judicial councils of North Macedonia. This opinion contains 40 recommendations on the law on judicial council that was already positively evaluated by the Venice Commission. And now we are going to change the law because it is easier to change the law than to implement it. The European Commission in the progress report noted that implementing planned reform is a long process and requires continuous change in behavior, and after that send peer review mission that recommend new legislative changes. The fight against corruption in North Macedonia, like in many countries, depends on a comprehensive approach that not only involves institutional changes, but also requires a shift of political culture and active participation from both civil society and media. The country's ongoing struggle with corruption revealed that true reform cannot be achieved solely through external recommendation, but must be rooted in local ownership and political will. In addition to independent judiciary and anti-corruption body, other essential pillars of anti-corruption in North Macedonia is the need for free and independent media landscape and free civil society. Investigative journalism plays a crucial role in exposing corruptive practices, holding public officials accountable, and informing the public about governance failures. Between 2008 and 2017, Macedonia experienced a period of populist rule marked by systematic erosion of freedom of speech. The government used surveillance, intimidation, legal harassment to control the media and suppress dissent, creating an environment of fear that led to widespread self-censorship. Defamation suits were also strategically employed to silence journalists, especially those exposing government corruption, and these legal battles discouraged investigative journalism. These measures undermined democracy, eroded checks and balances, and reduced public accountability, contributing to North Macedonia's lowest ranking on Reporters Without Borders Index in 2014. We were on 123rd place. However, after 2017, significant improvement led to rise in our ranking, reaching 36th place in 2024, similar to our status before 2007, before populist authoritarian practices took hold. Another important issue for us is EU membership, which served as a strong external incentive for North Macedonia to adopt anti-corruption measures, encouraging the country to align our governance practices with EU standards. However, the Bulgarian veto on opening EU accession negotiation in 2020 led to significant disappointment within North Macedonia. This veto not only hindered our EU integration processes, but also damped the enthusiasm for further reforms. The setback created a sense of disillusionment as the EU's commitment to the region appeared uncertain, and this affected the momentum for tackling corruption and strengthening democratic institutions. This is another example that effectiveness of EU-driven reforms depends on local ownership and commitment. While external pressure can initiate reform, lasting change must be rooted in domestic priorities and implementing through homegrown strategies. To conclude, the fight against corruption is not only a matter of legal framework, but also of political will. A strong, supportive political culture is essential to ensure that reforms are respected in practice. Breaking the circle of corruption requires more than legal reforms. It demands political will, strong institutions, and shift in social attitudes. Accountability mechanism must be reinforced to ensure that corrupt actors face real consequences, while public trust in democratic institutions need to be restored through transparent and consistent enforcement of anti-corruption measures. Without genuine political commitment and structural reforms, North Macedonia risks remaining trapped in the cycle where corruption is both a cause and consequence of its political instability. Thank you very much, and I'm sorry that I overstepped the time.
Thank you. It's my great pleasure to introduce our third speaker in this panel, Mr. Kerimi, who is member of the Venice Commission in respect of Kosovo, and he is also chair of the subcommission of the Venice Commission on the protection of national minorities. He is professor at the Faculty of Law of the University of Pristina, where he was, to my knowledge, also rector just a while ago. Please, Kerim.
Thank you. Mr. Chair, distinguished colleagues and esteemed panelists, I am both pleased and privileged to be part of this distinguished panel and be able to address you for the next 15 minutes, or at the chair's mercy, slightly longer. I feel I should begin with a brief preliminary remark disclosing the underlying philosophy of my presentation, of how and why I came to choose the topic I did and frame it the way I will present. It would pose no challenge to any imagination to say that I created and recreated several versions and have all sorts of different drafts with different names and different contents and scope of focus before I settled somehow. I had to go far back to history in my quest of searching for a proper theme. The massive historical record of corrupt behavior, as you can imagine, wasn't entirely helpful, at times complicating my quest, perhaps a perfect function of history. But let me share with you one useful passage from a 300 BC treatise written by a chief minister to the king in ancient India, which I quote: "The king shall protect trade routes from harassment by courtiers, state officials, thieves, and frontier guards. And frontier officers shall make good what is lost. just as it is impossible not to taste honey or poison that one may find at the tip of one's tongue, so it is impossible for one dealing with government funds not to taste at least a little bit of the king's wealth, end of quote. So this citation attests to the ancient nature of corruption, which, same as today, amounts to the abuse of entrusted power or public office for private gains. But even more so, it illustrates the central, and if you wish so, supreme role of institutions in controlling corrupt behavior. Something along the line of Douglas North's proposition that institutions matter most, a proposition as valid today as it has ever been. I wouldn't probably say anything novel if I state that corruption is an enduring challenge that undermines democracy, weakens institutions, and erodes public trust. What is more of an intrigue is that the role of specialized anti-corruption institutions, a relatively neglected theme, is crucial in upholding the rule of law and ensuring effective governance. So to spell out the main thrust or objective of my presentation, I will focus on the Venice Commission's contribution in shaping the principles that govern the foundation, design, and operation of specialized anti-corruption bodies. And in doing so, I seek to portray the process through which the Venice Commission constructs an institutional edifice of prime importance by relying on the fundamental precepts of the rule of law. There is only one more dimension that I seek to address, and that concerns the fundamental question of the sources of law the Venice Commission relies upon in setting the standards, including its own determinations in shaping both the sources and the standards emerging thereof. In terms of method, I seek to achieve the intended objective by exploring numerous opinions that address country-specific corruption challenges of varying magnitude, particularly those opinions concerning targeted legislative initiatives aimed at preventing and combating corruption. I have been able to identify at least 10 such specific opinions on countries ranging from Albania to Ukraine, Georgia to Montenegro and Moldova, and so on. I should also note in this connection that the Venice Commission has engaged with corruption-related issues in at least 2 other significant contexts, namely in the context of 1, the vetting of judges and prosecutors, including political vetting, and 2, in the context of seeking to curb corruption through the so-called anti-oligarch laws. Both of these initiatives, charged with complex institutional and political questions, haven't been lightly embraced, if at all supported by the Commission, in turn displaying its preference for increasing and strengthening the capacities and independence of existing structures of authority, including specialized anti-corruption institutions. Now, on the substance, namely the rule of law principles governing these specialized anti-corruption institutions, the Venice Commission has identified the core rule of law parameters central to the structure and operation of specialized anti-corruption bodies, such as A, institutional independence, B, well-defined mandates and powers, C, accountability mechanisms to prevent abuse of power, and then another important consideration concerning the protection of whistleblowers. Beginning with institutional independence, the basic premise is that an anti-corruption body must operate free from political or other influence to function effectively. As far as the Venice Commission's approach is, in its 2023 opinion on Georgia, the Commission found that giving the Prime Minister control over the appointment and dismissal of the head of the Anti-Corruption Bureau compromised its independence. So the Commission's best practice recommendation was that the appointment should require cross-party parliamentary approval with an appropriate anti-deadlock mechanism. Additionally, the Commission has recommended that the head of an anti-corruption body should have immunity for official actions, namely no prosecution in respect of activities and words spoken and written when carried out in the official capacity, in order to prevent undue pressure and preserve the independence of the institution. B, with regard to clear mandates and adequate powers, the understanding is that without well-defined responsibilities and sufficient authority, the anti-corruption bodies cannot combat corruption effectively. So now the Venice Commission's approach. In its 2024 opinion on the draft law on the prevention of corruption of Montenegro, the Commission observed that the anti-corruption agency's capacity of verification of the asset and income declarations was hampered by lack of access to data from banks and other financial institutions. In the absence of an anti-corruption body's power to request and to receive information from the private financial institutions and companies in general about the assets of public officials, the whole mechanism of asset declarations may become superfluous and devoid of meaning, as it would become too easy to hide or misrepresent the true state of assets and income. And so the best practice recommendation from the Commission was that anti-corruption bodies should have the power to access financial data from banks and companies to verify asset declarations of public officials. Now, when it comes to accountability and transparency to prevent abuse of power, the logic is that anti-corruption bodies must be independent but accountable, ensuring that they are not misused for political or other purposes. The Venice Commission's approach was, among others, as follows. Both in its 2014 and 2024 opinions on Montenegro, the Commission stressed the need for judicial oversight of anti-corruption bodies when entrusted with law enforcement functions or prosecutorial decisions. In its 2023 opinion on Georgia, the Commission criticized the so-called triple accountability model, where the Anti-Corruption Bureau was answerable to Parliament, the Anti-Corruption Council, and the Prime Minister. Instead, accountability should be streamlined and be essentially limited to the Parliament. Now, the protection of whistleblowers is another critical element in the institutional equation, as without proper protection, whistleblowers face retaliation, deterring them from reporting corruption. Now, on Venice Commission's approach, in its 2024 opinion on Montenegro's draft law on the prevention of corruption, the Commission recommended extending whistleblower protections to all threats to public interest, not just those linked strictly to corruption. The Commission also recommended that whistleblowers should have access to interim protective measures before court proceedings, and employers should be prohibited from penalizing whistleblowers, and compensation for retaliation should be automatic and proactive. Now, finally, about the sources of standards for addressing corruption, the Venice Commission has based its recommendations on a mix of international legal instruments and other international standards, including, obviously, its own best practices. I won't name those instruments, as those were already covered by Veronica, but I'll be focusing briefly on the Venice Commission's own standard setting. So faced with concrete legislative proposals or solutions, and absent any international standard or hard source of law, the Venice Commission has filled legal gaps by developing its best practice models. For instance, in its 2024 opinion on Montenegro, the Commission notes the absence of international standards on the scope of public officials who should be required to submit asset and income declarations. It questioned, indeed, the proposition that such a requirement could be justified on the basis of legitimate public interest for any public official, irrespective of their financial situation or the decision-making powers, and so therefore it recommended that only those with decision-making power be required to declare their assets publicly. In its 2023 opinion on Georgia, the Commission dealt with a curious legislative case presented by Georgia's law on the fight against corruption concerning the Anti-Corruption Bureau. The law required that a select number of high-ranking officials, including the President, members of the Parliament, and members of the government, to undergo a drug test within a time limit defined by the head of the Bureau, the results of which will subsequently be made public on the website of the Bureau. The Commission questioned the clarity and foreseeability of this legal provision, noting that it failed to specify the legitimate aim pursued, and with regard to the question of necessity in a democratic society, it expressed concerns as to the fact that the results of this drug test are made public. Ultimately, it concluded that the provisions on mandatory drug testing of officials be removed altogether from the law. And then again, Montenegro 2024 opinion, another example of a best practice determination by the Venice Commission can be found there with regard to the requirements to be elected as member to the Anti-Corruption Council, as well as the eligibility requirements for the director of the Agency for the Prevention of Corruption. In both cases, the Commission recommended to exclude persons who have been convicted for corruption-related offenses from being eligible for membership of the Council or for being eligible to become director of the agency, and to add integrity criteria to the eligibility requirements. And now conclusions. The Commission's work is pivotal in shaping transnational anti-corruption standards by applying rule of law principles to real-world corruption-related cases. While it draws from international conventions and best practice, it also defines new standards where existing laws are either ambiguous or absent. So the fundamental task that now remains is ensuring that its recommendations are effectively implemented, strengthening both the independence and accountability of anti-corruption institutions in pursuit of the common global goal of combating and controlling corruption effectively. And so my final remark would be thank you all very much.
Thank you very much, Karim. And thank you all for all these excellent presentations, thought-provoking presentations. Now we have 20 minutes for this discussion and dialogue, and I invite you to pose questions or make comments, but if you do so, please be concise and short, because time flies and clock ticks. So, please.
Yes, good afternoon already. Thank you for your presentation. My name is Carlos Ayala, current president of the International Commission of Juries. So I have a question, maybe if the three of you can comment, but especially Veronica, who made a presentation closer to what I'm asking, and Renata as well. Is the importance of fighting corruption, upholding the standards of the rule of law, and specifically due process of law. We've seen several examples where judges themselves have been harassed. Judges themselves, under the excuse that they are being prosecuted for corruptions, have sent, let's say, an alarming signal, a red notice to the rest of the judges that any of them can be arbitrarily prosecuted, persecuted, based on corruption without the basic guarantees of the rule of law. This is without to say that, of course, I believe in the importance of the responsibility of judges. I believe in the importance of fighting corruption within the judiciary, but a very alarming signs in several countries around the world is how to dismantle the independence of judges with the excuse of fighting against corruption without respecting the basic due process guarantees. Thank you very much.
Thank you. Anyone else? No, there is one. Angelique.
Yeah, if there is nobody, if there is nobody, I dare to ask another question. We we're talking about political will, and the other factor for corruption is culture. We all know, and when you look at these lists of countries, the most corrupt and the least corrupt, you also see different cultures. You see the religious relation, which countries are up and which countries are down. And I think there is also one factor that I find most interesting of giving presents. If you have in a culture some sort of tradition to give big presents and to be nice and to be kind and not to get anything in return, it makes more easily acceptable in corruption situations, thus giving something for the other. And it seems to me that in cultures where you are quite restrictive, you don't easily give presents, you observe that people are less inclined to accept something like corruptions. So I wonder, I think this is a soft factor, but for me it's an obvious factor. Actually, just to say something funny, in the first Ukrainian constitution, which was made outside Ukraine because Ukraine was just under occupation, they had a clause not to make too big presents to foreigners. So just to tell you that, I think that's the only constitution where you have such a clause. But I think there is something in it, this tradition to give and to be kind, and then to accept more easily corruption. And what can you do against something culturally very deep in a situation? Thank you.
Thank you. So perhaps we should start in a reverse order so that Kerim is first and then Renata and Veronique.
All right, so I'll begin with the last intervention, perhaps. I think you're right, Angelica. It's a deeply cultural thing, and so in many ways, in certain societies, giving a present is conceived as an act of kindness, an entirely sort of conceivable activity. And now what to do and how to change that, I'm not sure there is a simple, single, fixed solution, but for instance, in the practice of many countries, the country of my origin included, for instance, the institutions are paying more attention to the question of giving presents, and the demand that all those public officials that have to submit their income and asset declarations also declare the presence. And so this has obviously triggered some degree of social dialogue, and hopefully this will as well serve the other purpose of awareness raising, and so people perhaps in the process will be more reluctant to give and take, understanding that they have to make these public. And so if this proposition is valid, I'm afraid we have to wait for a longer period of time to see the effects of this practice.
Thank you very much for the questions. They are really challenging. The question about corruption in judiciary and the problems how to deal with this is one of the actually hottest questions in Macedonia, because our example shows that you can do all legislative changes, all reforms, you can make the legal system completely in line with the highest standards, and still there will be problems with the judiciary. And in my opinion, with strong public prosecution office, which should be independent from the political powers, there will be no problems for politicization in the process of criminal responsibility of the judiciary. there are cases in some of the countries we have studied in Venice Commission where the public prosecutor is under the Minister of Justice, or even we have seen in some cases the Minister of Interior is also involved in the processes, and there is some kind of hierarchy. So I think that together with independent judiciary, it is also important to have independent prosecution service in order to avoid politicization. So that could be one of the ways. The question about the presence and the culture of presence, it's something that can be solved by changing the legislation and also building the public awareness of its forbiddenness. For me, for example, when in our country, we have strict rules that you have to disclose the presence and you have to inform state anti-corruption commission about that, and institutions are doing, but it concerns about the small presence because there is a limit. What about the, for me, bigger problem is extortion or racket that is done by the institution when there is a cashback from the public procurement procedures, and that's not the present. That is something that actually officials are demanding from persons that are getting some jobs from some public enterprise or some public institution, and that is actually the higher problem with the corruption. When I was in one of the trips from Venice Commission, and in a country with such kind of a tradition of giving presents, and when I take it the present, I wrote to Simona what to do. Is there a procedure to declare it? Is there a procedure to bring it in Venice or what? So it can be easily regulated, and in our country there is awareness about that, but other problems are more serious and create bigger pressure on the system.
Thank you for the questions. I'll start with Angelica's question because in a way it's one of the most important ones. How do you change the culture? And it's indeed true that when you have a very corrupted country, then corruption is at all the levels. It's not only about politicians or about certain layers in the society, it's about everyone. Just if you are small and not so rich, you give small presents. If you are big and rich, you provide and get bigger bribes, bigger presents. So it's really a cultural phenomenon. And it's difficult to fight with it for at least two reasons. On the one hand, because it's culturally accepted. It's seen as something that is normal, that is even correct, because it has always been like that. And on the other hand, so it's one element. And on the other hand, it's very difficult not to do it on the personal level, because if you don't do it and everyone else does, you lose. If they provide gifts to doctors and I don't, I will not get the treatment, they will get the treatment. So it's my interest not to kind of depart from the usual practice. So you need, in my opinion, to kind of challenge or contest, attack these two elements at the same time. So on the one hand, the mental element, to show that in the end, if we have corruption, we all lose. Because if you count it as a whole, if you see the distortions it brings to the society, we all lose in the end. And smaller you are, more you lose, because obviously there will be someone richer who will pay more and who will get more. So just to persuade people that in the end, it is not really convenient for the society, changing this mental element. And the second one, try to stop it at the same time, because as I said, it can't work on the personal level. How to do it, I have no idea. If I did, I think I would get the Nobel Prize, which I don't think is really coming. So that's for this question. Then for the other question, that's another very important issue, which is not limited to corruption, but which is more broad, because we have many of these, let's say, good moves, like fight against corruption, fight against terrorism, fight to ensure transparency. All these are positive moves, but they can easily be misused by someone who just wants to use these nice labels to just get rid maybe of some people. And we need to be very cautious because it's not easy to see the lines. One issue which stands in the way and which ensures some limits to to the risk is obviously the rule of law standards, because even if you fight against corruption, terrorism, to ensure transparency and whatever else, you need to play by the rules. You can't depart from the rules even for the noble cause. And now this obviously brings the question that currently we are discussing in the context of many countries, and I think our colleague from Poland might discuss it in his presentation, and that's how do you actually, when you have, for instance, a period of the rule of law backsliding, how do you restore the rule of law without at the same time violating some of the guarantees of the rule of law? Is it truly possible that you can always play by the rules? And can you really make a distinction between breaking the rules for the good thing or for the good cause and breaking the rules for the bad cause? And who will then decide what the good and the bad thing is? And again, I'll end up with a question to which I don't know the answer. That's it.
All right, one more question or comment, please.
Hi, I'm Kim Shepley from the United States, and a friend of the Venice Commission, even though there may be some rumors to the contrary. And so here's a question that actually unites panel 1 and panel 2, which is that the Venice Commission in its reports has typically confined itself to looking at individual laws and individual decisions, when occasionally, as I'm sure the Venice Commission members know, there's a broader context that gives meaning to these rules. So I'm thinking of the case, for example, in Ukraine, where when I guess President Zelensky first came in, he came in on the grounds of eliminating corruption, set up a very ambitious anti-corruption system. There were many issues with that system that I think those of us who worry about constitutional principles might have criticized. But of course, the constitutionality of the anti-corruption system came before the Constitutional Court at a time when the Corruption Commission suggested that a number of members of the Constitutional Tribunal were themselves under investigation for corruption, and suggested that those members recuse. Those members did not. Those members found that the anti-corruption system was unconstitutional. And then that decision came to the Venice Commission for assessment. And the Venice Commission assessment was, I think, a very complicated case, but the bottom line was the government must always follow decisions of the Constitutional Court. So this is where I wonder, the broader question is, what's within the Venice Commission's purview and what's not? So on one hand, the argument that government must always follow decisions of the Constitutional Court is an absolutely correct decision under normal times. But if you have a problem of corruption that was exactly at issue in the case, both because some of the justices were accused and also because they were assessing the system under which they were accused, I'm wondering whether it really made sense to think of that opinion without the context. And so this goes to the question of how much context should the Venice Commission take into account where there are allegations of corruption in the very system that the Venice Commission is asked to assess.
Do you wish to? Yes, please.
In my view of the work of Venice Commission till now is that always, in all opinions, Venice Commission is taking care of the context. And you can see in several opinions that it is actually stressed that maybe this is not in line with the standards, but in the given context, it functions and upholds the rule of law. So I think that till now we can be all satisfied with the complexity of the opinions, taking care of all details. And there were some, I heard even some of the colleagues complaining that, well, sometimes the opinions on Eastern Europe are different from the opinions from Western Europe in some lines, but the context. For example, there was opinion on judiciary in Netherlands. If you see it as standards, the involvement of the political bodies in some processes of appointment of judges that function in Netherlands, excellent. They have percent of over 60–70% confidence in the independence of the judiciary. Macedonia, for example, is a picture how international standards should be looked in the law. and we have 1% of the confidence. So the context is important, and Venice Commission, when we are giving a recommendation, we really take care of that.
Very quickly about the context, and I don't think I'll be able to discover something other than what my colleague already indicated. So context is critical for anything, so also for sort of our wider academic enterprises. So there is a problem, and then we go after. And then context might be highlighted more perhaps in the work and operations of the Venice Commission, also because of its very procedure and the sort of attention it pays through its method of fact-finding in-country visits, which are very useful at times. And so the context oftentimes is portrayed on the basis of, the interlocutors that are consulted, and the Commission constantly makes sure to have as comprehensive an approach as possible when it comes to its fact-finding operations. And I think these are naturally reflected in the very opinions of the Commission.
Yes, thanks for the question. It will be in the same line, and I think since we are all from the Venice Commission, that's probably not surprising. There are two extremes that we can have. One is not to take the context into account as well as at all, and just to look at the situation without really taking into account what's happening. That would be what I think you described it as a legalism. I think it's pure legalism when you don't take the context into account at all. On the other hand, taking the context too much into account, that would mean getting political, because the context normally is really political. That would also mean being accused of applying double standards, or maybe multiple standards, because then you would need to treat every country in a singular way, because every country has its own context, which moreover changes over time. So then no general standards could basically, or only very general standards could be used, and then they would always need to be specified in the local context. The Venice Commission always tries to go for the middle ground. That means on the one hand, sticking to some standards which are not overly general, but at the same time taking the local context into account. Does it manage to do so in all the opinions, or in the opinions that you mentioned? That's for, I think, an ad hoc discussion, and I'm not familiar with the Ukrainian opinion, the one Ukrainian opinion you mentioned, so I don't want to comment on it. But I would say that overall, at least the opinions I've ever read and worked on over my 15 years on the Venice Commission, I would say that at least the vast majority of them have really struck the right balance between the two interests. But I think that's the role, now taking my other hat, that's the role of us as academics, to basically question whether what somebody's do is correct and engage in a discussion. And I'm very happy that we can engage in this discussion. That's it.
Unfortunately, I see that the organizers of this seminar are getting anxious, because the next item in the program is lunch break. And as former professor of European law, I can tell you that much about EU competition law, that we cannot compete successfully against the lunch break. So time to conclude this panel. I thank you very much, Kerin, Veronica, and Renate, for your excellent. Yes, and also the audience, especially those of you who dare to make comments and pose questions. Thank you. Perhaps you wish to make some.
Thank you. Just a practical announcement, please, before we break for lunch. We will start at 2:15 as foreseen in the program. You can keep your badges when you go out, so when you return, you don't have to actually give your ID, get the badge again. But please, don't lose them, don't forget them, because you saw it is important. Nice lunch. No, we go on. Yes, it's a free lunch. And
that won't constitute corrupt behavior.
Thank you.
time is it? In 5 minutes we should start. Thank you. So this one works. You don't.
So I can use this one.
Yes, you. No, do not touch. You just speak.
1, 2, 3.
Yes, close, yes, like this. Thank you. Because we have around 20 participants, online participants, and we also have the interpreters.
And those participants, they are from where? Do you know?
The participants. The participants we registered late.
Okay.
They are still very.
But they have to register in order to get into it, yes?
Yes, otherwise we did not give them the link.
Okay.
Yeah, they were.
Because someone asked me and I said, you don't need to register. They have to.
Could not fit in the room because
Of course, yeah, of course. Marta! Con piacere! Come stai?
Bene, bene.
Tutto bene?
Sì, che finalmente.
Ma tu in Bocconi in questo giorno?
Sì, si sta bene. Devi venire, ti devo invitare a.
Veramente, ascolta, io vengo in Italia in ottobre-novembre.
Ok.
Il mio nuovo libro sarà in italiano.
No.
Il mulino
Ma dai.
si chiama populismo, no, minaccia populista contro la democrazia.
Ok.
E questa è la mia.
Quella benedetta e Barbara, perfetto.
Allora, sì, stai tranquillo, amico mio. Stai tranquillo. Solo per entusiasmo grande. Was that sorry?
I hope that we're in time because
Oh yeah, yeah, it's 16 past, yeah, people are coming back. Io ho questo microfono. Scusi, what was your question?
if you need headphones, because I think
No, I know, I speak French and Italian, so I understand. Bonjour, bonjour, comment allez-vous?
Très bien, vous-même.
Très bien, merci. Tout va bien, tout va bien. Je suis maintenant à Princeton, aux États-Unis. Très intéressant et très, comment dire, difficile pour Trump.
our afternoon session. Ladies and gentlemen,
Okay, you're right, you're right, you're right. You are right.
ladies and gentlemen, I think that we can start, and your colleagues who are arriving late will join us. We have a very interesting session this afternoon, which is the challenge of rule of law-based reforms after the demolition of the judiciary. The session will be chaired by Professor Angelika Nussberger, who is a member of the Venice Commission and a member of the Executive Committee of the International Association of Constitutional Law. Our panelists will be Wojciech Sadurski, member of IACL, Amin von Bagdandi, also from, he's director of Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and Monsieur Bertrand Mathieu, member of the Venice Commission. Monaco. I would like also to make a technical announcement. We will try to make a picture all together at the beginning of the coffee break, so please don't disappear, so that we could have something to remember this very interesting event. So I give the floor to Professor Dusbecker, please.
Thank you very much, Sergey, and thank you all for being interested in our panel this afternoon. And I think indeed the topic is really one which I would call one of the hottest, the challenge of rule of law-based reforms after the demolition of judiciary. So as you see, there is no country mentioned here, but as I understand the speakers of today in the afternoon, they are probably all looking probably more or less closely to the reforms in Poland, which means Poland is an experimental case in the situation. The good thing about it is we have a country that has moved back after the demolition of the judiciary. We have no other such example. It's our unique example, and that's why we are so interested and also so thrilled to see how to do it best. So it's an experimental experience, but still I would like to have us the whole picture in mind. And for the Venice Commission, it's never one country only, but what we say should be valid for other countries as well. So we have been talking about standard setting, and we have been talking about context. How much does context mean for our standards? So this is very important also for looking at Poland. We have indeed three outstanding speakers, and I will just introduce them with books they have written, which are perhaps somehow relevant for today's topic. So we have Professor Sadurski, who has written a famous book which is called Poland's Constitutional Breakdown. So I think this is a relevant perspective for this discussion. And we have Armin von Bogdandi, who has written and co-edited a book called Transition 2.0, where before the change in Poland, together with a group of colleagues, there was a reflection, how is it possible to reform a system that has gone in the wrong direction? And Professor Bertrand Mathieu, he has written a book, Le droit contre la démocratie. So perhaps, I don't know, I have no clue what you're going to say. Avec un point interrogation que je n'ai pas prononcé. With a question mark, le droit contre la démocratie, question mark. So these are the sort of book backgrounds that I can present. What concerns us as Venice Commission, we have today this dialogue, and we said lessons learned and learning lessons, so this is our title. So we as members of the Venice Commission, many of us are academicians, but at the same time we also have a mission as the Venice Commission, and you have to see our task within this mission. So when we have our country visits, we speak to all. So we try at least to speak to all sides, all different interests, and we try to get a holistic picture of what is happening. And concerning now Poland concretely, we are, I would say, in the middle of a working process. We have adopted some opinions, and we have been called to adopt further opinions. So that is for you, I think, important to understand that we are not as free as normal academicians to debate, because we have to keep in mind that we have a specific mission as a Venice Commission in this context. So this is perhaps the introduction I would like to make. We have an experimental approach here. We will look how you see it, and we want to draw lessons from what you say, but we will not try to defend our position, but we have to keep in mind that we are expected to give advice that is valuable not only for one country, but for the general problem of restoration rule of law. And just one last sentence, it was already mentioned several times, we are working on the new rule of law checklist, and there will be a chapter just dedicated to this problem. So we want to get some best practice concerning this really difficult problem. So that is just what I wanted to say, and without further ado, I give the floor to Wojciech.
Thank you very much, Angelica. Okay, so thank you very much, Angelica. Thank you for inviting me here to the Venice Commission and the Association Internationale des Droits Constitutionnels. It's a great honor and pleasure. I'm not going to do a particularly congratulatory speech, but at the beginning I would like to congratulate Venice Commission on its 35th anniversary. And even though I will be critical in my remarks about the recent opinions of Venice Commission on Poland, I want to first say and establish my credentials as a great fan of Venice Commission, especially regarding Poland during the really dark and difficult years of 2015 until 2023. Venice Commission was one of the strongest factors affecting fight for democracy and judicial independence in Poland. And its opinions, sorry, especially 4 opinions on the judiciary. There were some other on police and public prosecutors. But the 4 opinions about the judiciary made a real difference. And here, forever, Venice Commission will be remembered alongside the European Court of Human Rights and ECJ as those external factors which supported independent judges and fight for the independence in Poland. And there were, as I said, there were 4 important opinions. The first was already in 2016. The last one was in 2020. And as a sort of encapsulation of the approach of the Venice Commission in these difficult times of the rule of law and justice, the populist authoritarian party, I would like just to cite a sentence from this 2020 judgment, opinion about the so-called muzzle law. That's how we used to call it, the law which imposed all sorts of restrictions, coercive restrictions of judges. And in its conclusive paragraph, in paragraph 60, the Venice Commission said, the amendments of December 2019, this is about this muzzle law, diminished judicial independence and put Polish judges into the impossible situation of having to face disciplinary proceedings for decisions required by the European Convention of Human Rights, the law of the European Union, and other international instruments. So you cannot put it more stronger. And as a postscriptum, I want to say that yesterday, as I was flying from Warsaw to Venice, I opened this a daily newspaper called Rzeczpospolita, a very serious Polish paper, and in its special legal pages, I found the story called "The End with the Muzzle Law." And yesterday, this newspaper announced that the Ministry of Justice in Poland has just presented a draft law to rescind and annul basically all disciplinary and problematic aspects of the muzzle law, including the one which would punish judges for scrutinizing the legitimacy of other judges in the procedure, the law which would force judges to disclose their membership in various NGOs, etc. So, although it has taken some time, you can see that Venice Commission has made a real and unqualifiedly positive change. But this is sort of like prehistory. And I want to move to the post-2023. And I would like perhaps to paraphrase Mark Antony from Shakespeare's Julius Caesar. Mark Antony famously said, I come to bury Caesar, not to praise him. And I may say, I come to assess or evaluate the Commission, not to praise it. I hope I will be forgiven for that. Because in 2023, with the victory of the democratic opposition on 15th October, everything changed. But not in the Venice Commission's approach. In fact, that's the actual problem. The Venice Commission maintained its doctrine, which is sort of encapsulated in a mantra: you cannot restore the rule of law by violating the rule of law. And of course, everything depends on how you understand the rule of law in this maxim. My friend, and a friend probably of many of us, Andras Shayo, used a motto to one of his blogs in Verfassungsblog from a French minister of 19th century who said, "L'égalité nous tue." Legalism kills us. And I'm afraid this is something that is relevant to what's happening now. Because the new government established by the majority that won in 2023 has inherited from its predecessors, from the Law and Justice, a real legal minefield, a situation in which the whole institutional system is contaminated by illegality and what Radbruch called statutory lawlessness. So we have all the top institutions in Poland tainted by procedures, institutions, and persons who are entrenched there, who are very difficult, almost impossible to remove and change within the clear, pure fidelity to statutes. Constitutional Tribunal, the Supreme Court, National Council of Judiciary, Prosecutor General, you name it. You look at any of the institutions which are a crown of the legal system, and they actually poison the system with its illegality. And you are now 1 year, 3 months after the election of the democratic forces. And we are 2 months before presidential election. President is one of the main factors of these landmines or of this minefield, because he keeps either vetoing various laws proposed by current majority, including one 3 days ago which tried to sort of fine-tune, sort out the issues about the elections, or sending them to so-called Constitutional Tribunal with obvious outcomes. And in this context, I'm afraid, and I'm sorry to say, that the Venice Commission was unhelpful, showing what I consider to be a degree of insensitivity to the special transitional situation in which the government does not have the luxury of simply complying with all the statutes, because doing so equals paralysis. So I'm going to support this judgment with a quick analysis of 3 opinions of Venice Commission handed down in 2024. 2 opinions which I will consider jointly for brevity, to save time. The urgent joint opinion of May 2024, which was then supported by the Commission in its regular session in June, and the joint opinion of the Venice Commission and DGI of 11th October 2024. They may seem different because the first one was on a very specific draft proposal of law of the National Council of Judiciary, while the second was on abstract questions by Minister of Justice Adam Bodnar related to the judiciary. But as a matter of substance, I believe they raise very similar questions, so I will consider them jointly. And the third one was a package, a legal package on constitutional tribunal, which I will discuss at the very end. So let me start with these two, with the urgent joint opinion and the October regular opinion. That's how I will be referring to them. And let me say, first of all, that both these opinions, as all opinions of Venice Commission, contain a long list of incredibly positive and important and constructive suggestions. But as I say, I'm not here to praise. I don't want to criticize. But the problem is that, you know, as the saying goes, one bad apple spoils the bunch. And actually, there are more than one bad apple in this package of these two opinions on the judiciary. I will mention them in some detail because I want to show what is really so unhelpful and, in the end, wrong about them. So I think what is my way of deconstructing Venice Commission's doctrine, which can be discerned in these two opinions, starts from paragraph 21 of the full opinion of October, when the Commission states that, I quote, to declare a judicial appointment as non-valid equates/amounts to a decision to dismiss a judge. And then, of course, follows a conclusion. Such decisions are in the jurisdiction of the judiciary as part of judicial independence. And I don't want to now paint the background of what is it about, because I presume that most in the audience know it, and that is that the whole judiciary in Poland, including Supreme Court, but also common courts, is contaminated by so-called neo-judges. I'll call it neo-judges, although Venice Commission avoids this admittedly politically sensitive concept. They say about inappropriately appointed judges. Anyway, we are talking about judges who were promoted or appointed at the recommendation of the National Council of Judiciary after the beginning of 2018. That is when a new NCJ was established, which was fully representative of the Law and Justice majority in the Parliament, because they changed this election. And both European Court of Human Rights and European Court of Justice, and also Polish Supreme Court in its joint joint opinion of three chambers back in 2020, decided it is unconstitutional. So we have this problem about so-called neo-judges. And now, of course, something has to be done about them. There were various proposals. Adam Bodnar asked, Minister of Justice asked Venice Commission, how can I go about it? And the Commission said, to declare a judicial appointment as not valid amounts to a decision to dismiss a judge. I completely disagree with that. My analogy is a little bit like with a divorce versus invalidation of marriage. My view is that the decision to declare a judicial appointment invalid because it was made by the president at a recommendation of an illegitimate body, NCJ, is less like a divorce, more like invalidation of marriage. And it matters a great deal in what happened next. So let me move on. And now let me say a few words about one aspect of this opinion, May opinion, which was later confirmed by the Venice Commission in its regular session. The May opinion about a proposal, draft proposal on the National Council of Judiciary, which of course, as you all know, as in almost all continental European countries, is absolutely central body in appointing, promoting, and demoting and dismissing judges. So it's, one may say, the heart of the judicial system. And one admittedly marginal issue there, because as I say, there were many good assessments by the Venice Commission. But there was one tricky issue. If we act in accordance with the law, and those improperly appointed judges go back to where they came from, can they then stand in the election of the new proper National Council of Judiciary? So it was a question of eligibility of neo-judges, now removed to their previous status, in the election to the NCJ. It may seem to be really, really, really marginal, but I think that its treatment by Venice Commission is extremely informative about its thinking. So in the first bullet point, the Venice Commission states an obvious. It says this restriction in standing for the election, is based on the premise that a judge appointed to the NCJ in violation of the basic rule of procedure for the appointment of judges, it's a mouthful, it's a neo-judge, right? Cannot be considered as independent and impartial because she or he participated in a procedure considered to be deficient. Correct, yes. Now, what are the conclusions drawn from this obvious statement? And I would like now you to please listen for a moment carefully to the dissection of the passage that follows, because it's extremely significant. Let me read it. However, the concerns regarding the independence and impartiality of these judges stem solely from procedural flaws in their appointment or promotion. The wholesale blanket exclusion of such a large cohort of judges lacks individual assessment and thus raises questions of proportionality. In addition, first-time judges being nominated after judicial training would be excluded from the right to be candidate, even though they have no choice to enter the legal profession, but to accept their nomination by the National Council. Career choices may also have appeared unavoidable, as the NCJ has remained in office several years. Everything is wrong about this passage. 4 sentences, 4 mistakes. Let me state from the first one. The concerns regarding the independence and impartiality of these judges stem solely from procedural flaws in their appointment or promotion. Not true. It stems from the deliberate decision of some judges who knew very well that the new procedure is unlawful and unconstitutional, because the debates in Poland were very, very intense then, and nevertheless they decided to apply for promotion or admission if they were outside the judicial profession, for example, prosecutors, law professors, barristers, etc. So the concerns don't flow from the procedure, the concerns flow from the deliberate, voluntary choices of individual judges. This sentence sounds a little bit as to say that the burglary into a house stems solely from the fact that the owners left the doors open. So, of course, burglars, could come into. The second sentence. The wholesale blanket exclusion of such a large cohort of judges lacks individual assessment and thus raises questions of proportionality. I'll come to this individual assessment in a moment. But the fundamental problem I have about this sentence is the question-begging connection between this particular procedure and proportionality. Proportionality, as we all know, demands that the rules are commensurate or proportional to the aims to be achieved, that they are the least restrictive means to achieve a particular aim. Here, a particular aim is to cleanse the judiciary from improperly appointed and promoted judges. So why should you have individual assessment of a case by case if we know that the only thing that matters is that they all equally have decided to run in this improper unconstitutional procedure? That's the only thing that matters. If the problem was systematic or systemic, then the solution must be systemic. Third sentence. First-time judges being nominated after judicial training would be excluded from the right to be candidate, even though they have no choice to enter the legal profession, but to accept their nomination by the National Council of Judiciary. From the very beginning of public discussions about what to do with neo-judges, everyone, and there was a consensus, the first time judges would be excluded from the procedure of any, say, verification. Because they indeed, those who just finished the school for judges, the so-called assessors, etc., they are a special category, and they wouldn't be captured by the new measures because they didn't participate in competitive procedure, and for them, National Council of Judiciary was a little bit like a postman, you know, so they were out of the picture. And the last sentence, career choices may also, that is for other judges, not just them, have appeared unavoidable as the National Council of Judiciary has remained in office several years. Think about what the Venice Commission is saying here. They have plenty of empathy for those judges who could, oh, sorry, I'm getting carried away. I promise I won't do it again. That, you know, what, thank you, Armin. So what the Commission is saying here is showing certain empathy to judges who couldn't resist temptation. Because, you know, NCJ was for a long time, we don't know when all this finish. You have only one life, right? You know, there is a time when you want to be promoted, so they did. But Venice Commission doesn't show equal empathy to those judges who were, by their own conscience and honesty, denied this possibility. We have two judges like that in our room now. Judge Dariusz Mazur, who is now Deputy Minister of Justice, who was a judge in Poland who didn't apply for a promotion, even though he could think that, you know, his career choice is unavoidable. There is Judge Kożuchowska-Warywoda, who is also a very high official of Ministry of Justice. She didn't apply. There were many decent, honest judges who put integrity above career. And how much time do I have? No, you are already 4 minutes. Oh, I'm terribly sorry. Okay, so I won't be talking about the. In that case, I won't be talking about Constitutional Tribunal. What I want to say is that in this way, at least in this analysis, to me it's clear that Venice Commission somehow has lost the plot, hasn't realized what is the fundamental issue about the statutory lawlessness in Poland, and that some measures which in a normal, regular, rule of law abiding state are unavoidable. Otherwise, you end with complete paralysis, which to some extent we see now. And the last word I want to say, I would urge us and the Commission to go back to Gustav Radbruch, to a distinction between gesetzliches Unrecht and übergesetzliches Recht. Statutory lawlessness, which we now see plenty of it in Poland, and the compliance of which is not required by the rule of law, broadly understood, and above supra-statutory law, which comes from European law, as Professor Kim-Lane-Scheppele has argued so persuasively, and from the constitutional law of Poland, but including its unwritten rules of democracy and the rule of law. Thank you very much.
Okay, so I put on the watch here 15 minutes, so it won't be. Well, so first of all, thank you from my side for having me at the 35th anniversary for the foundation of the Venice Commission. In Germany we say, wie schön, dass du geboren bist, wir hätten dich sonst sehr vermisst. We are happy that you were born, otherwise we would have missed you so much. Now, congratulations. First of all, if you want me to arrive at the end of this talk, someone needs to open a door to have some oxygen. May I ask the conveners, the people in the back, if you could open some window to have some oxygen, because I'm afraid to faint here in the beginning. So, wonderful. Okay, so our topic is the elaboration of... So I'm privileged. I get the oxygen first. That is fair enough. So the topic is elaboration of constitutional standards after the remission of the judiciary. So we might call it reforms 2.0. I put some red in the picture, so in the afternoon it might help to get across. I'm following up to what Professor Sadurski said, but I will do it on a more abstract level, but I will operate on the two issues that you were raising. So you called upon me to teach the Venice Commission a lesson. So I don't feel in that position, but I will bring to you a suggestion. And I think it is a suggestion that might be controversial, so we might have something. So you also keep awake, so it will be confrontational. So my suggestion is to keep the role of the Venice Commission, the constitutional role of the Venice Commission, in sync with the overall development of European constitutional law, and that plays out in Transition 2.0. And even, I think, you should become more important in the overall development of European constitutional law, not least, as you said, in the development of the new rule of law checklist. So I will do that. Where is the, is that, yeah. So I will do that also with two sentences from your opinions that seem to me emblematic for the current self-understanding of the Venice Commission. So the first is, it says, the Polish reforms have to be seen first and foremost against the background of the obligation by Poland to execute the judgments of the European Court of Human Rights. So that makes the Commission an appendix to the European Court of Human Rights. Now, with all due respect to the European Court of Human Rights, the Strasbourg Court is only one of the sources of transnationally valid constitutional standards, and there are also the EU values that are relevant in that context. And indeed, the Article 2 of, that came with the Lisbon Treaty is a manifest of European constitutionalism. It is relevant, of course, for the EU member states, but not only for the EU member states, because it's also relevant for the candidate countries, and also all the countries that are associated with the European Union are also bound to these values by the bilateral agreements. And now these values are particularly important when it comes to the enforcement of these values. And that brings me to the second, no. Oh, yeah. We have to go back. Yes, and that brings me to the second quote. So the Venice Commission and the DGI also stress that the judgment of the Court of Justice of the European Union do not have an automatically invalidating effect within the Polish legal system. That's not wrong. But something very important is missing here. And so I will come to your conclusions, but I will come in a very German doctrinal way. So what does Transition 2.0 mean? So what was Transition 1.0? It was a country is under authoritarian government, and that country decides, and it decides overwhelmingly to transit towards constitutional democracy, and it does so with very few transnational strings. That's Transition 1. Now, how is the current Polish process different to that? Well, it has managed successfully Transition 1. Then an elected government has regressed from constitutional democracy and has developed systemic deficiency, and now we have a new government that wants to overcome that. So what do we have? The regression has a democratic pedigree. It is legally entrenched. The former government continues to enjoy support. And all that happens in a transnational framework. And there we have the Council of Europe framework, but we also have the European Union framework. And I think we all agree that the European Union framework comes with much more Wumms, as we know saying in Germany. And I think that latter feature is too little reflected in this second sentence. So I think the Venice Commission should use the Polish EU membership because it makes a difference for you to accomplish your mandate to promote democracy through law. And I also see that covered by your mandate because the EU values that I showed you, the EU values are the expression of the common traditions of the member states, and much of that is built on what the Council of Europe and not least the Venice Commission has produced. So it's not something different. These are the same values, but it is for the mechanisms that makes the difference. Now, as again, the second quote, they do not have automatically invalidating effect. That is correct, but much is missing. So what is missing? Let's explore that. So these values make a transition 2.0 at the same time more difficult, but they also facilitate it. I will develop that, but I make two very important caveats here. The first is primacy is not a silver bullet, but it helps. That's the first. Primacy is not a silver, but it helps. And the second is what I'm doing here, being a German doctrinal legal scholar, I'm investigating a legal possibility. I'm not advocating to go politically that path. That involves many more decisions to be taken, and I'm happy to discuss that, but that's not my brief here. Here my brief is a positivist doctrinal scholar who shows a legal possibility. Yeah, it's important to see that. And the key is that the EU values put the transition 2.0, therefore what is going on in Poland, in a very tight constitutional context. And it has two sides, this tight constitutional context. The first is that Article 2 places constraints on such transitions. Most importantly, it requires that this process respects the principle of the rule of law, and that is the principle of the rule of law and not the principle of the rule of law read right or small like that. The principle of the rule of law, and that is all EU law, the law of the Council of Europe with the European Convention on Human Rights, but also domestic law. Now that creates an obstacle for overcoming the resistance you just mentioned to all that. But the Article 2 requires to respect all that law, and that is legally relevant, but it's also politically relevant. So I see if the Polish government enacts legislation that infringes the Article 2, the third thing that these people will do is that they go to the Commission and that they go to the European Court of Justice. And since the accusation of double standards is all over the place, that's to say that the PiS and the Fidesz say they only go after governments that are against their political opinion, so that there are double standards in Europe. The Commission and the Court, they will have to apply the standards. There's just no way out. So if European law is broken, or even domestic law is broken in a meaningful way, it is very likely that that will not survive scrutiny by the European Union institutions. And that is the question that I put to you. You know, how to deal with that problem. But again, I think there is a way out, and that is now the facilitating. And just to say, so I think the cautious stand by the Venice Commission, you know, responds to that, because that there is a real danger, and we don't want that the former governments that they win in the Court of Justice. So there is reason in this cautious stance. But then, and we have the other side, and that is missing here, and that is that it can facilitate a democratic transition. So how does the argument go? I have 4 minutes and 30 seconds left. So we have a violation of EU values, and that is given the common jurisprudence of the European Court of Human Rights and the Court of Justice. I think that is safe to assume that the selection of the judges by the new Polish National Council of the Judiciary, as well as decisions by the Constitutional Tribunal with the October judges, that this is an infringement of Article 2. I think there we have an agreement. So we have an infringement, and there continues to be an infringement of Article 19 together with Article 2. Step one. So how does that play out? It plays out with primacy. So what is the key idea of primacy? The key idea of primacy is that all member states' bodies, not just the courts, all member states' bodies have to give full effect to EU law. Now that started with disapplying national legislation, and that's what we all know. So we have Costa Enel and Simmental. But Simmental is 77. It's almost 50 years ago, and a lot of things have happened then, and that in particular recently. You know, the Rimshewicz case, the VZ case with Poland. We have all the cases with the Polish Constitutional Court, with the Romanian Constitutional Court. So what do we see there? We see strong judicial federalization. We see that primacy not only is on disapplying legislation, but it goes much further. We have now instances of nullity. So the act is not existing. And it comes in two ways. Either that European Union law requires member state institutions to declare nullity, or we have even further going statements that union law itself has the effect of nullity of the domestic situation. Of course, that changes the entire picture. So the marriage has never occurred, to use your example. So how does that affect? And very importantly, primacy comes before proportionality, because primacy is a rule of coalition. So if there is a conflict with primacy, there is nothing to balance anymore. So that is very important. So how does that play out? So if we have an infringement, and if primacy applies, how does that play out? Well, first, for court judgment, all national institutions must refrain from any measure that continues or deepens a situation of illegality. Now, publishing Constitutional Tribunal decisions that suffer from an Article 2 deficiency are such illegal deepening of an illegal situation. And I think the same is true with respect to the neo-judges in a position of power. So I think that is the point that needs to be considered. Of course, we see 3 levels of impact. They have to disapply. They have to be declared null and void, or there might be the null and void effect of EU law. Now, this is reserved to very critical cases. Critical cases, as the Commission put it in the last year's case, Commission v. Hungary, a case supported by 16 member states. And the Commission goes strong, and what does it say? Here we play the Article 2 card in full, because there's a frontal attack against European society. So I think that we share that the overhaul of the Polish judiciary, that is a frontal attack against our values, it's a frontal attack against European society. So I think in such a situation, the full thing with nullity applies. So what does that mean for the Venice Commission? And so I close. What is the place of the Venice Commission here? I see it at 2 levels. First is that the Venice Commission should take more note of this development that we see here than it has done so far, and that it sees that this impacts also on your evaluation of the situation in Poland. But I think the Venice Commission could move on and become a full actor in this new European constitution. And that I will end on that note. The European Union and the Council of Europe have been for decades in a rivalry. That rivalry has been overcome in this rule of law crisis. They have joined forces, I think, with very good effect. And I think now my suggestion is do another step, endorse that development within the European Union, and give your authority and your advice in that development. Thank you very much.
Non, ça ira comme ça. Je voudrais d'abord dire que je suis extrêmement heureux de me retrouver ici dans ce débat, ayant été pendant quelques années vice-président de l'Association internationale de droit constitutionnel et ayant le grand privilège d'être aujourd'hui membre de la Commission de Venise. Je voudrais aussi remercier sincèrement les organisateurs de ce débat, et tout particulièrement la présidente de session qui n'a pas craint de donner la parole à une voix qui n'était non pas dissidente, mais qui pouvait être nuancée sur certains propos. Et j'allais dire, de ce point de vue-là, je suis aussi heureux d'être là parce que je vais in fine défendre tout à fait la position qu'a prise la Commission de Venise dans cette affaire concernant la Pologne. D'abord, je voudrais revenir quand même, si vous me le permettez, quelques instants sur la notion d'état de droit. En effet, cette affaire polonaise est au cœur des contradictions qui sont susceptibles d'affecter l'état de droit. L'état de droit occupe dans l'ordre juridique une place aujourd'hui prépondérante, à tel point d'ailleurs que si l'on faisait, mais je n'ai pas fait l'étude, si on faisait une étude de terminologie, on s'apercevrait que cette exigence relative à l'état de droit tend à supplanter, non pas au fond, mais dans le langage, l'exigence relative à la démocratie. On parle aujourd'hui plus d'état de droit que de démocratie. Hier, c'était l'inverse, mais c'est toujours quand même, d'un certain point de vue, révélateur. Le support et le garant de l'état de droit, c'est le juge, qu'il soit supranational ou national. Et en fait, il y a un élément qui est important à relever, c'est que la référence récurrente à l'état de droit accompagne le renforcement du juge dans le système institutionnel. L'état de droit fait en fait l'objet d'une formulation très générale dans les textes qu'il consacre, et il renvoie à des exigences qui sont de plus en plus contraignantes et à des concepts de plus en plus larges dans l'espace politique et social. Et cet état de droit, en fait, il n'est défini nulle part. Et nombre de constitutions, dont la Constitution française par exemple, je ne parle pas de la Constitution monégasque, ne font pas référence à l'état de droit. L'état de droit, il est essentiellement formulé par des instances consultatives, au premier chef la Commission de Venise, et par des juridictions, notamment les juridictions européennes et les cours constitutionnelles nationales. Et ces gendarmes de l'état de droit, ont été confrontés à une difficulté qui a engendré une nouvelle contradiction, et c'est le thème: comment rétablir un état de droit jugé menacé ou affaibli du fait du pouvoir politique, tout en permettant à un nouveau pouvoir politique issu d'une majorité différente, à la suite d'élections, d'user de moyens considérés comme susceptibles d'entrer en conflit avec l'état de droit lui-même. C'est une contradiction fondamentale à laquelle la Commission de Venise a été confrontée. D'abord, quelques mots sur cet état de droit. Nos systèmes politiques européens sont des systèmes mixtes, des systèmes démocratiques et libéraux. La démocratie renvoyant pour l'essentiel au mécanisme de légitimation du pouvoir, le libéralisme renvoyant au mode d'exercice du pouvoir, c'est-à-dire pour l'essentiel au contrôle et à la limitation du pouvoir. Et le juge, bien évidemment, est celui qui est chargé d'assurer l'aspect libéral, l'aspect de contrôle du pouvoir dans nos systèmes politiques. Et de ce point de vue, les cours européennes jouent un rôle particulier puisqu'elles sont des outils importants de protection des libertés individuelles à partir du moment où elles se placent en surplomb des considérations étatiques. Je ne dis pas qu'elles doivent ignorer les considérations étatiques, et encore moins que les États et que les juridictions des États doivent ignorer les considérations étatiques, mais l'intérêt de ces juridictions européennes, c'est de se placer en surplomb. Si le juge n'est pas une institution démocratique, dans le sens que je viens d'employer, le juge est une institution nécessaire à la démocratie. La légitimité du juge ne tient pas, sauf dans certains systèmes, du choix des électeurs, elle se trouve dans sa fonction de tiers impartial. Le juge est d'abord le garant du bon fonctionnement de la démocratie, au travers notamment du contrôle des élections, et qui veille à la correction de l'expression de la volonté du peuple ou de ses représentants. En fait, l'état de droit et le juge, c'est quoi historiquement? C'est quelque chose qui est fondamental, c'est la protection contre l'arbitraire. Je crois que le cœur de l'état de droit, c'est la protection contre l'arbitraire. Et qui protège contre l'arbitraire dans une société? C'est le juge. En fait, le juge, par rapport à l'état de droit, occupe une position particulière. Il est une position particulière sur laquelle on pourrait d'ailleurs s'interroger au regard du principe de séparation des pouvoirs. Le juge est à la fois le définiteur et le prescripteur de l'état de droit, autant qu'il en est le garant. C'est le juge qui définit l'état de droit et c'est le juge qui veille au respect de l'état de droit. En fait, si on prend, et ça a été cité, l'article 2 du traité sur l'Union européenne, qui renvoie aux valeurs de l'Union européenne. Cette liste, elle présente essentiellement deux caractéristiques. Je ne la rappelle pas ici pour ne pas prendre sur mon temps. Elle présente deux caractéristiques. Elle renvoie à des valeurs communes, mais ces valeurs sont tellement générales que si elles sont consensuelles du point de vue nominal, il est évident qu'il peut y avoir des conflits et des problèmes en ce qui concerne leur mise en œuvre. Comment concilier l'universalisme et les droits des minorités, les non-discriminations et les différences entre les nationaux, les étrangers extra-européens, les valeurs traditionnelles et les reconnaissances spécifiques de minorités sexuelles? Ce sont des questions qui, qu'on le veuille ou non, se posent dans un certain nombre de systèmes. La deuxième caractéristique, c'est, je dois le dire clairement, c'est le flou conceptuel de cet article 2. Flou conceptuel de cet article 2. À quelle conception de l'état de droit ce texte renvoie-t-il? Une conception substantielle, formelle, stricte, large. La dignité et la liberté sont-elles distinctes des droits de l'homme? Comment s'articulent la dignité et la liberté? Comment s'articulent la démocratie et l'état de droit? Et on considère finalement dans la jurisprudence européenne que l'état de droit est le concept qui absorbe quasiment tous les autres concepts. Il est évident que l'on se trouve, et c'est un constat, ce n'est pas une critique, qu'on se trouve face à un flou conceptuel. Et parmi ces valeurs, en effet, le concept d'état de droit occupe un rôle stratégique au niveau européen. Il va être utilisé dans deux directions. Première direction, il va justifier l'intervention de l'Union européenne ultra vires dans les structures institutionnelles des États, notamment en ce qui concerne la justice. Alors, le problème, et on peut comprendre cette logique, c'est que l'Union européenne n'a aucune compétence en ce qui concerne les structures institutionnelles des États, mais comme la justice est l'élément central de garantie de l'état de droit, l'Union européenne exerce des compétences en ce qui concerne les structures juridiques. Et puis, il y a aussi une conception de l'état de droit qui, à mon avis, est beaucoup plus difficile à appréhender, et on la retrouve, par exemple, dans la saisine par 15 États de la Cour de justice contre la Hongrie, au motif qu'elle aurait méconnu l'état de droit en adoptant une loi discriminatoire à l'égard des personnes LGTB. Et là, on est sur un rôle de l'État de droit qui est différent du rôle structurel qu'il peut jouer par rapport aux structures judiciaires. On renvoie ici à une logique de transformation ou d'une certaine conception idéologique de la société. Alors, à partir de cette fonction de définiteur et de prescripteur de l'état de droit, jouée par le juge, on se trouve dans la situation polonaise qui est l'objet de notre rencontre, à un conflit entre un pouvoir politique qui cherche à se dégager de ce qu'il considère être comme une forme de carcan tant institutionnel que substantiel, et les institutions et les juridictions garantes de l'état de droit. C'est ici à une forme de conflit entre le droit et la politique que l'on assiste. Et la tentation est alors forte de remettre en cause l'indépendance de la justice, ce qui est le marqueur des États qui assument une certaine rupture avec le libéralisme. Et dans ces États, la question ne se serait pas posée en Russie, dans ces États qui sont des régimes autoritaires mais non despotiques, la situation politique peut se retourner. On ne se poserait pas la question d'un retournement de la situation politique en Biélorussie. Donc on ne saurait pas comment rétablir l'état de droit en Biélorussie à la suite d'élections. S'appuyant sur les condamnations portées au nom de l'état de droit par les juridictions européennes, le nouveau pouvoir politique peut souhaiter recréer les conditions d'une véritable indépendance de la justice. Mais pour ce faire, et ça a été le cas, il peut estimer qu'un rétablissement progressif de l'état de droit ne satisfait pas ses ambitions, car il ne crée pas immédiatement les conditions satisfaisant les exigences de l'état de droit et implicitement ne lui permet pas de mener sa politique. Il peut alors faire valoir la nécessité de renverser les institutions judiciaires et de renvoyer des juges qu'il juge inféodés au pouvoir politique précédent. Une telle procédure est alors en effet susceptible de mettre en cause les critères essentiels de l'état de droit, à savoir l'indépendance de la justice, la sécurité juridique et le droit au recours. Et j'insiste sur la sécurité juridique et le droit au recours. En fait, dans la vie de la Commission de Venise, je crois que la Commission de Venise a probablement une vertu qui peut être considérée par les institutions concernées comme un vice, c'est qu'elle est éloignée des débats politiques nationaux. Et que la Commission de Venise, en fait, elle ne satisfait vraiment les intérêts d'aucune nation, d'aucun État et d'aucun gouvernement. La Commission de Venise, elle se place en dehors du débat politique interne. Le projet qu'avait analysé la Commission de Venise visait à modifier la composition du Conseil supérieur de la magistrature, alors que la Cour européenne des droits de l'homme avait jugé inconventionnel le système. Et il posait, ça a été rappelé, le projet qu'avait analysé la Commission de Venise dans un des avis rappelés, posait problème, notamment ce qu'il prévoyait l'exclusion du droit de se présenter aux élections des juges qui avaient été nommés ou promus pendant les activités du Conseil dans sa composition actuelle ou antérieure. Et la cessation anticipée des fonctions des membres judiciaires actuels du Conseil national de la magistrature et l'absence de recours juridictionnel contre la cessation anticipée des fonctions des membres judiciaires. Alors, le gouvernement polonais, et ça a été rappelé, pouvait légitimement faire valoir que les nouvelles dispositions visaient à tirer les conséquences d'une décision de la juridiction de Strasbourg. Mais il n'en reste pas moins que les décisions des juridictions de Strasbourg ne sont pas d'application directe. Elles doivent passer nécessairement par le truchement des décisions prises par les autorités nationales, alors même que ces autorités nationales sont contraintes de le faire au niveau du respect du droit européen. Mais on ne peut pas considérer que si les institutions nationales ne mettent pas en œuvre le droit européen, ce droit européen va s'appliquer ipso facto directement. Et l'idée de fédéralisation judiciaire, qui est une idée qui me paraît extrêmement pertinente dans la réalité des choses, ne fait pas encore partie du droit de l'Union européenne, puisque aucun État ne s'est jusqu'à présent engagé par les traités à accepter un système de fédéralisation. Il n'en reste pas moins donc que la question se posait de savoir si des mesures prises en vue de remédier à la violation constatée de l'état de droit peuvent violer des principes reconnus tant par la Constitution nationale que par le droit conventionnel. La Commission de Venise admet que les objectifs poursuivis par le gouvernement sont pertinents et qu'un strict respect des exigences ordinaires serait susceptible de faire perdurer la situation constituant une violation de l'état de droit. Ça, je crois que c'est un élément important, c'est que dans cette idée, qui est probablement une idée de proportionnalité, à laquelle j'adhère d'ailleurs, la Commission de Venise admet que l'on est dans une situation particulière. Mais la question de la remise en cause du droit au recours, qui est quand même l'un des droits absolument fondamentaux, j'allais dire, de l'état de droit, c'est probablement le pilier de l'état de droit, le droit au recours, la Commission de Venise a prévu une voie de recours sans caractère suspensif. En réalité, et j'en terminerai par là, dans ce cas de figure, aucune solution n'est véritablement satisfaisante. D'une part, la violation d'exigences, en l'occurrence tout à fait essentielles de l'état de droit, même aux fins de rétablir l'état de droit, la fin justifiant les moyens alors, crée un dangereux précédent. Encore une fois, la conception de l'état de droit, et je sors de la question des juges, la conception de l'état de droit est une conception large et évolutive, puisque même la Commission de Venise va retravailler ces critères de l'état de droit. Et si on peut, j'allais dire, pour rétablir l'état de droit tel qu'il sera défini, remettre en cause les situations existantes, ça crée un précédent qui risque d'être utilisé. Et je mets en garde contre ce point. On risque de créer des précédents qui seront utilisés par des gouvernements dans des contextes moins vertueux. D'autre part, plus généralement, la question qui se pose est celle de la succession de régimes politiques s'inscrivant dans une logique de rupture. Lorsque cette rupture touche à des conditions essentielles de l'état de droit, elle peut résulter d'une révolution. Et ce que le professeur Sardisky a en quelque sorte implicitement reproché aux juges en fonction, c'est de ne pas avoir été des révolutionnaires. Et dans ce cas, le nouveau régime fera table rase de certains aspects du précédent. Mais dans ce cas-là, on n'est plus dans un système de l'état de droit, on est dans le cadre d'une révolution où le fait l'emporte sur le droit. Et dans ce cas-là, ce que dirait la Commission de Venise ou la Cour européenne des droits de l'homme n'aurait pas grand poids. Mais elle peut également résulter, comme ce fut le cas en Pologne, d'un changement de majorité. Et dans ce cas, je crois, et je n'irai pas plus loin, mais c'est sur ce travail que j'aurais dû me pencher, je crois qu'il est nécessaire de réfléchir à des mécanismes de transition qui, s'ils ne satisfont pas à un rétablissement immédiat de l'état de droit, évitent une violation brutale de ces mêmes exigences. Et ce que je préconiserais pour ma part, c'est une réflexion. On a, et dans cette salle, certains ont travaillé sur les régimes de transition, et je crois que c'est une réflexion sur la transition d'un système considéré comme ayant violé l'état de droit à un système qui veut rétablir l'état de droit. Ce sont des mécanismes de transition sur lesquels il faut réfléchir, sinon on se risque de se heurter à deux impasses. La première consisterait en effet à ne pas tenir compte d'éléments essentiels comme le droit au recours pour rétablir l'état de droit. Le deuxième système conduirait finalement à faire perdurer l'atteinte à l'état de droit du fait qu'on ne peut pas toucher au système existant au nom de la sécurité juridique. Voilà, c'est une invitation à réfléchir et malheureusement pas des solutions que je vous propose. Je vous remercie.
Thank you very much. I found the three interventions very stimulating, and I would say we have what I would call a philosophical divide with practical consequences. Yeah. We have a philosophical divide among us, or among the Venice Commission and your criticism, and with practical consequences. And let me just make 2 points. The first, you mentioned, Professor Sadurski, you mentioned we should go take Radbruch as a we should have an orientation towards Radbruch. And Armin, you basically said we should take the values which are in Article 2 and value them more as more important than the written law that we have in Poland. So I won't now talk about Poland, but let me give you another example where I see the same philosophical divide, and just to explain the Venice Commission's position from another point of view. We had these famous cases about the shooting at the wall in Germany. So based on GDR law, the shooting seemed to be legal. Shooting on refugees, on people who want to leave the country, it was in the GDR law. And so when these people were judged by German courts after reunification, these people came to courts and said, you cannot do it, we did what is legal. And then when you look into the German courts and you look at the Constitutional Court, they quoted Radbruch. And they said this, Unrecht cannot be Recht, so what is absolutely unacceptable cannot be the law. They went into this philosophy, and that's what I understand you did. And then the case went to the European Court of Human Rights. In my view, it was very wise, because the European Court of Human Rights did not quote Radbruch, did not go into philosophy, but they said, look at the GDR law. And in the GDR law, for example, it was written that you can shoot on people only when they're carrying weapons. And they were not carrying weapons. So they said, just take it literally, and there you are. It's illegal under GDR law. And that is what I mean, and what we try to do at the Venice Commission in these opinions. We tried to take Polish constitutional law very seriously. And we try to develop all our points of view based on Polish constitutional law. And we did not try to take some abstract principles. And that's why we try to have our feet on the ground. So this is the first sort of more philosophical remark, and the practical remark. You are, of course, absolutely right that such a transition is very difficult, and it's also dangerous. The next elections will come, and if you have no achievements with your new sort of government, then the voters might say, well, then we don't give you trust anymore, and they might vote once more for the other party. We see that, but when you look at the Venice Commission's opinions, they were very clear about saying, well, legal certainty and safety of the judicial mandate would say you cannot touch upon it. But we accepted to make exceptions. But we did not make these null and void exceptions, but we said they have to be proportionate. And that was our understanding in order to get a compromise or a solution that might be acceptable for the next future. But now I've misused my position as a moderator. I should not moderate, but I should moderate and not take a position myself, but I just wanted to give an answer. But now the floor is open, and I'm sure that a lot of you, Marta first, and then Cesare, and I see, I see Carlo and Christoph. So I collect you all, and because I have now 5, I think, and I collect you, and then I give the 3 of you one answer. So, Cesare, you want to start? Marta was the first, and then Cesare.
From here is okay? Oh, okay. Thank you. Sure, thank you so much. So, thank you for the remarks, and indeed any criticism is useful for going deeper in understanding what we are doing. First of all, a disclaimer, I am indeed member of the Venice Commission, but I am speaking on my own capacity. I am not involving the authority of the Venice Commission with these remarks. But I was part of those opinions, at least as a member. I was not one of the experts involved, but in my view, we were not killed by legalism. The debate brought me back in some way to the origin of the 20th century constitutionalism, the crisis of positivistic approach to law. Law is something more than simply a group of legislation, because if you stay strict to legalism, you can be killed by this legalism in a physical manner in some cases, at least at that time. But we are not in the same position. We do not have simply a legal framework, national legal framework, or natural values or, I don't know, other natural law or abstract values. There is a lot of things that happen in between. There are constitutions, there are European framework, there are the European Union treaties, there are the European Union values, there is the European Convention of Human Rights, and many other things. All the things that developed exactly to build up a sort of bell of a broader, what Kim says, the rule of law writ large. I think that the Venice Commission was exactly doing this exercising of understanding that our rule of law today is a rule of qualified European constitutional law. It's not just rule of law. There is Europe and there is constitution in the middle. So we were applying this when we were saying, yes, indeed, you have to accept some derogation to the usual respect of the strict legalism, but you have to have a good reason to do this. Either you are executing a decision of the European Court of Human Rights, and in any case, you have to apply proportionality in this exercise when you derogate for the strict observance of the legal framework. So it's not that we are trapped in legalism, in formalistic legalism. We went a little bit farther, but with some safeguards. Armi, I think that I disagree about proportionality. Because indeed we need proportionality in this kind of context. You are right, when there is primacy and there is the usual rules that govern EU law, you do not have proportionality because you simply have to disapply national law. But in your construction, you are not simply, and indeed the values of Article 2 are enjoy the primacy of EU law. But they are values, they are not the rules precise, clear and unconditioned as the first doctrine of primacy was saying. These are values, these are broadly written. So there is an issue of who is applying, who is interpreting, and how do you balance the different values. After all, we have democratically elected government and the rule of law that are competing on the same field. So how can you imagine that you do not have a proportionality approach when you are using values that are requesting for balancing and also for enforcing, and in the sense that you have to give a concrete meaning in the single situation. So in my view, what the Venice Commission is trying to do is not to enforcing the rule of law as it was in the 19th century. It is enforcing a rule of law that is indeed broader than it used to be, but still firmly rooted in law. After all, and I conclude here, this is a time where independent authorities, not elected authorities, courts, agencies, and even the Venice Commission are not in good shape. They are constantly attacked because they are not elected. So in my view, any move that is taken against, in order to invalidate and to say that a rule produced by an elected body should have a strong basis and a strong reasoning that support it. Otherwise, the institution itself can be put at risk, and its legitimacy and its authority. Thank you so much.
Thank you, Marta. Cesare, please.
I think for the Venice Commission it is a question of benchmarks, of interpreting benchmarks. And let me begin just a moment with Article 2 of the European Treaty. To the extent it is strictly related with the benchmarks that the Venice Commission applies every day. The concept of the rule of law, contrary to what Bertrand said, I don't think that is a fluid concept. It is possible to give a substantial version of the rule of law, not a formal version. Otherwise, the relationship within democracy and liberalism changes completely. If you accept a only formal version, it is necessary to give a substantial version of the rule of law. But this doesn't mean necessarily to refer to the rule of law according to the Radbruch principles to which Wojciech referred at the end of his speech. I would just like to remember that the Radbruch principle was applied in Germany after the Second World War, but not by the Hungarian Constitutional Court of Laszlo Solyom after 1989. This is no coincidence. It is clear why, because the possibility of interpreting, referring to this principle changes from time to time, but also from state to state. So it's a question really of benchmark in this case. I would like, however, also to consider the fact that in spite of the large correspondence of the European standards to which the Venice Commission refers with the Article 2 version of the rule of law to which I referred, I think that the institutional mechanism of the Venice Commission are those of the Council of Europe. We are not arming an EU judge. And I think that the reason why the Venice Commission, in spite of the enormous difficulties met during this rule of law crisis, has maintained, if not even enhanced, its role, is also due to the that it is maintained the role, the institutional figure, which is well-known institutional figures, as a member of the Council of Europe and necessarily and inevitably referring to the institutional mechanism of this institution. Thank you.
Thank you, Cesar. The next on my list is Christoph.
I want to be brief, as many things have been said by the former speakers. I think why Armin's invitation to the Venice Commission to apply Article 2 and supremacy in order to be more powerful does not work is, or why I suppose it will not be followed, is exactly because the Venice Commission does not consist of legalists but of lawyers. And that means we have to stick to proper legal application of European Union law, and that does not mean just to take principles, as has been said by Bertrand, and to apply them simply like any other primary law in competition law and so on. And exactly what you have said, the Venice Commission, unlike the European Court of Justice, is not a body that wants to extend its power, but it is a body of experts which wants to give advice, as we have seen earlier this morning. And let me just add one thing which takes up a remark of Bertrand. He said in French, la commission est éloignée. So the Commission has a distance to the country concerned. But there's one quality. The Venice Commission, whenever it writes an opinion, in 90% of the cases there's a country visit and there are meetings, discussions with all stakeholders, not only governments, also NGOs and the institutions concerned. And I think this is a special value which should be kept in mind when we talk about criticism which was very, very strong this afternoon. I think the Venice Commission is thankful for this criticism. I remember the criticism in 2015, 2016 by the former government. And the judge always think if one is criticized by both sides, he cannot be totally wrong. Thank you.
Thank you, Christoph. So, Carlo, please.
I think, well, I'm stimulated. I'm stimulated too. Actually, I wanted to comment on what especially Armin said. And I think he pointed to a very important issue, namely the role of the Venice Commission within the network of European bodies which are charged with defending the foundational values of democracy, the rule of law, and the human rights, and which also include the European courts in Strasbourg and in Luxembourg. And the Venice Commission should be very conscious of its role in this, of its specific role in this institutional network. And we have often been, and so we have been also in the Polish cases, we have often been the first European institution which has produced a legal assessment of the situation. So it was when the rule of law backsliding started in Poland, and so it is now when the restoration of the rule of law has started. In between, the European courts have taken position on the same issues that the Venice Commission took position in the four opinions to which Wojciech referred to. And by and large, the European courts have adopted the same positions that we were, in a way, the first to publish. But now we are in a, and here I come to the issue of primacy. The European courts have been very clear in their assessment of the situation left by the former government. They have been both in Strasbourg and Luxembourg. They have been very clear about the non-independence of the National Judicial Council. They have been very clear about the irregularities in the appointment of the judges on the nomination of this National Judicial Council. They have also pointed to the issue of the judgments of the courts, such courts where those neo-judges have participated, and they have also been very clear as to the present constitutional tribunal and the issue of the December judges and the missing legitimacy of the present constitutional tribunal. There's no question about these issues, but what I want to emphasize is that neither the Strasbourg court or the Luxembourg court have issued clear directives as to how to remedy the situation. And that's where we now come in, and we are again the first European institution which is charged with assessing legally the situation, and in this case the draft legislation produced by the new government. Primacy doesn't help here, because there are no clear directives by the Luxembourg court to which apply the principle of primacy. It is true that the Venice Commission has perhaps too much emphasized the jurisprudence of Strasbourg at the expense of the jurisprudence of Luxembourg. Perhaps we should also bring in more case law of the Luxembourg court. But, for example, if you look at the opinions on the restoration of the rule of law in Poland, the approach we have chosen, it's a specific approach, and it's the execution of the Strasbourg judgments. There are certain general directives of the Strasbourg court, but not any detailed directives. And that's where we stand now. It is legally an uncharted territory, so to say.
Thank you, Carlo. And last but not least, we have a voice from Poland.
Thank you very much for giving me the floor. I'm a judge from Poland, temporarily seconded to the Ministry of Justice to try to help to heal Polish judiciary. I'm not a real legal expert. I'm not a constitutionalist. I'm just a simple criminal judge with 27 years of service. What I know is that Polish judiciary is after a long-lasting illness, which was lasting for 8 years. It was not healed, otherwise in the opposite, it was incited. I know that it has to be cured on a living organism in such a way that we wouldn't kill this organism. I know that no one before invented any kind of medicine for this kind of illness. And I know that the organism of the judiciary was affected very deeply, as more than 30% of Polish judges are defective. So millions of citizens are waiting for such a court which will deliver judgments which wouldn't be defective. I don't want to dig into details of the Polish proposal, how to heal the status of Polish neo-judges, as it is quite complicated. But Polish government suggested, before this first Venice Commission opinion, a kind of very general solution that in respect of judges who accepted being promoted with participation of defective National Council for the Judiciary, that they could be sent back ex lege to their last legal positions. I mean those positions which they acquired legally after the assessment of the old legal National Council of the Judiciary. It didn't mean removal them from judicial positions, just sending them back to the last legal positions. The Venice Commission excluded such kind of ex lege solution, stating that the motion is within the competence of the judiciary, not the legislature, which I would fully agree with in normal situation. Also, the idea of the value of stability of tenure, of judicial tenure, was revoked. But we are living in the times in which the balancing exercise is very much popular. And I wonder if the Venice Commission could take more favorable approach to this Polish proposal by assessing it as a kind of conflict of two rights. Right one is a right of individual acting as holder of defective judicial position, and right two is collective right of Polish citizens to have a right to quick access to independent and impartial tribunal established by law. I think that if we sort out things in this order, then maybe Polish proposal sounds more acceptable. Thank you very much.
Well, now we had a long discussion, and this last opinion is sort of going into what we usually do in our assessment of the situation where we hear all the voices. So I think we should be more on the abstract level, not so very much into the Polish case. We have already -7 minutes into the coffee break. So I think that it's important that you all answer, but have in mind that this section should come to an end as well. So please be precise. Thank you. Who wants to start? You? Okay.
Thank you very much. So there were so many important points raised, but I cannot start even responding them. So I want to make an appeal to Venice Commission, to the members of the Venice Commission who are here, to Marta and Cesare and Angelica and Bertrand, all dear friends and valued colleagues. Remember, your opinions matter a great deal. They are, of course, not just intellectual exercises. They are discursive instrument of debate in countries such as Poland. I'm speaking now about Poland because the situation is very special. And it happens that your opinions are also weaponized. They are used as a weapon in the arguments regarding very specific issues. So I pick up Angelica's urge to be very, very practical. When you say, for instance, there should be individuation of consideration of problematically appointed judges, but immediately add, but there can be some cohorts established. Remember, in Poland, immediately this will be picked by warring sides within the by and large democratic liberal field, and some will say individuation, so we have to do it by case, which will last until 2030, according to the ministry assessments. And the others say, no, cohorts, so let's look at the groups of judges. Remember that these things have consequences. When you say that the constitutional tribunals, so-called judgment and so-called constitutional tribunals have to be published unless they were issued with the participation of improperly adopted judges. So the idea is that the other judges are sort of kosher. Remember, in Poland, this will be seen as undermining the government's strategy of fading out this extremely, extremely toxic body which calls itself Constitutional Tribunal. And when you say that non-appointment of new judges to the vacancies in so-called Constitutional Tribunal is quote-unquote crippling the tribunal, you sort of assume that this body is, with maybe some minor problems, that it is a real, legitimate constitutional tribunal. Just remove those 3, now 2 pseudo-judges, one of whom, by the way, is member of Venice Commission. So remember about this sort of political responsibility and impact that your decisions make, because you have enormous intellectual and moral capital, very well earned over the years and years of your opinions, including in those very dark years of 15 to 23. And you know, every sentence in your opinions which you issue, which I'm absolutely sure is issued with the highest integrity and honesty, will make a difference. I just want to make one last point. À mon cher ami Bertrand Mathieu, non, je ne suis pas révolutionnaire. Je ne suis pas pour la révolution en Pologne. Mais je voudrais dire que le principe de l'état de droit est totalement prone, sorry, I'll go back to English, lends itself to interpretation. As we all know, it's not obvious, it's not self-interpreting. But there is one dogma, one axiom which should be seen as an essential point, and that is the independence of judiciary. This independence of judiciary has been fundamentally harmed in Poland over those 8 years of the rule of the law and justice, and any action, it's not so much as you say that le but justifie les mesures. No, the end doesn't justify all means, but any means which may restore judicial independence and thus remove judges who are not independent because they showed by this participation in this illegitimate procedure must be seen as conducive to the rule of law. Okay, thank you.
Yeah, so that was rich and interesting. So what I suggest is that the Venice Commission at its 35th birthday might look at the path that it has taken and consider whether to adjust it somehow where it goes into the future, and something that I see as a possible way to give an even greater contribution to European constitutionalism. And if I say even greater, that's sincere. But of course, I see that there might be institutional questions of identity of the institution, question of the path that it has taken so far, not least question of institutional capacity, that you might say perhaps it's not such a good way to adjust the way that is proposed here. And I can see that it won't kill my sleep tonight. But I think what you should consider is the second one, that you need to see the impact of EU law on domestic law. Now, when it comes to the point that came from Bertrand, by Marta, Cesare, Christoph, the critique. First, the critique that Article 2 is too indefinite, too open. That is true, but that has never been produced a fear among constitutional lawyers and judges that a norm is too imprecise, too open. And indeed, we now have concretizations of those prohibitions for very specific situations. We know what Article 2 means when it comes to the Constitutional Tribunal, to the October judge, and so on. We know that. It has been a very broad process in concretizing that. So it is concretized, and Carlo Tori made that point. Moreover, then the point was that the member states won't go for that. Yeah, that has been several. But that is not true, because the European Council has endorsed that jurisprudence by the European Court of Justice. You'll find it in the conclusion. And the European legislator has endorsed it. You find in the conditionality regulation, so perhaps the most important EU legislation of the last 50 years, there they quote and cite the case law of the European Court of Justice that goes that path. So if you want to name it with a very famous constitutional theoretical concept, that was a constitutional moment, because the court makes a step and all the other powers followed. In the Hungarian case, 16 member states, never ever so many member states intervened in a case before the European Court of Justice, endorsed that position. So we have had a constitutional moment. So it's not just the court, it is the entire political system that has made this move. So it has a strong basis. For that reason, it's not that I'm going into philosophy. It's not a philosophical, it's a purely legal doctrinal argument, and the argument is that Polish constitutional law is subject to primacy. That's the argument, and I think that is not a philosophical argument. Now, Marta, your point is on proportionality. So proportionality has a point, and indeed there is a difficult and complex situation of the European Court of Justice that mitigates the impact of primacy due to questions of proportionality and legal security. So there is a body that speaks to that, but I'm pretty sure that in this situation here, where we have a situation that can now be called a frontal attack to European society, that's how the court is now framing these issues, that there is no space anymore for these considerations. But it is in the law. And I close with Carlo Tori. we are heading in a new legal universe. We are heading into uncharted territory. And I would be happy to have the Venice Commission on our side in that path. Thank you.
Quelques remarques générales très rapidement. La première, c'est qu'il faut bien voir, et on le voit assez rarement parce que nous sommes tous soit des juristes, soit des juges, c'est qu'on est dans un monde où il y a un conflit de légitimité entre le politique et le juge. Et je crois que la Commission de Venise, en tout cas, a intérêt à ne pas aller sur le terrain politique ou à y aller le moins possible. En fait, il est vrai qu'on utilise des outils fluides. Et je suis un peu en décalage avec ce que disait Césarée. L'article 2, ce sont des concepts fluides. Et notre rôle, c'est d'essayer de proposer une interprétation. Et lorsque l'on dit que finalement les juges s'adaptent très bien au fait que les concepts soient fluides, oui, ils s'adaptent bien au fait que les concepts soient fluides, parce que plus les concepts sont fluides, plus ça leur donne de pouvoir aux juges. Donc les juges aiment bien les concepts fluides. On est en fait une institution consultative. On n'est pas une institution normative. Et en fait, je crois que notre rôle, c'est probablement à la Commission d'être un rôle de vigie. On est une vigie, on donne une direction, on fait des propositions, on analyse des situations, mais nous ne sommes pas une institution normative. Et je crois, pour renvoyer un débat qu'on a eu ce matin, il ne faut pas que la Commission de Venise fixe des règles trop précises. Ce n'est pas son rôle. Elle n'est ni juge ni législateur. Elle est un organe consultatif. Et enfin, je terminerai en répondant un peu dans ce débat qu'on a avec Wojciech. Il a la tension. Il a dit très justement, il y a un élément absolument fondamental qui surplombe les autres, c'est l'indépendance du juge. Je le suivrai assez facilement parce que l'indépendance du juge est la garantie d'un procès équitable. Mais d'un autre côté, le droit au recours est aussi la garantie du droit à un procès équitable. Et donc on se trouve dans la situation polonaise que l'on a eu à analyser vis-à-vis de deux principes, l'indépendance du juge et le droit au recours, qui l'un et l'autre participent à cet élément qui est le plus fondamental, celui qui est en surplomb, qui est le droit à un procès équitable. Et j'ajouterai en disant, et j'irai dans le même sens de ce que disait Martha, c'est que ma défense de l'avis ou des avis rendus sur ces sujets par la Commission de Venise n'est pas un avis qui tient au fait que je sois membre de cette noble institution, mais par le fait que c'est aussi une conviction personnelle. Je vous remercie.
So thank you all for being with us, for discussing with us. I think there was a lot about the role of the Venice Commission, a lot to think about. We are 35 years old, but we have hopefully a future for us, and so we are happy to discuss with you. Thank you all, and there will be coffee break, and I have no authority, but I guess we can have 20 minutes, yeah?
We restart at 4:30.
We restart at 4:30.
And the picture will be taken in the beautiful room.
And the picture will be taken in the beautiful room. Thank you all.
Where we have coffee.
Thank you very much. You moderated with great dignity.
Ladies and gentlemen, I think that we can start the next session. I think we can start already. And we have a very important moment. Huh? No, we have the keynote speech. Oh, you.
Yes, I will also need those notes, but yes, good. That's mine.
Ah, that's yours. Okay, sorry.
Can you just leave it?
No. I just
Okay, I'm all set up, so that's fine. Yeah.
Do you know how to operate?
Yeah.
Oh, they will do it.
Yeah,
Okay.
I'm all set.
Thank you. We are ready to resume. Welcome back. We now, yes? Sorry, we okay? We settled? Yes. Thanks for coming back on time. We are now going to listen to the keynote speech of today, Professor Kim Scheppele from Princeton. You all know her. She's a member of IACL, of course, and she's well known for her work on Hungary-Poland. She's also well known for many articles, including one on the Venice Commission. So we look forward to listening to her.
Thank you so much. So one of the perils of going last is that many things have already been said. I'm not of the view that everyone has to say every single thing that's been said. So I'm going to show you some slides that I'm just going to skip because some things have already been said. And also in talking to many of you, especially over the dinner last night, a lot of you are curious about what's happening in the US. So I was going to talk more about Poland and Hungary, but I may actually talk a bit about the US, in part because I think there will be a role for the Venice Commission, or at least I hope so. So let me start by just, oops, you know what, I have two different things. Oh, I have to do it back there, right there. Oops, nope, go back. All right, I have my computer and this, and they're not connected. So if I seem to be referring to a slide you're not seeing, like wave and let me know. So first let me say that I can't believe the Venice Commission is 35 years old because I remember when it started. In the 1990s, I spent most of that decade actually working at the Hungarian Constitutional Court under the late, great President Solyom as a researcher. And my job at that point was to check the English translations of the case summaries that were going to the Venice Commission. And the Venice Commission was just incredibly important in the new democratic lives of the East Central European states. Then, of course, what happened a bit later was that some of these East Central European states that had been so promising in the 1990s began backsliding. And so what I'm going to talk to you about today is what I think of as kind of three stages of the Venice Commission. And what we've been arguing about today is whether we're moving to stage 3. So let me just say that stage 1, the Venice Commission was a coach, right? So what was so striking about the post-communist countries in the 1990s was how few communists there were. Everyone said they weren't, or they didn't believe it, or whatever. They just disappeared, went to ground. And so what you had were democratic governments that by and large agreed on the direction that all of these states should move. They wanted to comply with European law. They were grateful for the advice of the Venice Commission. And the Venice Commission was like a coach, right? So countries would come to the Venice Commission and seek its counsel. It wanted to know best practices, these countries. And then, of course, the Venice Commission eventually expanded. So now we've been talking about Europe all day, but I know I have friends here also from Latin America whose countries have also signed on. My own country, the United States, is also a member. And so the Venice Commission has expanded. And so it's done that because there was demand from countries that wanted the Venice Commission as coach. Okay. But then when democratic backsliding started in earnest after the turn of the millennium, particularly starting, let's say, in 2010 in Hungary, the Venice Commission took on a new role. and it started getting many more references from the institutional partners that have the capacity to send requests for opinions to this body. So requests from the Parliamentary Assembly, requests from Council of Europe bodies, requests from the EU were coming in to say, we think something funny is going on in these countries. Can you please help us assess whether our suspicions are correct? And so the Venice Commission really moved into a very different role in that period when it became a kind of assessor of compliance with democratic values. And here too, since most of those opinions were about countries that were both EU member states and members of the Council of Europe, it was a little bit unclear, and this is where I think I'm going to side with Armin in his last talk, that it was a little unclear exactly which European values were being applied. There was kind of a sense that there was a web of them that included also the new EU law values, which were being made more concrete over the course of the last decade. But this was a change in what the Venice Commission did, and the Venice Commission stepped into this role. And those assessments were not exactly, how to put it, they had more force, because I'm sure all of you on the Venice Commission understood that those were going to be used in various kinds of sanctioning processes to come. So even though they're not legally binding, they certainly had a fair amount of force. What I want to argue today is that I think that the Venice Commission is now entering, or is being invited to enter, a third stage where its role again changes. And I think it's going from being a coach in round one to being an assessor in round two to being a guarantor in round three. And what do I mean by that? So we're now seeing a different kind of transition. So not the kind of transitions that we saw in the 1990s. Again, Armin talked about this, so I won't really go on about this, but the transitions that are happening now are quite different. And what you have are democratic governments being elected, replacing other democratic governments that turned autocratic. Because that's how autocracy works these days, right? It's not tanks in the streets, it's not violent coups by and large. It's that you get democratically elected governments that try to change their democratic systems by law in a way that locks down power so that it doesn't rotate, and so that all the key elements of power are in the hands of the governing parties. And so then assuming you can get a breakthrough, it's happened in Poland, it has not happened in Hungary, and you should all watch for the next Hungarian election, because the Orban government is already changing all the rules so that their primary contender, who now is more popular than Orban, can't win. So I have a long article on this in the Journal of Democracy about all the ways that Hungary has rigged the election rules. But basically what's happened is that you get countries that have been backsliding countries now coming to the Venice Commission with a different request. And the request is, look, we want to restore the rule of law, but we need a guarantor who can say that we're not just doing what the last government did, right? This is not just a tit for tat. You get elected, you throw out all their people, you put in your people, and then they're going to do the same thing the next time around. They're asking the Venice Commission to be a guarantor of the process so that the pro-democratic, the government that now claims to be pro-democratic, doesn't also engage in a parallel power grab. Right? And that's what the Venice Commission is being asked to certify. Not that you can't ever do this ever, but that it's different if you're doing it in the direction of moving away from European values than if you're doing all these things in the direction of moving toward European values. So this is where we can, oops, I just lost my little clicker there. So this is where we can talk about the difference between what the Venice Commission did when it was being a coach and what the Venice Commission is now being asked to do as a guarantor, right? So in Transition 1.0, and Armin's one of the editors of this Transition 2.0 book, in which a lot of us contributed to articles to how to think about if Poland could get a new government, what they might do. You know, after '89, the post-communist governments were very often becoming democracies, really full democracies for the first time. But all sides wanted to move away from dictatorship. There wasn't any meaningful opposition to that. And these new governments simply lacked experience. They wanted to join European institutions as quickly as possible. The Council of Europe brought them in right away. The EU took longer. But it was a process in which everybody was more or less on the same side. Now in Transition 2.0, this is not the case. Because constitutional democracy, which actually existed in these places, in Poland, in Hungary, I would argue even in Russia, where I also worked at the Constitutional Court, less perfect, less developed, but still there was something, that these constitutional democracies were hijacked by elected leaders that changed the law and therefore claimed electoral legitimacy for the laws that they changed. Okay? And that these aspirational autocrats actually did have, still have popular support. So if there can be an election that removes them, it's not like in 1989-90 where the communists just disappeared. It's that they're still there fighting back and still there, you know, with a fair amount of popular support. So the question is, what do you do under those circumstances? That's where I think the Venice Commission has gotten itself a bit stuck. And so these new democratic governments, the new what they call pro-democratic governments that come in, want to get rid of the autocratic hangovers without becoming autocrats themselves, right? And that's this guarantor role, which is just very different from what happened when the Venice Commission was being asked simply to be a coach. So as some of you know, I've been hearing myself quoted all day. It's very gratifying that somebody reads my work. I'm really delighted, thank you. The term I've used to call this is sort of autocratic legalism, when these aspirational autocrats come in. And you can tell because what they try to do is to lock down or to sort of eliminate all the checks on central executive power and lock themselves in for the foreseeable future. All of it is legal. That's the whole point. It's all legal. It's all even democratically legal in the sense that a democratically elected government passes these laws. Now, of course, in Poland, they didn't have a constitutional majority. Many things were violations of the Polish constitution from day one. It's just that the court was packed so quickly. There was no one around to say so. In Hungary, of course, they changed the whole constitutional framework because they had a constitutional majority. So all of this was done in a way that mimics the way democratic governments are supposed to act. Okay. So the Venice Commission opinions are now being sought as these new governments attempt to uncapture key institutions. And it won't do to try to separate the let's say, the pro-autocratic forces from the pro-democratic forces by asking which one has a democratic pedigree, right? They both do. And that's exactly the problem in these societies. So that's why I think the Venice Commission is not being asked to take sides between political parties. It's being asked to take sides on which side is actually supporting European values. It's asking, these countries are asking for a legal judgment. They're not asking for a political judgment. And it's not neutral, right? If one country has moved their judiciary, let's say to pick up the discussion from the last panel, if one country has moved their judiciary away from all the standards of judicial independence that European countries are supposed to follow, then it's not a neutral thing to say, well, they were elected and the next group is elected and they just want to change it back. These are not equivalent. If the legal job is to figure out which one is compliant with European values, okay? So this is where, you know, and I know many of you have seen my blog post, Blinded by Legality, for Fassen's blog last December. I will not repeat it except to say that I think that following the law, just asking whether things are formally legal, cannot be the right answer here. And this is why the Venice Commission is being called upon to say which side are European values on. And yes, it means taking sides in a contentious situation. That's why it's so difficult. And you know, all of us who are sitting in the middle of these contentious situations know that it's just a very difficult place to be standing. But this is where it seems to me what the Venice Commission needs is a kind of rule of law baseline. And to say the rule of law baseline is where European values say that here's a space within which European political societies have room to choose which form of government they shall have, but it's not an infinite choice, okay? So the law that attempts to break autocratic capture is not the same as the law that accomplishes democratic capture. Okay, now here was, whoops, there. There. So here was where I was going to talk about Poland. So I'm not going to talk about Poland. There will be a slide about Poland, but I'm going to switch because last night people said, why don't you talk about the US? Everybody wants to know. And so here's where I'm going to say what's happening in the US is faster, farther, more radical even than what happened in Poland. So all that's changed, Trump has only been in power for less than 2 months. And the only thing that's actually changed is that he issues executive orders. Okay, now in the US legal system, like in the legal systems that almost everyone in this room comes from. An executive order of a president or a prime minister cannot override a regulation, cannot override a statute, and cannot override the Constitution. And yet, all of the people that Trump has put in across the government have been acting as if these executive orders are the only law there is. Okay, now there are, as of I counted this morning, there were 110 lawsuits that have been brought against various aspects of what's going on in the United States, mostly on these grounds. The president can't destroy an agency like the U.S. Agency for International Development, which was set up by statute. He can't just dismantle it. There's a set of Supreme Court precedents about what we call impoundment, which is if Congress appropriates funds, the president can't just decide not to spend them. We worked that out during Nixon's years. There's also a set of rules about how an executive order obviously cannot override a statute. For example, when the National Institutes of Health, which is the largest biomedical research funder in the world, suddenly decided to go through each individual contract and decide which ones to cancel, there is contract law that binds the U.S. There is also the mission of the NIH, which is written into statute. And so there are many, many cases. The Justice Department, which has fired most of all the lawyers who worked on all the Trump cases, including all the FBI agents who worked on all the Trump cases. Anyone that Trump had a grudge against has been fired, removed, and had their security clearances denied. The Justice Department is a shell of its former self. By the way, the entire national security law wing of the Justice Department has been fired, so there is no national security law wing of the Justice Department. It's just been decimated in 6 weeks, okay? So all of that is patently, it's authorized by the executive orders, but otherwise it would be patently illegal. Okay, so there's 110 lawsuits. In these 110 lawsuits, in almost every single case, the first judges who hear the case are first being asked for what we call a temporary restraining order, which is stop. Like, don't do this, roll it back. We want to wait and see. It's not a decision on the merits, it's just a decision of what's the posture while we're figuring this out. So temporary restraining orders all over the place. A temporary restraining order can be turned into an injunction if there is evidence showing that the complaining party might win on the merits. Okay, so we started with a bunch of TROs, as we call them. It's moved to preliminary injunctions. Almost all the lower court judges, regardless of which president appointed them, have been able to see that most of this is actually illegal. Okay, but we have this problem, like Poland, like Hungary, which is a packed Supreme Court. Now, the Supreme Court has been packed over a long period of time. There were 2 judges that Donald Trump appointed during his first time in office who were appointed irregularly. In one case, the Senate refused to hear the credentials of the nominee that President Obama had appointed, and the argument was, it's a year before an election, and you can't appoint a judge a year before an election. Totally made-up rule. Okay. Then, when Ruth Bader Ginsburg died 3 weeks before the next election, they said, oh, well, that only applied to them. We're going to race through an appointment now. So 2 of the 9 judges have been appointed in an irregular fashion. This may sound familiar from Poland. We also now have 2 judges on our Supreme Court who have engaged in massive and very visible conflicts of interest, who have had trips and various favors paid for by people who appear before the court, who don't declare this on their asset declarations, and who make partisan statements. The wives of 2 of our Supreme Court justices supported the January 6th, protesters, insurrectionists. One by literally texting the White House Chief of Staff saying, hold the line, don't get rid of the insurrectionists, they're almost taking over the Capitol, and the other one by flying flags. And anyway, so we have justices who are, shall we say, their neutrality is in question, and their integrity is also in question. And that court now has, as you probably all saw this past summer, ruled in a case that raised the question about whether he was then former President Trump could be indicted on charges related to the January 6th insurrection. And the Supreme Court at that side decided that the president has either absolute or presumptive immunity for everything he does in his official sphere of action. Framed a different way, what the Supreme Court said was that Congress may not bind the president by criminal law. That's really what that decision was about. And that adds to other precedent that has come since these Trump-appointed judges have been on the court, where they now have a very solid majority. There's another set of decisions that has been chipping away. Those of you who have studied American constitutional law may know the case of Humphrey's executor from the 1930s, when administrative agencies were just getting going in the United States, and there was a question about whether Congress could limit the president's ability to remove people who were put in charge of administrative agencies, whether the president needed to show a reason for doing that. The court has been steadily chipping away at that, and we expect that Humphrey's executor, now our new Justice Department, has asked the Supreme Court to overturn that precedent. We believe that they will, which means that the entire executive branch is going to have people in it who can be fired at will by the President of the United States, and that includes agencies that we've thought of before as independent. That's all before you get to the executive orders and what happens when they get up to the Supreme Court. And that's where I want to say that what most of us are expecting is that the court will adopt, we know for sure there are 4 votes, and there may be as many as 6 votes, for something called the unitary executive theory. And the unitary executive theory says, read the US Constitution. Article 2 is the part that outlines what the president can do. Article 2 says the president, it only mentions the president in defining the executive branch. So there have been conservative scholars hard at work for 25 years now, writing law review articles that say what that means is that the entire executive power has to rest in the President of the United States. He has to be able to control everything else by direct order in the executive branch. That includes the Department of Justice, that includes the Federal Reserve, that includes environmental regulation, and something where experts had been in charge. Okay, so it's almost certain that the court will adopt that theory. So, and then other things. I mean, there's so much going on that I can't describe it all. But I tell you this just to say that we're in the process, a very advanced process of autocratic capture. And I should say, since I worked in Hungary in the 1990s, and I think, well, anyway, I have a weird expertise in Hungarian constitutional law, which is why the Venice Commission has been peppered with amicus briefs for me over the years as all these cases have come before you. This is a copy of what Orban did in 2010. Particularly using the federal budget to defund any source of opposition, using bullying threats to go after the people who might oppose them. I started getting death threats in 2011 as I stood up against the Hungarian government. This is now happening throughout the US, that militias and others are launching death threats, and that Orban suspended the civil service law, fired huge swaths of civil service. This is also happening in the US. I should say that Orban has this English language think tank called the Danube Institute, and they had a formal memorandum of agreement with the Heritage Foundation, which designed the program that Trump is using. So this is not just a conspiracy theory in the sky, it's literally a copy, and I've been through this before, so that's why I'm talking to you about it. You've been through it before too, on the Venice Commission and, you know, and all the people watching backsliding states. Okay, so why talk about all of this stuff? Well, the reason for talking about all of this stuff is that the fact that governments in Europe have gotten away with it also mean the US thinks it can get away with it, and it's literally copying some of the stuff that's happened here. And so one question is, you know, what are some of the lessons that can be drawn for this? Well, one of the things I would love to recruit you for is weighing in on some of this stuff. Now, how could the Venice Commission do this? Well, the US is a member, but the OAS might be able to refer some of these issues to the Venice Commission. I am hoping the EU and perhaps even the Parliamentary Assembly of the Council of Europe will review it. Let me just tell you, some of you are like, how would that be? Let me just give you one example. Some of you have also seen that there's this guy called Elon Musk who has no official position in the US government, so far as we can tell, who with his kids have been ransacking through every single private database the US government has, taking all of our most personal data onto private servers from all over the government. This has to be a violation of the EU-US Data Protection Agreement. Wouldn't it be helpful if the EU asked you to assess data protection in the US? You've done that before. On the Council of Europe, now I know this is on the OAS, for example, I know this is a controversial subject in Europe, but on the OAS, what's happening as this immigration crackdown has been going on, and by the way, you probably saw over the weekend that the immigration police went into a dormitory at Columbia University arrested a guy who had a permanent residence green card, told him orally, your green card is now canceled, spirited him away. His lawyer had no idea where he went. He's turned up, I think, in Louisiana, in a prison that has the highest death rate from inmate violence in the country. And now we're trying to say, is there a right to a hearing before all of this? And the government's answer is no, we're about to deport him for national security reasons that have not been elaborated. Okay, that's just one case, but one case is enough. The US is going to engage in this massive crackdown. They've reopened Guantanamo Bay. A lot of citizens of OAS states, who are the particular targets of this immigration crackdown, are going to be arrested, even if they have lawful visas, and stuck in Guantanamo again. You'd think the OAS might be interested in an assessment of the US's immigration policy on these matters. Those are just a couple of examples, but one reason why I wanted to talk to you is that I want to get your help, right? Because I can imagine the Trump administration would not immediately say, oh, the Venice Commission think we did a wrong thing, maybe we should change our minds. They're not going to do that. But one of the ways that I think the US might be usefully pressured is by having its former allies, we don't know if they're current allies, put some pressure on the US from outside. And I think Venice Commission opinions would be really crucial and important in doing that. So I'm not talking about Poland, as you can see. I'm going to go, I do have slides here on Poland. You've already heard a lot of this. And my blinded by legality opinion, you can read it. So this is where I want to come back to something that I know Armin had talked about. The question now, when you have these backsliding states, so I think now this is like the assessment period that I talked about, phase 2, that the Venice Commission is used to. So the question is, what's the Venice Commission going to do with these kinds of cases? You know, cases out of Hungary, cases out of Poland, but also I hope you will get some cases out of the US. If you need any help, let me know. Happy to find lawyers who can write briefs and fill you in on what the US law looks like. But, you know, what is the right standard here? And this is where I do think that the Venice Commission, applying European principles, has nonetheless been, I think, rather too concerned about rule of law just within a country and thinking simply about certainty, predictability, the kind of rule of law values that make law not abusive if you're simply in one system. But of course, the reason why the Venice Commission exists, right, was to try to bring post-communist states into a European legal culture by saying, here's the way that European principles apply to you, post-communist states. And now the fact that so many states from Latin America have wanted to join is to say, well, maybe, in fact, I should find out whether the Venice Commission is applying the OAS standards or whether you're applying the European standards. They turn out to be, of course, very similar, because we're really talking about constitutional principles that most constitutional democracies have adopted. And so, I'm trying to make my slides here match the slides there. And so I think the right approach here is not to take the rule of law writ small, right? Where you look at a sign like that and you say, that's a rule of law problem. Just make it consistent, fix it, and so on. Instead, what I think you need is, and Armin foreshadowed this, is what I've been calling the rule of law writ large, which is to say, how do the national laws that you're asked to assess fit into a broader structure of European values? Because these are values that, at least in the context of Council of Europe and EU states, also in the context of OAS states, these are countries that have signed on to transnational legal obligations that are also part of their law. And so one thing you can do is to say, maybe in order to fix things at national level, you may have to break the law nationally. You may have to do something in the national legal system that would be a violation if all you were looking at was the national level, in order to bring it into compliance with the transnational level. And so here's where I just want to say that there are sort of hard questions that I think need to be asked here when thinking about, you know, how the Venice Commission can contribute to rolling back. And by the way, it's roll the clock back. Sorry, even native speakers make typos. Roll the clock back to a prior rule of law state. And so this is where it seems to me that you know, the Polish opinions, which I've been critical of, spend way too much time, I think, thinking about reliance on statutes that the Venice Commission said should never have been enacted in the first place. That was, to me, the easy case. The Venice Commission already said, if the Polish government goes ahead and enacts the law on the National Council of the Judiciary, the law on the ordinary judiciary, the constitutional court reforms, all of those were already attacked by the Venice Commission. I think the Venice Commission opinion should be read as putting everyone on notice that they should not rely on the legal effects of those statutes if they're enacted by autocratic governments. Just the way I think no one should rely on these executive orders that Trump is issuing, because they are unlawful. If you just take the general structure of US law that an executive order can't override a statute or the Constitution. No reason to rely on something when you're on notice that it's unlawful, right? So that's where I think the reliance interest should not be the dominant interest. I think reliance interest should be balanced against these rule of law requirements to comply with the values that the Venice Commission is called upon to enforce. And so I think that means that the Venice Commission, when it comes in and assesses these countries that are now, assuming we ever get a new government in the US, which is also a question. By the way, there's a whole now law review articles and the whole apparatus we see saying that Trump can run for a third term. The reason why is you read the 22nd Amendment, it says the president may not serve more than 2 terms. You do your originalism thing. When was that statute passed? After Roosevelt. What was the problem? He served 4 consecutive terms. They didn't pass that after Grover Cleveland, who served 2 discontinuous terms. So therefore, it implies that you're only banned from having more than 2 continuous terms. That argument's already being made, so watch this space. Okay, so the question is, when you see these kinds of legalistic arguments being made, how do you get out of them, right? You can't just say democratically elected government makes an argument that passes legal muster in some world. You have to say, does it pass legal muster or constitutional muster in a world of values that these countries have signed on to? And so that's where I simply, want to say that the Venice Commission, I think, needs to enter this new space where it becomes a guarantor of what I'm calling retransitions. So when the Polish government comes to you to ask for opinions, when the Ukrainian government came, I talked about the Ukrainian judgment earlier today, they're asking for you to guarantee to their fellow politicians that you're not just engaged in doing back to them what they did to you, that you're engaged in bringing the country back to standards that everyone has an interest in living under. And so that's what they're asking you to do. And so that's where I think the Venice Commission now has this extremely important role in trying to not pick sides in a political fight. You're picking sides in a rule of law fight. It's meant to be legal when you get to it. And so that's where I hope that you'll keep working with transitioning governments. You'll be in the assessment phase in the US, but I think you're in the transitioning phase in Poland. I hope we get to a transitioning phase in Hungary. I hope we get to a transitioning phase in the US, at which point a new democratically elected government may ask you, how do we honor the rule of law without looking like we're doing to them what they did to us, okay? And so that's where I think this discussion can be continued. So thanks. And I don't know if we're complete. I tried to shorten, but I don't know if we have time for questions. Do we have time for questions or not? Or do we go straight to conclusions? I'm around. I can talk to you. Are there any questions? I can also answer questions on the dire state of affairs in the U.S. You can open the window. That would be useful. Yeah. Yeah. Are there no questions? Everyone's exhausted. I know it's a long day. So, no? You all agree with me? That would be a lovely result. I would like that, but I always like debate too. No questions? Armin.
So that was wonderful. Thank you very much.
We agree. After all these years.
No, I found a point where we do not agree.
Okay.
I don't agree. And the point is that took me some effort, but then it's the point of you need to break the domestic law. And here, the terminology is important. It is not breaking the law, because if you have primacy, you're not breaking the law.
Yes,
You're applying the law that you need to apply. So it's not breaking the law.
Right.
It is applying the law that you need to apply.
Exactly. Actually, so here's the question. I agree with that in the EU context. What do we do with the non-EU states? So there, again, if you don't have primacy, and I think that's what you were hearing in the reactions to your comments, if we're applying Council of Europe standards, then the question is, you don't have primacy, you don't have the nullification of the inconsistent law so that it doesn't exist, so you're not breaking it. Then the question is, maybe the Council of Europe needs a test of nullification. Maybe it needs to move in the direction of something like primacy in order to get there. And I think this is where I think a lot of people have been reluctant. We don't have that in the OAS system, right? So I think that we need one more step to bring in the non-EU countries on this stuff. And that's why I say break, but I think, the question is whether that's valid law to begin with, I guess is your point, right? And we can do that from other values, perhaps. Yeah, and I think.
Oui, merci beaucoup pour votre intervention. Simplement un mot. Moi, j'ai quand même une crainte, c'est que la Commission de Venise soit entraînée dans des débats qui sont des débats de nature essentiellement politique. Et il y a un thème qui m'a un peu symboliquement heurté, tout au moins si la traduction est juste, parce que je vous ai écouté en français, étant donné que je suis un handicapé des langues, c'est le terme « recruter ». Et je ne crois pas que l'on puisse recruter la Commission de Venise, ce qui voudrait dire qu'on l'engage dans un camp ou dans un combat. Merci.
Okay, so, I think that where we disagree is that I think you're still seeing things in a very political frame, that you still think I'm moving toward a political solution to this when I'm trying to argue what the Venice Commission needs to do is to stay in this legal frame. So of course law and politics are completely mixed up in any national context. What the Venice Commission can usefully do is try to draw a line between those two things, right? And so that's what I'm suggesting is not that the Venice Commission take political sides, but that the Venice Commission stay on the side of rule of law defined the same way for all of its, at least all of its EU countries, maybe a slightly different definition for the Council of Europe countries, but that the revolution that you spoke of in your presentation is not what I'm advocating here. I think it's really a matter of trying to make a legal system consistent all the way through with the values the country has signed on to purely legally, plenty of space for politics beyond that. I hope I was responsive. My French is like 80% of getting what you say, and I was trying not to use headphones because I need practice, so yeah.
Yes, thank you. I think there's some language that can be used for your argument from the Inter-American Democratic Charter, because Article 2 of the European Union statute is contained in the Inter-American Democratic Charter. Though I'm not sure how the current administration will follow any resolution, any recommendation. So my question is, how isolated do you think the current administration may become from the Venice Commission? They can pull out. They already pull out from the World Health Organization, the Human Rights Council. Who knows what else? So you have to think on alternatives that go within what we call the collective protection of democracy, but also by other means. Thank you.
So I think this government will pay attention to nothing but itself. I mean, it's not paying attention to the opposition. It's not paying attention. I mean, so it's an imperial government. And wait for Panama. Wait for Greenland. I mean, so I'm not thinking that these international organizations, and of course the U.S. is not even. It's only half in the OAS, right? It's always refused to be bound by anything that would be really binding, right? So the point of actually mobilizing other institutions that do value the rule of law and that do have the Democratic Charter is really interesting, and of course the Inter-American Court has now taken up interpretation of the Democratic Charter and in the way that it understands its rights jurisprudence, right? So, I mean, the Democratic Charter is becoming bigger in the transnational law in Latin America. So I think all of that is terrific. What that means is that it will help countries in Latin America diagnose what's wrong with the U.S. Not because it can fix the U.S., because it's only those of us, I think, inside are going to be able to fix it, but external pressure is going to be very helpful. I don't think Trump and his allies in the government realize how much the U.S. needs allies. right? And so this, if there's an action that sharpens what our what our southern neighbors think of us, it's something that will help them unify around a common response to the U.S., which I think would be very helpful. So it's, again, I don't think any of this, I mean, the U.S. doesn't believe in international law. I mean, you all know that you can get all the way through U.S. law school without ever encountering international law. There's only 2 law schools in the country that require a course in anything like international law, Harvard and Michigan. And I've taught at both. I've taught those courses in both places. And everywhere else, American lawyers get 0 training. So as a result, the people who were working in the Justice Department giving legal advice to the president know 0 international law. Now, there's a big legal advisor's office at the State Department. It had no permanent legal advisor during the entire Biden administration. So again, when you're talking about trying to bring international principles to bear on the U.S. treats it like it's Martian law, like doesn't come from around here and doesn't apply to us. The crucial thing is that it unifies the rest of the world in their response to the U.S. And that kind of unified pressure, I think, would be very helpful in a realpolitik kind of way.
Okay, thank you very much, first of all, Kim, for your presentation. And in your presentation, you suggested the Venice Commission to step up and be kind of a soft power to give a pressure to the US government. And I mean, in the continent, not only the members of the Council of Europe, who are also part of the EU, but out of the EU, the opinions or the principles, values, standards developed Venice Commission has a very important part. For instance, the European Court of Human Rights often refer to the opinions of the Venice Commission, and also constitutional courts and other domestic courts use the Venice Commission's opinions in their reasoning, in their judgments. So do you think that we all, or most of us, know that the US courts are not very fond of using other judgments coming from other parts of the world? So do you think that the Venice Commission's opinions, if they come to the other side of the Atlantic, will influence the US courts somehow?
Yeah, so look, I've been teaching comparative law in the US all my life, and I have to instruct, US lawyers don't know much besides US law, and you'll all know that. So will this have a direct effect? One can always hope. There's a really interesting article that will surprise many of you, written by David Fontana, who's a professor at the George Washington Law School, called The Rise and Fall of Comparative Constitutional Law. And what he shows is that in the immediate post-war period, post-World War II period, it was much more common in US law schools for comparative constitutional law to be taught than for US constitutional law to be taught. If you look at the speeches of Supreme Court justices, it was almost always about the reconstruction of Europe, the reconstruction of Japan. Many of them had served in World War II and had spent time abroad and understood the role of the importance of law, legality, and the new constitutions across the world in creating a different world. And that was very common in US law schools. It's not until the 1960s when the so-called Warren Court, which then goes on a role elaborating civil liberties in a sort of extraordinary way, when the clerks of the Warren Court start to become the law professors, that US constitutional law takes the shape it does, and comparative constitutional law disappears from US law schools. It's really interesting. So it's not that long ago, and unfortunately it took a world war for American lawyers to pay attention to the rest of the world, and I don't want another one of those, but it may well be that this particular lurch into autocracy that the US has engaged in, I'm getting more media hits in the US than I've ever gotten. Everybody calls me up and says, somebody tells me this is kind of like what Orban did, right? And Americans all know about Viktor Orban now. I was trying to get their attention 15 years ago when it would have mattered in Hungary and nobody was paying attention. So what you're seeing is that as the U.S. starts to realize it's following a path that other countries have gone through, it's gotten people more interested. Will it change the lawyers? Not so sure. But I know we have some more questions. But I don't think the Venice Commission shouldn't think about changing the U.S. It should think about strengthening the spine of the countries that do sign on to the Venice Commission to understand what's wrong with the U.S., to generate external pressure. I think that's the role here.
Kim, returning to the discussion that we've had for quite a long time, and it's about the rule of law writ large. Yeah. What do you say to the arguments that there will be inevitably some aspects of statutory lawlessness in member states which are invisible to European law, to EU law and the European Convention, European law and also international law of human rights, etc. So that European law is quite broad and the principle of primacy allows us to inject it into domestic law. But what about if we run out of European law and still we feel it is wrong? Maybe nothing specifically come to my mind, but say the issues of, I don't know, states of emergency or some details of electoral law which are really outside the competence of Europe.
Yeah, so transnational law is not a complete system, and international law has developed in silos. So actually, just I was reminded of something I wanted to say to Selim, which is that Turkey's in the customs union. The U.S. is going to put, tariffs. All right, we happen to have a president who loves tariffs, doesn't understand them, but he loves them. Turkey's going to get implicated in this, and the fact that the U.S. was so complicit in disabling the WTO, appellate body, also means that there isn't a cop on the beat enforcing international trade law right now. So it could be that the EU customs union, including Turkey, is going to need to be the one that stands up to the U.S. because the WTO isn't able to do it right now, right? So that's a way in which countries that are not even in the EU, but in the very larger, configuration of EU orders, can participate. So what happens when the rest of this law runs out? Well, that's the reason why you get more transnational law. Right? You don't need the law of war till you have wars. You don't need the law of whatever. I mean, as you know, actually there was a big effort in the 1970s, as I recall, to develop a kind of transnational law for states of emergency. Which rights can you derogate from, which you can't? The Syracuse principles, there were several different efforts, and then it kind of fizzled out, but maybe that's what we need. So it's a spur to the creation of international law when you get the black holes in national law that you can't quite reach through international law. So I think we're going to be in a growth phase of international law, given the tremendous interdependence of countries. And then you get this rogue giant in the middle of it trying to rip the whole system apart. It's going to make everyone see where the holes are to fill.
Thank you very much, Kim. Enjoy your presentation. But let me perhaps challenge your idea of a third step, becoming the Venice Commission a kind of guarantor. As far as I understand, I think that it's important to bring together political concerns together with legal and more technical concerns. And my understanding is that the current authoritarian stream is shrinking the political domain. I mean, as you said, for instance, about parliament, and are trying, to make a clear-cut distinction, a kind of watershed with its technocratic agenda against discussing about values, about principles. And I think this board is likewise like parliament, I think are an interesting scenario to pull together both dimensions.
Yeah, no, I agree. And this is where, we can go back to the beginning of today in Cato Reagan's speech about the rights of the political opposition in a dominant one-party dominant state, right? So we can take the South African decisions and say, when you've had this closure of politics, and there really is only one big party occupying the whole space, which you've had in Hungary for 15 years. In Poland, the opposition stayed alive and active. But, in South Africa and India, I thought for a while Russia might go that way, where you had sort of one big party that dominates electoral politics for the first couple of decades, and then you get a splintering out of parties. That's one form of democratic development. In those systems, it may become incredibly important for constitutional principles to include rights of minority parties. And so, again, you know, this is where constitutionalism fills itself out to create a space for politics. It doesn't just shut down. I mean, in some cases, with rights questions, that's why you exclude politics from certain kinds of rights infringement. It doesn't matter if you have a majority that thinks it would be great if people were hung from their thumbs in the public square. You're not going to do it, right? So this is where another feature of constitutionalism is this keeping the political space open for argument. That's why I'm saying that the point of the Venice Commission here is not to pick sides. It's to create the possibility of a continued democracy with protection for rights and protection against autocratic capture of the democratic institutions. And so, but politics should thrive under such a system. It's not closing it down, right? That's why and so I just think what's happened, so one last thing. I mean, we have a very good idea of human rights, what their contours are, very strong similarities between the way the Inter-American Court and the way the European Court have interpreted these, consistent with the way a lot of constitutions, I mean, we have a kind of transnational field of human rights where there's some minor differences, but by and large, we've got solid agreement. What we haven't had is a system of agreement on democratic institutions and how they work, because they're much more various. You know, parliamentary systems do things one way, presidential systems do things a different way. We have fourth branch institutions. You know, I was just asked by my students, how come in Brazil, you know, Bolsonaro's been indicted and he's going to be put on trial, and we didn't manage to do this in the US. And part of that is because the prosecution is a fourth branch of government. It's not sitting under the executive. Biden worked way too carefully in the early days after insurrection to appear to be even-handed. In Brazil, fourth branch institution, it's protected, right? So maybe we should think about, you know, constitutional structures that are more resilient in systems of autocratic capture. And this is where, and this is new to us, right? Because, I mean, the Venice Commission has been the lead in thinking about, you know, do constitutional arrangements of an institutional sort violate basic principles of European constitutionalism? That's why the Venice Commission has been so crucial. But, you know, this is something where, again, we're elaborating it as we go. As you see more bad examples, well, not like that, not like this. And so, you know, it opens a space for politics, not closing it down. I go on too much, sorry. I get very excited about these subjects. I think there's a question in the back. Yeah, Andreas, I think? Oh, the microphone disappeared, okay. There. Running out of time, yes, and you need to speak. Yeah.
Maybe it's the last question. Thank you very much. Well, thank you very much. I think there is very broad agreement about the substantive principles you have put forward and the dangers we are in. Yeah. But that is also a reason why we really have to take care not to be perceived as taking political sides. We have to try to find this, and to rely on this common basis, which has made this institution not only a European one these days, but a broader one, even in the world at large. And exactly looking for this common ground rather than from involvement on one of the sides, even if what we say may be more for one side than for the other political side in a country concerned, we shall look and remain on this common ground. Right. That would be my suggestion.
Yeah. Yeah, if I can just say one closing thing, that one of the things that we now see as going with autocratic capture is that the autocrats always accuse the other side of being political, but they're not. Or they, you know, or they'll say, you're siding with them. You're obviously funded by Soros. The entire Venice Commission is, you know that, right? I mean, so just because the autocrats accuse you of being political doesn't mean you are. Right, and that's where I think the Venice Commission taking a stand and saying, these are principles we apply to everyone. I must say that this is something where the Venice Commission might think about how to negate that criticism. Usually when I talk about this stuff in the US, I pair Hungary and Venezuela. And I talk about the same problems in both places. And the reason why is that one is a right-wing dictatorship and one is a left-wing dictatorship. And you can show that it's the same problems, and that way you say, look, I'm not just against right-wing governments, you know. Personally, I would not vote for them, okay? But I wasn't a real fan of Chavez either, because he also crashed his constitutional system, brand new constitution, very similar to Orban. So the fact that the Venice Commission now has members from Latin America, where a lot of the anti-constitutional revolutions have come from the left, it may be very good to elaborate some opinions in a different political context so that it becomes possible to say, this is really not about whether I don't like right-wing governments or left-wing governments, but we don't like anti-constitutional governments, and they can come from all sides. You know, so that's what I've done, and the fact that there are so many Latin American members now of the Venice Commission may give the Venice Commission an opportunity to make that point in its own opinions. Anyway,
thank you very much.
Lots of work for you all to do, and happy to help if I can.
Thank you very much for this presentation. Probably we are arriving to the end of this very interesting day for the conclusions, and I give the floor to the Secretary of the Venice Commission, Mrs. Granata Menghini.
Grazie, Sergei. Thank you very much. I think I have 3 minutes left. No. It's I will try to be short. I'm not going to make conclusions in the sense of summarize or respond to arguments. I just wanted to have a few words about the Venice Commission as a standard setter from the viewpoint of the Secretariat of the Venice Commission. I've been on the Commission for 23 years. So first of all, I will say that events like this are precious for the Venice Commission. The academia is an interlocutor for us. The IACL is one of our interlocutors, one of the privileged interlocutors of the Venice Commission. So we do interact with the academia to reflect together, to build on this reflection in our work. The academia is also a stakeholder in some countries. So we also meet the academia in countries as stakeholders. So we also hear their specific point of view. And it is interesting. I think it's in a context like today to learn lessons. I think it's very interesting to have these exchanges into respect on the content, of course, but also on ourselves. And I welcome that, and I thank you for today's discussions. I think it's not easy to understand the Venice Commission. We are a very special, maybe funny creature. I think it's easy to say what we are not. We are not a judge. I think there were some Freudian slips about the Commission producing judgments or being a court. We are not a court. We are not a professor either. We are not a decision maker. We are no legislators. We are not an NGO. We are none of these things, and in a sense, a little bit of all these things. And I think you see this by the composition of the Venice Commission. And you see our speakers today from the Venice Commission have been, while being professors, many of them, they've been judges, they've been constitutional judges. They have been ministers, at least 2 here. They've had many capacities. It's a combination of all this. We do not produce judgments, of course, we produce opinions, but I think it was rightly pointed out that to say that they are simply not binding is to underestimate or to ignore what happens with our opinions, really. So there are strings attached. I think we all agree to this. The methods of the Venice Commission are very particular. First of all, we are inclusive. This was mentioned today. The Venice Commission does not study texts, does not analyze texts simply. We do so, but we also travel to the country. Most of the time we do travel, sometimes it's online, but with a view to meeting all the stakeholders. All the stakeholders means all those who want to discuss with us. We listen to everyone, the majority, the opposition, in parliament, outside parliament. The stakeholders meaning also judges, lawyers, prosecutors, if need be, the professions, if it is necessary, constitutional courts, to the extent that they can discuss with us, civil society as well, very importantly. We do not side with anyone. We do not defend any of these groups, any of our interlocutors, or we may be persuaded by their arguments. And our opinions carry arguments and messages, and I think all those who meet with us recognize when they read our opinion an echo of our discussions. There is a lot we don't say about what we do. There is a lot we don't say in opinions, I think for a good reason, but maybe these exchanges help to explain. We are also a collegiate body. It's not one person, it's not two, it's not the rapporteurs only. It's 61 plus. It's some 100 people, at least in principle, who read a draft opinion and who check it against their own legal background. It is pretty solid. In 23 years, it has never happened to me that a visit in the country has not changed our mind, and it has never happened to me that some difficult, crucial recommendation was not changed, nuanced in Venice. So all this is very unique. But what is our mission? Our mission is to provide impartial, viable recommendations based on the standards. I'm going to say briefly 2 words about each of these. Well, the impartial we have seen, we don't take sides. We are not political. We do not, we travel to the country, but we have a different, higher view from an external view. I don't know about the internal point of view, the external point of view. I think we are a little bit the third way. Standards, what standards do we use? Certainly we use hard law. We use the judgments of the European Court of Human Rights. We should use more the judgments of the European Court of Justice. We also use judgments of the Inter-American Court of Human Rights. By the way, the court has also quoted an opinion of the Commission. It was said before, we complement hard law in a way that, through soft law, makes it possible to implement these judgments. Very often we have heard it about the judgments on Poland, but also for corruption, for example. There is a general obligation to do something. You have to prevent corruption. How do you do that? Who guides the legislator to do that? At the same time, we are not decision makers. It is not for us to say how to do it. We give indications. States may disagree with the manner in which we suggest they could meet the objective, but they can choose something else. But the objective is there. It is not because we said it that it needs to be done. When we do that, we take care not only of the specific problem, but we have to take into account the global problem. So, for example, if all the judges of a constitutional court are fired, maybe rightly so, what happens to who appoints the new ones? What happens? What about the principles of pluralism in a court? How do you actually address this? We were told, well, I heard today you are sticking to mantras, rule of law for the rule of, through the rule of law. It's true, but it's true that we say a lot that, but we've also identified the root of the backsliding in what Kim also mentioned, the idea of the winner takes all. And that is an issue. We have seen, we do not consider governments good governments or bad governments. They are elected governments, they are governments, they are politicians. We have seen other revolutions in the past. We have seen revolutions who have been saluted as being a transition to democracy, but that have not delivered on the promises. So we do not side with, again, we do not support one of the other revolution. We try to provide advice that will last for the next government and the other governments, the other countries that are watching us and who are ready to pick up this or that advice, maybe taken out of context as well, and use it against the meaning. So let's go back to the mission. We provide guidance to states. This is our core work. in the process of providing assistance to states, we also not only apply standards, but identify gaps or problems in the standards and maybe develop the standards. This is all done because what we aim to do is provide viable solutions. And this is the idea, the roles of the Venice Commission. We have been called many, many things. We have been called, even just today, in many ways. We are coaches, we are red flaggers, we are auditors in other cases, we are the moral compass, we are the firefighters, we are, but there's many of these. And we have probably covered all these roles in many cases. We have also triggered reactions by institutions. Let's not forget for Poland, it is reminded, it was recalled today, it was our opinions in the first place that that were used in the judgments. The European Court of Human Rights has referred to our opinions in more than 120 judgments, never disagreeing with us. I mean, they do what they want with the opinion, but they never disagreed with us. So we do stick to rules, but we provide for exceptions. It was mentioned today about Constitutional Court. We do say Constitutional Court judgments have to be respected. We do say that. We have also found exceptions to this in some contexts. For example, when the Constitutional Court itself does not respect its own rules of procedure or its own principles, we have said that in that case, even the Venice Commission, who does not normally second guess Constitutional Court judgments, some cases it has said maybe it is necessary to do that. We have also sometimes been asked by Constitutional Court to help them, to support them actually. That is, again, another concept. And we have also, through this, because of this need, we have developed the standards somehow. Inamovibility, for example. Inamovibility is a big principle, but now we say inamovibility applies to, I'm thinking now, members of a judicial council, but can be judges, who have been appointed with due respect for the Constitution, not only the Constitution, because the Constitution may have been changed in the wrong manner, so the Constitution and the standards. So we are, along the way, we are trying to adjust a little bit. So we need to give viable. What does viable mean? It's an important part of our job. We need to provide, to suggest to the extent possible. Sometimes we say the law should be repealed. We don't find that there is any viable or good way to repair a law. It's against the standards, it's against the standards. But if we want to make it viable, then what do we do? What do we use? We use the experience of other countries, difficulties experienced by other countries, but there is a limit to what we do, and that is that we act upon request. We cannot choose what law, what comparable law is being, to assess. We can only assess the countries, the laws and constitutions which we are asked to assess. So sometimes we are reproached that we have not criticized another system which is as bad as the one you're looking at. We have not been asked, so we cannot do that. But we use comparative material anyway, so we look at other examples. We use the opinion of the academia, the views of the national stakeholders. Of course, we use the international partners as well. We relate with international partners, and there would be a lot to say about our interactions with the European Commission in the processes of accession. But we need to, I'm finished. We need to provide new solutions. When we want to give recommendations, our tendency is to look back at what has been done in the past, and we come up with sort of traditional solutions. And there I agree, they might not be sufficient, so we need to be creative, faithful to ourselves. I think the methods are good. The update of the rule of law checklist, which is going to be, it has been a big endeavor, is going to try to cater for these needs. By the way, we are doing this update through an inclusive process. We have consulted all the stakeholders of the rule of law checklist. We are in the process of putting together the results. But I think there is a lot of discussion to continue, and we'll continue to do it in dialogue. So I thank the co-organizers, Helle Krunke, Celine Essen, Angelika Nussberger, of course, who is the soul of the Venice Commission on this conference, Sergei and Ioana and Luca and Mario and everyone else, and thank you for your attention.